Please be seated. Good morning. We will take up Adkins versus the State of Idaho, case CV01-24-14744. This is the fourth day of the bench trial. In the matter, we have a counsel table for the plaintiffs, Mr. McKay, Ms. Dady, and Ms. Pletcher. For the state, Mr. Craig and Mr. Grigsby. I gather that counsel have some preliminary matters you'd like to discuss before plaintiffs resume their case in chief. If that's true, let me know.
It is. Good morning, Your Honor. Scott McKay for the plaintiffs.
Good morning.
We filed yesterday a motion to admit the testimony of Dr. Wardell. Of course, Dr. Wardell testified pursuant to an offer of proof. We believe that there are issues that are raised in our motion that could be relevant and inform the testimony of our first witness this morning, Dr. Lyons. I don't know if the court has had an opportunity to review that motion. We were prepared to...
I've read the paper. I don't know anything about any interaction the admissibility or inadmissibility of that testimony has with any further evidence to be presented in the case.
And we can take those issues up through when the first witness is on the witness stand, if that's the court's preference, or we could discuss the motion today and possibly the court can provide us further guidance on this issue.
So how does the outcome of the motion bear on what you do in presenting the rest of plaintiff's case?
Yeah, and I think that Ms. Dady would be the lawyer who would discuss these issues, but what I can tell the court is we would ask questions that are similar to the questions that were asked of Dr. Wardell, and I presume they would provoke similar objections than what were received with respect to his testimony, and we would proceed accordingly.
So we're back then to the issue that you want to present further evidence on the notion that the abortion laws are bleeding Idaho of medical providers.
Yes, and I think we have responded to some of the court's, I think, statements that those issues were not raised in our pleadings. I think the motion describes respectfully and in our view how they were and where they were and why these issues are relevant to this trial and then certainly relevant then to the testimony of Dr. Lyons.
All right, so I guess here's the issue as I see it. Now, I agree with you that there are allegations in the complaint concerning the idea that the laws will have or are having the effect of physician flight from Idaho. The claim to which they're relevant, that evidence is, I guess, potentially relevant, would only be Claim 3. Is that fair to say? I mean, it doesn't have anything to do with Claim 1.
So I think, as I said, rather than speak to these issues, may I allow Ms. Dady to do so?
That's fine.
Thank you. Ms.
Dady, so far, you'd agree with me. Is that fair to say? The evidence at issue relevant to Claim 3, not to Claim 1.
Yes, Your Honor. This evidence is primarily relevant to Claim 3. And as we noted in our written motion that we filed over the weekend, we identified the areas in the complaint where we specifically allege in multiple different places, including quoting Dr. Wardell himself in the complaint. But primarily today, what we expect this type of relevance to be, this type of evidence to be brought in is through the expert testimony of Dr. Julie Lyons, who's a plaintiff in this case. She's a member of IAFP, and she is a rural family medicine obstetrics provider. So she will be having testimony today that will be touching upon the impact that workforce issues has had in her area of practice. So that's the area that we anticipate coming up today. And for Dr. Wardell in particular, We think in the complaint, it was laid out quite clear that the departure, however many, of physicians from Idaho after the bans has impacted physicians to the extent that it has trickled down to patient care.
All
And
right.
that goes straight to claim 3.
So, Claim 3 is a claim that women in certain medical circumstances have a constitutional right under the Inalienable Rights Clause to care that would include, in the plaintiff's view, abortion. Is that a fair characterization of what Claim 3 is?
Well, our characterization of Claim 3 is that it prohibits the state from affirmatively blocking access to life and health-preserving care, and that, of course, includes abortion for people with pregnancy complications that are threatening to life, health, future fertility, fetal diagnoses, and that it is our responsibility and burden as plaintiffs to show that that right has been infringed.
Understood. Now, where the hang-up is, is this. If women in those medical circumstances have a right to not be blocked by the state from obtaining this care, as you say, then Claim 3 is going to succeed irrespective of any impact of the laws on the availability of physician care. If, instead, women in those categories don't have the constitutional right to not have the state block access to that care, then Claim 3 is going to fail, irrespective of whether the one effect of the statute is to discourage physicians from wishing to remain in or locate to Idaho to provide care. So I guess tell me where that logic is wrong.
What I would add, Your Honor, is that if these laws are having the effect of driving physicians who provide obstetrics care out of Idaho, that is a form of blocking care, especially as you will hear today, if permitted. Patients who are living in rural areas already have very little access to obstetrics care, and if these laws persist in causing the type of confusion and inability to apply them in situations with people with pregnancy complications, then that is another form of blocking the care that is being caused by these laws.
I guess I'm struggling with how that's the claim, because the claim isn't that women have, under Article 1, Section 1 of the Idaho Constitution, a right not to be blocked as a general matter from receiving this kind of care, women in any circumstance. It's a claim that women in particular circumstances are entitled not to be blocked by the state from receiving the care. And I guess again, if the statute if the statutes block care directly by making it illegal to provide it, what difference does it make if they also block care by bleeding Idaho of physicians who would provide it, except that it's illegal for them to provide it?
I think, Your Honor, this is another form of the chilling of the care, and it certainly would go not just to people who are being completely blocked in receiving health-preserving care, some of the care at the margins. I think what we've shown so far and will be additionally showing is that this is additionally, even right now, with the laws criminalizing care, that this is also contributing to the chilling and inability to provide life-saving care.
All right. I'm going to adhere to the ruling I've made repeatedly throughout the trial on this subject. I don't intend to allow any further evidence on the subject of the idea that the effect of the laws is to bleed Idaho of capable OBGYN type providers, or providers who would provide that sort of care. Ultimately, it just doesn't, from my perspective, have any perceptible impact on whether the claim in Claim 3 fails or succeeds. That is an issue that turns on what the constitutional rights are of women in certain medical circumstances, and not what the market effects of the laws are. All right. Do we have further preliminary matters from the plaintiff's perspective to discuss?
Yes, Your Honor. I'll have Mr. McKay come back up.
All right, thank you. Mr. McKay.
Thank you, Your Honor. Yes, one other issue that actually became an issue at about 5:15 last night when we received from the state an amended witness list. The amended witness list had two names on it, Dr. Rod Story, Dr. Dustin Hughes, names that were unfamiliar to us, names that had not been disclosed in discovery, names in response to interrogatories that would have required the state to tell us who these people are and that they plan to call them as witnesses and that they had information relevant to the claims, to their defense of our claims here. Names that were not disclosed in accordance with the court's scheduling order, either at the attorney's conference or a day before the pretrial conference when they would have been due. So we're in a situation, Your Honor, where we don't know who these people are. We don't know what they're going to say. We're prejudiced if the state is permitted to call these witnesses, and we have to deal with this issue on the fly. I know we're not to the state's case in chief yet, so I wanted to at least front the issue, and glad to provide further argument or hear what the state has to say about this, and respond to whatever they have to say, and we'll address it however the court deems appropriate.
All right. Thank you, Mr. McKay. Mr. Craig?
Your Honor, I think the objection is premature since they haven't even rested yet. We haven't even called our first witness yet. But I think the fact of the matter is that they've they've presented witnesses that have testified to evidence that has come in over our objection, over relevancy objections that Your Honor has admitted. We have a right to rebut that evidence. There's no requirement to disclose rebuttal evidence. I mean, that's kind of the nature of trial. Stuff comes up, things go through, when you're acting on the fly in trial, there are times where, again, evidence comes in over objections that we have a right to rebut. And so these are two witnesses that we will call to directly rebut testimony of Dr. Aker and Dr. Harmon, specifically in addition to Dr. Corrigan, but most specifically Dr. Aker and Dr. Harmon's testimony.
All right. Understood. Well, I'm going to just stop that discussion there, and we'll get on with the plaintiff's case, and we'll deal with that issue on down the road. Are there other matters to discuss before we resume the presentation of evidence?
No, sir.
Okay. Ready to go, Mr. Craig?
Yes, Your Honor, thank you.
All right. Plaintiffs may call their next witness.
Good morning, Your Honor. Catherine Decoction on behalf of the plaintiffs, and actually, we do have a few more evidentiary matters to get to before we call Dr. Lyons to the stand, if Your Honor doesn't mind.
All right.
So first things first, Your Honor, we'd like to offer into evidence the designated deposition testimony of one of the state's two 30B6 witnesses, Yvonne Dunbar. Ms. Dunbar was deposed back in June. We designated her deposition. We provided our designations to the state on October 9th. The state did not counter-designate Ms. Dunbar's testimony, but did say that they were standing by their objections with the exception of a handful. And I'm happy to provide those page and line numbers.
All right. So which is this deposition testimony in one of the plaintiff's exhibits?
Your Honor, we actually have a highlighted copy for you, if that would be preferable.
That's fine.
May I approach?
Hand them to the bailiff, please.
I don't, but it's the same list that we provided you on October 9th.
Okay, and so the highlighting is the portions that you wish to have admitted into the trial record. Is that right?
That's correct, Your Honor.
All right, and these are page and line citations that you provided to the state,
Your Honor.
and that was what, as part of the witness list, or?
That was part of our pretrial exchanges, Your Honor, witness list, exhibit list, and deposition designations.
Okay, and so you're offering that evidence at this point. I gather that the transcript contains certain objections by the state that the state may not be waiving. Mr. Craig, are you? I guess, what can you tell me as far as any objections you have? I don't know that to the extent you've objected on the record of the deposition. If you'd like rulings on those objections, I can make them. What I would do is make them to whatever extent I concluded it was necessary to rule on the matters in rendering findings and conclusions at the end of the trial. In other words, I don't intend to flip through this document in this room and render rulings on the spot. Is that sufficient, satisfactory?
It is, Your Honor, if we could submit a written response, because many of the objections would simply be objection to form, for example, and so we might need a little bit more specific. We object because this is, whatever the calls for speculation or those types of things. I do object to testimony as a whole because nothing that they asked is relevant to their claims, and so I think the entire evidence is irrelevant to the claims. So relevancy for everything, but then if we could do the line by line, submit a written objection so we can flesh out the objection forms, for example.
Well, all right, and I suppose what I'd say to that is that you, of course, both sides will have an opportunity for a post-trial argument piece, proposed findings and conclusions, and I don't have any problem with the idea that in conjunction with that document, whether as part of that document or as some sort of standalone piece, you present any argument you want to present on the admissibility of this evidence. And of course, the plaintiffs, I suppose, if they wish to contend that some objection is being expanded beyond what it was on the record of the deposition, and that's grounds for determining the objection was waived effectively, they can so contend. We'll I guess I'm not sure what to say beyond plaintiffs have submitted these portions of the deposition. It'll be, I guess, provisionally part of the trial record, subject to rulings on objections that have not yet been made.
Your Honor, if I may be heard just a little bit further
Sure.
on that. We provided these designations to the state over a month ago on October 9, 2024. They've had time to submit clarifications or additional objections, and they declined to do so. In fact, the only thing that they did in response to receiving these designations was to withdraw the objections they made at page 5, line 18, page 48, line 9, page 52, line 7, and page 59, line 9. I'll note for the court that there is no testimony on page 5, line 18. It's a list of exhibits, so I'm not sure what the state was withdrawing there. But with all that said, we'd object to the state submitting supplemental objections. They had an opportunity at the deposition. They had more than a month to do so before trial started. And supplementing the objections at this point, Your Honor, would be untimely.
Yeah, I respond to that, Your Honor.
That's fine. Before you do, I want to get back to the list of objections that counsel is saying were explicitly withdrawn or waived by the state. So you listed page 5, line 18, which is not is a portion of the deposition that is precedes the testimony. Then
Your Honor.
page 48, line 9, you said. Is that right?
That's right, Your Honor.
All right. And page 52, line 7, correct?
Yes, Your Honor.
59, line 9. I have the list, is that right?
That's the list as it was provided to us by Mr. Craig.
Okay. And as to those matters, I guess, did you expressly withdraw your objections there?
I don't have that list in front of me. We did send them an email withdrawing objections, so I have no reason to believe that she's misstating what we've said.
Okay, understood.
And then at the pretrial conference, when we were talking about designations and objections, my understanding was the court was going to hear verbal objections, and we would go through the line by line, make verbal objections, and then the court would rule on it in chambers after the fact. Based on what the court said today, with your inclination to rule on after the trial, in order to save time, trial time, all that, it makes sense for us to just submit the objections in writing. We can go through line by line and do the objections as I anticipated during pretrial conference if we want, but in order to save time and allow plaintiffs to finish presenting the case, I think it's more efficient for us to do it in writing after trial.
Okay, I couldn't say, I guess, say exactly the words I used during the pretrial conference on this subject, but what I would say is that what I would have been intending to convey in my mind is the idea that if a deposition transcript is going to be offered into evidence, and there are objections stated on the record of the deposition that are not being withdrawn, they need to be ruled on, and so I would have a need to do that. Now I don't know that that ordinarily that process would entail a going through the deposition transcript and having any kind of oral argument on what the objections were and whether they ought to be sustained. But I don't intend to foreclose the parties from submitting any further written argument on the topic they want to submit as part of their proposed findings and conclusions. So I'll leave it at that. Other deposition transcripts at issue, or just
No other deposition transcripts, Your Honor, but we do have a few other evidentiary matters.
All right.
Plaintiffs would like to offer into evidence a number of the state's discovery responses as an admission by an adverse party. Those are on our exhibit list, and I also have copies for Your Honor, but this would be exhibits 213, 214, 215, 216, 217, and 218. And we've designated particular portions of each of those documents, but these are the state's answers to written interrogatories and their admissions in response to requests for admission.
All right. And the exhibits at issue, do they contain the entirety of the answers, the state's discovery responses, or just the portions you're seeking to admit?
The exhibits contain the entirety of the responses, Your Honor. However, we do have excerpted copies for you if you would prefer that.
All right. So what you have is some additional form of these 6 exhibits?
Slightly shorter form, Your Honor.
Slightly shorter. All right. And does Mr. Craig have the shorter versions at this point?
I don't believe so, but we can provide those electronically.
All right. Well, I suppose let me know, Mr. Craig, if you intend to object to the admission of these items into evidence. Whether it's, let's start with the existing exhibits, which you've certainly had an opportunity to review, exhibits 213 to 218.
Yes, our primary objection is, again, relevance. None of the questions that they asked during discovery are relevant to their claims. And you know, we could go through and, if you want, question by question. I don't have the shorter list and specifically argue why we don't think they're relevant, but as a whole, their discovery requests were not relevant to their claims and are not relevant and should be not allowed because of irrelevance.
Well, we'll accept the shortened versions of Exhibits 213 through 218, provided you can present a copy, I mean, I suppose by email to opposing counsel. That's fine. I'm going to deal with the relevance objections on the back end. These will be, I mean, as you say, interrogatory responses, if that's what they are, would be certainly statements of a party opponent that are eligible for admission in evidence if they're relevant. I'm not going to take the time to sort out whether they are or aren't relevant at this point. You all can; they're provisionally admitted, subject to post-trial consideration of the state's relevance objection, and counsel are welcome to present any written argument they want on that topic in their post-trial evidence or argument pieces that we'll set a protocol for at the end of the trial.
Thank you, Your Honor. So we have a clean record. Would you like me to briefly go through the response numbers that we've designated?
As long as you've handed me a binder that includes the excerpts that you want admitted. Is that not sufficient in some way?
I think that would be sufficient, Your Honor, but just so you have a record to refer back to, because the nature of these documents is that they may run over onto different pages, and those next pages may include responses we didn't designate. So I can run through this very quickly, accommodating the court reporter, though, by not going too fast.
All right, go ahead.
So for Exhibit 213, it's going to be response numbers 5 through 12, 15, and 20 through 22. For Exhibit 214, it's going to be response numbers 24 to 32. For Exhibit 215, it will be response numbers 1 through 6. For Exhibit 216, it'll be response numbers 6 through 12 and 21 through 22. For Exhibit 217, it'll be response numbers 7 through 147, 150 to 151, and 157 to 164. And finally, Your Honor, for Exhibit 218, it's just response number 1.
All right, understood. Thank you.
And last but not least, Your Honor, we're going to be asking the court to take judicial notice of a number of facts in post-trial briefing. These facts are contained in a variety of sources, which are all designated on our exhibit list, but we don't intend to offer them into evidence because they're properly the subject of judicial notice under Rule 201. I have a list of those exhibits if you'd like us to preview that for the court, but we can also just provide them to Your Honor in connection with our post-trial briefing.
All right. So some of the exhibits that you have designated and provided copies of, you're asking that I take judicial notice of them.
Of facts within them, Your Honor.
Facts within them. And so, what is your? Tell me again. What is your proposal as far as how this would be? I guess how this would be litigated.
Of course, Your Honor. At post-trial briefing, we'll file in connection with our brief a motion seeking judicial notice. And as part of that motion for judicial notice, we'll ask you to take notice of facts contained in a number of the exhibits that appeared on our exhibit list. For example, dictionaries with definitions for terms that we might want to refer to. And we have a list of those exhibits now that we can preview for Your Honor, but we can also put that off until post-trial briefing if Your Honor would prefer to move forward to testimony.
What do you say, Mr. Craig?
I suppose it would be helpful to know what facts they're asking the court to take notice of now as part of their case in chief.
All right. So I'm not sure how lengthy a discussion this is.
I think it might be a lengthy discussion, Your Honor, and it may in fact then be better reserved for post-trial briefing because we have a number of exhibits. For example, I'm not sure Mr. Craig wants to have me stand here and list all the dictionaries we're citing and the various definitions within them because that could take quite some time.
All right. And so if I understand correctly, it's a number of exhibits, and the judicial notice request would not seek admission of the exhibits in their entirety, but instead of or even of any portion of them, perhaps just of facts that they recite.
That's correct, Your Honor.
All right. And at this point, does Mr. Craig does he have a complete list of whatever these facts are that you're intending to seek judicial notice of?
He does not, Your Honor, and part of the reason for that is because we're not sure the scope of the facts that we'll be including in our post-trial briefing. Subject to judicial notice, some of those facts may come out in the course of the testimony at trial, and I don't believe that we're prepared to provide that here today.
All right, understood. Well, I suppose you can make any requests you want to in your post-trial papers, and Mr. Craig can object in any way he wants to, including, I guess, that your case will have rested without a determination being made on this topic. All right. Anything else?
No, Your Honor, I think we're ready for the main event.
Okay, let's have plaintiffs then call their next witness.
Your Honor, plaintiffs call Dr. Julie Lyons to the stand, and I did have one procedural question, Your Honor. Given your ruling concerning the testimony of Dr. Wardell, I understand that Your Honor would prefer an offer of proof to come from the examining attorney. And so my question for you, Your Honor, is whether I should make that offer of proof now at the point in Dr. Lyons' testimony where she would have made that testimony or after she's left the stand.
How about you just tell me now what testimony you would offer through Dr. Lyons that you understand you're not going to be permitted to offer on account of the ruling made earlier this morning.
Of course, Your Honor. So if plaintiffs were permitted to elicit testimony on this subject from Dr. Lyons, she would testify to the opinions that she expressed in her March 13, 2024 expert report at paragraphs 19 through 20, 33 to 38, and 83 to 89. Specifically, she would testify that it is her expert opinion that the state's abortion bans have exacerbated an existing physician shortage in Idaho, specifically impacting specialists who treat high-risk pregnant patients like obstetricians and MFMs. Her opinion would be based on her experience both practicing as a physician and also working as a clinical preceptor at the University of Washington School of Medicine, where she mentors and trains medical students who are applying to residency programs. Dr. Lyons' opinion would be further based on reliable and rigorous academic studies that she reviewed, indicating a drop-off in the number of medical students who are interested in applying to states like Idaho to practice obstetrics care because of the abortion bans or laws like them. Finally, Dr. Lyons would testify that her own practice has been impacted by these laws because it's reduced the number of specialists who she's able to work with to treat these high-risk pregnant patients. And she would further say that that's harmed her pregnant patients because by limiting the number of specialists practicing in Idaho, those patients are having to either delay their care or forego it altogether. And when they delay it, Your Honor, they're forced to travel much further than they might otherwise have had to do so. Dr. Lyons will also testify to the fact that these patients are being harmed because medical students who are coming to Idaho are not receiving appropriate training in abortion care, such that when these pregnant patients come in for care, these young doctors do not know how to provide it.
All right, thank you. You're welcome then to present the testimony that has not been excluded in advance from Dr.
Thank you, Your Honor.
Lyons.
And we've got some binders for the court, for counsel, and for the witness, if I could grab those.
That would be fine. Thank you. All right,
Fire, Your Honor.
go ahead.
Good morning.
Morning, Dr. Lyons. I'm sorry. All right.
Good morning, Dr. Lyons.
Good morning.
Could you please state your name for the record?
Dr. Julie Lyons.
Dr. Lyons, how are you involved in today's case?
I am a physician plaintiff and I am an expert witness.
Starting with your status as a physician plaintiff, on whose behalf are you bringing this lawsuit?
On the behalf of myself and the patients I serve.
And as an expert witness, in what field were you retained?
In rural family medicine.
Dr. Lyons, I'd like to walk through with you your background and educational history. Before we do so, I'll ask you, did you prepare any demonstratives to accompany your testimony today?
Yes, I prepared some slides with the help of my team.
Dr. Lyons, could you take a look at slide 2 in your binder and let us know what's on slide 2?
This describes my educational background.
Your Honor, can we display slide number 2?
Go ahead.
Dr. Lyons, where did you go to college?
I went to Brown University.
What did you study at Brown?
I studied biological sciences.
And when did you graduate?
I graduated in 1997.
Can you tell us what you did after you graduated from Brown?
Yes, after I graduated, I moved to Wyoming to pursue my passion in education. I was an outdoor educator as well as working at a school for children with emotional disabilities and taught adaptive skiing.
You were busy. Did you eventually decide to apply to medical school?
Yeah, after my time in Wyoming, I actually became a science teacher at a small Catholic school in Oregon. It was through teaching 7th grade science, where I was teaching health and anatomy, that I, really felt like my true passion was learning about the human body. And I felt like becoming a doctor would be a great way to integrate my interest in education and science and health. And so ultimately, I decided to attend medical school.
Where did you attend medical school?
I attended medical school at Oregon Health Sciences University.
And did you complete a residency after you graduated?
Yes.
What was your residency in?
My residency was in family medicine at the Family Medicine Residency of Idaho here in Idaho, in Boise, now known as Full Circle Health.
How long was your residency, Dr. Lyons?
It was a 3-year program.
And after you finished your 3 years at Full Circle Health, where did you start your practice?
I started my practice at St. Luke's Wood River in Haley, Idaho.
Is St. Luke's Wood River a particular kind of facility?
Yes, St. Luke's Wood River Hospital is a critical access hospital.
And what's a critical access hospital?
A critical access hospital is a hospital in a rural setting that has 25 beds or less. And these hospitals, due to the limited resources, receive additional Medicare funding to help keep our doors open.
Dr. Lyons, could you look at slide 3 in your binder and tell us what it depicts?
These are the positions I've held at St. Luke's.
May we display slide 3, Your Honor?
That's fine. Go ahead.
Dr. Lyons, what's the most recent title or position that you've held at St. Luke's Wood River?
Most recent, I've served as the chief of staff.
And have you held any other titles or positions there?
Yes, prior to that, I was served as the vice chief of staff for 2 years. I have been on the perinatal quality and safety committee. I have been the department chair for family medicine and ambulatory care. I was previously on the peer review committee and the credentials committee and the diabetes director for our hospital.
Could you look at slide 4, please, and tell us what's represented there?
This represents my work as a clinical preceptor.
Your Honor, may we display slide 4?
Go ahead.
Dr. Lyons, you mentioned you do work as a clinical preceptor. Where do you do that work?
I'm a clinical preceptor for the University of Washington, and I am part of the WWAMI program.
What's the WWAMI program?
The WWAMI program includes Washington, Wyoming, Alaska, Idaho, and who am I missing? Montana. And we are invested in educating medical students who ultimately want to train in rural settings.
And for those of us who chose law school instead of medical school, could you just tell us what a clinical preceptor does?
Yeah, clinical preceptors are essentially professors of medicine. We are teaching students how to become doctors.
Dr. Lyons, could you look at slide number 5 and tell us what's on there?
This is a list of my professional certifications.
Your Honor, may we display slide 5?
That's fine.
Are you board certified?
Yes.
And do you hold any other professional certifications?
Yes, I recently was nominated to be a fellow of my academy. I have certifications in neonatal resuscitation, basic life support, advanced cardiac life support, advanced life support in obstetrics, and stable.
And Dr. Lyons, please look at slide number 6 and tell us what it represents.
This represents my professional memberships and awards.
Your Honor, may we display slide 6?
Go ahead.
Dr. Lyons, are you a member of any professional organizations?
Yes, I am.
What are those?
I'm a member of the American Academy of Family Physicians, the Idaho Academy of Family Physicians, the Idaho Medical Association, the Idaho Coalition for Safe Healthcare, and I believe that covers it.
And in the course of your work in Idaho, have you received any awards for your work?
Yes, I've received an award from the University of Washington for excellence in clinical preceptorship. In 2022, I received the Idaho Rural Healthcare Hero Award for my work in women's health and increasing vaccine coverage in my community. I have been voted the Valley's best doctor in my community for 5 years in a row.
And please look at slide 7. Tell us what's on there.
This describes my local community service.
Your Honor, may we display slide 7?
Yes.
Dr. Lyons, beyond the work that you do at St. Luke's and the work for the University of Washington, can you tell us about the work that you've done in your community?
Yes, I really enjoy serving my community. I've been currently a member on the Blaine County Mental Wellbeing Initiative. I established the Blaine County Women's Healthcare Initiative, which is a program where we provide free birth control to women in our community. I served on the Blaine County School District as a physician liaison for the school nurses during the COVID pandemic, where I advised on policies, procedures, and protocols in keeping our kids healthy. And I was a Latino outreach coordinator during the pandemic, helping to improve vaccine rates for our underserved communities.
Could you please turn to what's been marked as Plaintiffs Exhibit 15 in your binder, Dr. Lyons, and tell us what you understand that document to be?
This is a copy of my resume.
And did you submit a copy of your resume in connection with your expert disclosures in this case?
Yes.
Does Plaintiffs Exhibit 15 appear to be a full and correct copy of your resume?
Yes.
Your Honor, plaintiffs move for admission of PX 15.
Any objection?
We would object on hearsay grounds, but suggest we do the same thing as with prior items like this.
All right, understood. Exhibit 15 will be admitted. Limited purpose of reflecting Dr. Lyons' qualifications.
Dr. Lyons, since you began your career in Idaho more than 2 decades ago, have you taken any significant leaves of absence?
Yes, I've had two short maternity leaves, and I'm currently on a sabbatical.
And why are you taking a sabbatical?
Taking a sabbatical to homeschool my children and do some traveling and for personal reasons.
And when is your sabbatical ending?
It ends in June.
Will you return to practice medicine in Idaho when your sabbatical ends in June?
Yes, I will return to my community and continue to practice full spectrum family medicine with obstetrics.
Could you describe for us at a high level the scope of your practice as a family medicine provider in a rural area?
Yeah, family medicine and providers in rural areas, we provide comprehensive care. I take care of patients from womb to tomb. I take care of patients when they're in labor. I take care of their babies that are born after. I take care of patients in the hospital who are admitted for pneumonias or other health conditions. I run a very busy and full clinical practice in the clinic and take a lot of night calls to keep our hospital running. I also work in the emergency room, helping out my fellow colleagues when emergencies arise.
On a given day, understanding that there is no typical day, how many patients do you typically see?
I typically see 20 to 25 patients a day.
You mentioned that you deliver babies and provide postnatal care. Dr. Lyons, can a family medicine physician like yourself provide obstetrics and gynecological care?
Yes, we are trained to provide full spectrum care, and that includes obstetrical care as well.
And in your obstetrics practice, do you work with any specialists?
Absolutely. As a primary care family physician in a rural setting, I am well trained, but I am not trained to manage every complication that can arise in a pregnant patient. And so I rely heavily on collaborative care with my colleagues, my OB/GYN colleagues here in Idaho, and my perinatologist or maternal fetal medicine colleagues here in Idaho.
On average, how many pregnant patients are you caring for at a given time?
I deliver approximately 40 patients a year. Our hospital delivers a total of around 170 patients, and this is pretty typical for the average family physician.
Can you ballpark for us, Dr. Lyons, approximately how many babies you've delivered in the course of your career?
I mean, I've attended probably 700 to 1,000 deliveries.
Why did you choose to practice medicine in rural Idaho?
I grew up in a rural town, and my father was a doctor, and I loved being part of a small community and being able to provide care in such an intimate setting.
Was there anything about Idaho's training programs that attracted you to the state?
Absolutely. When I was a medical student and I fell in love with family medicine, and I knew I wanted to be a rural doctor, and I knew I wanted to help take care of women and children, one of the best training programs in the country is here in Idaho, in Boise. It is an excellent program for its rural training tract and for its women's health tract. The women's health tract is what truly drew me because I knew that I could become competently trained in providing obstetric care and abortion care here in Idaho.
Does that same training program, that women's health tract, still exist in Idaho today as it did when you were training?
Objection, relevance.
Overruled, you can answer.
No, the current program is not as comprehensive as it used to be because of the abortion laws.
And when you say it's not as comprehensive, what do you mean?
Our medical residents are not getting the same type of abortion training as they were prior to the laws.
Your Honor, we
Dr.
would
Lyons.
object. We're getting into residency, those kind of items,
All
broader
right.
physician topics.
We're moving into a
Those
new
on
topic.
second thought appear to be along the lines of the prior ruling, so I'll reverse my ruling on the prior objection. I'll sustain the objection and disregard the answer. You can move on.
Your Honor, if I may, this was foundational to Dr. Lyons' training and to the background of the physicians with whom she works.
Well, I'm not sure whether medical residents obtaining currently the training they used to obtain, how that is foundational to Dr. Lyons' testimony, as you say. But in any event, you may continue.
Dr. Lyons, given that you practice medicine in a small community, what were your feelings about joining a public lawsuit down in Boise?
Oh, I was petrified. I was certainly worried about what repercussions could come to my career and to my family. And Idaho hasn't always been overly friendly to those of us that feel that this is a healthcare right.
Even though you were petrified, why did you ultimately decide to become a plaintiff and an expert witness in this lawsuit?
I mean, frankly, because I saw my patients at extreme risk and harm. These laws have destroyed the patient-doctor relationship and infringed on patient privacy. And I knew that I needed to use my voice as a physician to amplify the needs of my patients and keep them safe here in Idaho.
As a doctor, what changes are you hoping result from this lawsuit to Idaho's laws?
I am hoping that we can clarify these laws.
Is there a particular way in which you'd like to see them clarified, Dr. Lyons?
Yes, I would like these laws to be clarified to include medical exceptions that include abortions for patients with fatal fetal diagnoses, abortions for patients who have a medically necessary abortion to maintain their health, and abortions when patients have another diagnosis that they can't treat unless they are no longer pregnant.
Before we get into your expert opinions in this case, I want to talk a little bit about your own experience providing care to pregnant patients before and after these laws went into effect. So, Dr. Lyons, are you familiar with the laws that the state of Idaho passed in 2022 concerning abortion access?
Yes.
Could you take a look at slide 8 in your binder and tell us what's on that slide?
These are the laws.
Your Honor, may we display slide 8?
Go ahead.
Dr. Lyons, can you, you said these are the laws in particular. We've been talking about abortion bans today. Are these the laws that we've been referring to when we talk about the abortion bans?
Yes.
Are you familiar with the medical exceptions to these laws?
Yes.
Could you look at slide 9 and tell us what's on slide 9?
Slide 9 is the medical exceptions to our abortion laws.
Your Honor, may we display slide 9?
Go ahead.
Dr. Lyons, I know that you're not an attorney, so not asking for your legal interpretation of these laws, but from the physician's perspective, what's your understanding of the scope of the medical exceptions under the existing law?
And essentially, the only exception is that abortion can be provided to prevent a patient's death.
Is abortion generally considered to be a safe procedure by experts in your field?
Yes, abortion is safer than carrying a baby to term.
Are there any emergent medical conditions for which abortion is considered to be an appropriate medical treatment?
Yes, there are many medical conditions.
Could you describe for us how abortion care was part of your practice in conjunction with caring for pregnant patients before the abortion bans went into effect?
Before the bans went into effect, abortion care was a conversation I had with all of my patients. I was able to counsel them confidently in their decisions. I was able to assist in the provision of emergency abortions when necessary. I was able to provide abortions myself, and I was able to refer patients to Boise to our maternal fetal medicine specialist when it became necessary to have an abortion for medical reasons.
You said you would refer your patients to Boise if they needed an abortion for medical reasons. Why would you do that?
The scope of our training and the way we train in medicine is each of us have our own sort of realm, probably similar to you lawyers. But yes, perinatologists or maternal fetal medicines are the specialists that help us primary care doctors handle high-risk pregnancies, including abortion care when necessary.
So, Dr. Lyons, when you would refer your pregnant patients to specialists in Boise, what, if any, further interaction with that patient and her care would you have?
Well, these are my patients. I take care of them, taken care of them before they get pregnant. I take care of them while they're pregnant. I take care of them during their complication. I take care of them post-operatively. And I'm, consulting with my specialists. I'm reading chart notes. I'm, the quarterback of the team.
Is there a term for that kind of model of care where you quarterback and you work with specialists to provide care to a patient?
Yeah, we call this a shared care model in medicine.
Why do you employ the shared care model?
The shared care model is essentially what is necessary to keep patients safe. It is the model that works best in rural health settings where we can really reduce morbidity and mortality and make sure that we are following standards of care and, keeping patients safe and healthy.
Dr. Lyons, how has your own practice of treating pregnant patients changed since the abortion bans went into effect?
Well, the laws have had a really chilling effect. Initially, doctors were so confused, we were scared to even counsel patients on abortions, especially since our Attorney General issued guidance that it would be considered aiding and abetting to even refer a patient across state lines. I no longer can assist in the provision of an abortion for emergency care, and I have challenges getting my patients access to the specialists they need when they have pregnancy complications.
What about the
relevance, hearsay, discussion of what others were saying?
Your Honor, there's been no statement elicited. That's not hearsay.
Overruled. You can continue.
What about the experience of practicing medicine in a rural area on the whole? How has that been impacted by the abortion bans?
Well, practicing in a rural Idaho town is an extremely stressful, time-consuming, all-encompassing job. And with the implementation of these laws, it's really exacerbated that problem, and it's created delays in patient care, and this is a direct contributor to patient harm and patient safety.
Dr. Lyons, did you provide an affirmative expert disclosure in this case?
Yes.
Did you form any opinions in that disclosure?
Yes.
Did you form those opinions based on sufficient facts and data?
Yes.
Did you use reliable principles and methods when forming those conclusions?
Yes.
And did you reach those conclusions to a reasonable degree of scientific certainty?
Yes.
Could you please look at slide number 10 in your binder and tell us what's depicted there?
This is a summary of my opinions that I formed as an expert witness.
Your Honor, may we display slide 10?
Go ahead.
Dr. Lyons, we'll walk through each of these in a bit more detail, but at a very high level, could you tell us what the opinions were that you formed in this case?
My opinions are as follows. Firstly, is that patients and physicians and healthcare providers in rural Idaho face significant challenges when for access to care and provision of care. Secondly, the abortion laws have caused extreme confusion and fear amongst physicians and members of the healthcare team. Thirdly, these abortion bans really are exacerbating already underlying problems for patient access to care. And this puts our Idahoan women and children at extreme risk. And the also creates a lot of distress amongst the physician community and increases our burnout. Finally and frankly, these abortion laws prevent doctors from providing evidence-based standard of care medicine.
Your Honor, we would object to burnout and again the general physician discussion, healthcare more generally.
Your Honor, if I may be heard, this goes directly to the impact on Dr. Lyons, who is a plaintiff in this case.
All right. Well, ultimately, whatever testimony is rendered is not going to be considered in service of a theory that the laws are having the effect of bleeding the state of medical providers necessary to provide obstetrical gynecological care. Dr. Lyons' testimony as to the effect on her is fine.
Thank you, Your Honor. Let's start with your first opinion, Dr. Lyons. Could you remind us which one that was?
Yes, that's essentially, working in a rural setting, access to care and delivery of excellent health care is a challenge.
Let's start from the physician's perspective. What are some of the challenges associated with providing health care to your patients in a rural setting?
Your Honor, we would object to opinion number 1 is not relevant to plaintiff's as applied challenge, speaking more generally to rural Idaho.
Your Honor, Dr. Lyons is a rural family medicine practitioner. She's a plaintiff in this case. This goes directly to the impact that the bans have had on her.
Well, among other things, she's also testified in brief to the opinion at this point as well, without objection. Objections overruled. You may continue.
Dr. Lyons, I'll re-ask the question. What are some of the challenges from the physician perspective of practicing care in a rural area?
Same objection.
Overruled.
Essentially our challenges in a rural state, primary one is geography, access to care, access to subspecialists, and those are the essential, parts of my job that are challenging.
I'd like to get a better understanding of the patient population that you and your colleagues serve in rural Idaho. So to do that, could you take a look at Plaintiffs Exhibit 39 in your binder?
Yes.
And what is Plaintiffs Exhibit 39?
This is data on Idaho's rural health population.
Who is that data provided by?
The Idaho state.
And is the state of Idaho generally considered by experts in your field to be a reliable source of data?
Yes.
Your Honor, I would move to admit Plaintiffs Exhibit 39.
Objection.
Objection, relevance.
Your Honor, again, this is foundational to understanding the patient population that Dr. Lyons and her colleagues serve, the patient population on whose behalf she's bringing this lawsuit.
All right. I'll overrule the relevance objection and admit Exhibit 39.
Dr. Lyons, could you please review slide 11 in your binder and tell us what's on slide 11?
Yes, slide 11 is a description of the rural nature of Idaho. We're one of the most rural states in the country, as those of us that live here know. We rank 44th out of 50th in population density. And we also have a significantly lower per capita number of doctors per patient.
And the statistics you just discussed, where do they come from?
They come from the state.
And is that Exhibit 39?
Oh, yeah.
Dr. Lyons, can you speak a little bit about the challenges that you've observed in your practice for your pregnant patients in accessing care in a rural area?
Objection, relevance.
Overruled. Go ahead and answer.
Yes, so I take care of patients, for about 18,000 in our general area, many of whom travel many miles, sometimes up to 3 hours, to come to a prenatal appointment. Our critical access hospital, as well as those around the state, are limited in what types of pregnancy complications we can treat at our facilities and handle in our facilities. And so the geography becomes a significant barrier when patients develop a pregnancy complication.
Can you speak a little bit about health outcomes for patients living in a rural part of the state? How do those compare to their counterparts in urban areas?
Yeah, the statistics show that patients who live in rural Idaho tend to have, they do have higher poverty rates. They have less access to insurance, or are underinsured or uninsured. We have higher rates of preterm delivery. We have higher rates of teen pregnancies. And we take care of patients who have higher rates of pre-existing health conditions, which therefore put their pregnancy automatically at in a higher risk scenario.
Taken together,
Again,
how
we
do
would
those...
object on relevance grounds and not relevant to the applied challenge, talking generally about healthcare.
Your Honor, again, this goes to the experience of the pregnant patients Dr. Lyons treats and on whose behalf she's suing.
Overruled.
Dr. Lyons, all those factors taken together that you just mentioned, how did those impact the health outcomes of your patients?
Yeah, health.
Is there any particularly vulnerable patient population in a rural area that faces specific challenges?
Yes, in my community and those throughout Idaho, some of the most vulnerable populations that we serve are our immigrant populations, our refugees, and our indigenous communities.
And do those communities face any specific challenges?
Yes, these communities.
Under objection relevance, no plaintiffs before the court have these conditions.
Overruled. And I suppose I'll note, just for whatever it's worth, that in the end, when I'm charged with making a decision in the matter, I can only rely on evidence that proves to be relevant in making that decision. While there may be a fairly broad conception of relevance that is at play during the course of this trial, that is a separate matter than whether any individual item of evidence will prove to be relevant to the grounds for decision in the end, and that'll just be sorted out by and large in the back end, on the back end. All right, you may continue.
Dr. Lyons, I believe you were talking about the challenges unique to the immigrant, refugee, and indigenous communities in your area. Could you finish your answer?
Yes, my patients who come from these vulnerable populations face sometimes insurmountable challenges accessing care. It may be culturally, there may be language barriers, they may not understand how to access health care. They may not have access to transportation that could get them to appointments that may be necessary outside of our catchment area. My vulnerable patients are often put at an extremely challenging risk, which increases pregnancy complications rates and really makes my job harder.
You mentioned pregnancy complications rates, so I'd like to ask you about what percentage of your pregnant patients experience some form of complication?
I estimate about 25 to 30% of my patients develop a pregnancy complication.
And when a patient of yours develops a pregnancy complication, in your experience, is that likely or to lead to a situation in which abortion care could be considered an appropriate treatment?
Yes.
Objection leading.
Overruled.
Dr. Lyons, you mentioned earlier challenges related to geography, specific to practicing in a rural area. So in your experience, how often does the typical pregnant patient have to come in and see her doctor?
A typical patient may need to have 16 to 18 visits.
How does that change, if at all, for patients who have a high-risk pregnancy or are experiencing complications?
The number of needed visits increases significantly. There's no particular number. It really depends on what the condition is and at what point in the pregnancy she is, but it increases.
Do your pregnant patients ever have to travel outside of your area for specialty care?
Yes, often. That is part of the nature of my job, is to triage my patients and access help when that is necessary.
And when they need to travel, where do they go?
Our primary referral center at St. Luke's Wood River is working with St. Luke's Boise, and our secondary is St. Luke's Magic Valley.
How far are St. Luke's Magic Valley and St. Luke's Boise from St. Luke's Wood River?
St. Luke's Boise is approximately 3 hours by road, and St. Luke's Magic Valley is approximately 90 minutes.
Has the need to travel those distances ever prevented your pregnant patients from obtaining access to care that they needed?
Yes, absolutely. And let's say in a non-urgent situation where a patient needs to access a maternal fetal medicine specialist for a consultation or an additional ultrasound or some more testing, and I refer them to Boise for this appointment. Many patients, especially my underserved populations, it's extremely challenging for them to even get to that appointment to get care. And ultimately, if they're not able to go to that appointment, it drives up their health risk significantly.
How frequently is that an issue in your experience?
I would say that about 25% of my patient population has challenges accessing care outside of my valley.
You talked about non-urgent situations, and I want to focus now on urgent situations, Dr. Lyons. What happens when a pregnant patient needs to be transferred to a different hospital? I think, where do they go?
Objection relevance.
Overruled.
When we have a emergent pregnant condition that comes in our hospital, we try to get them ideally to Boise or Magic Valley, and it really depends on the weather and the condition and, you know, if we have a team available that can transport them there.
How do the resources at the Boise facility compare to the resources at your own hospital?
They're extremely different. It's a tertiary care center, and they have access to a lot more than what we do.
Dr. Lyons, are there any geographic factors that have previously impacted your ability to transfer patients safely?
Yes, we frequently encounter snowstorms or bad weather, which may limit our ability to transfer patients in emergency settings.
What do you do when you can't transfer a patient who's undergoing a medical emergency?
I panic, and I come up with plan B and C quickly, and I rally the troops, and we do what we can to keep that patient stable and safe until we can get her to where she needs to be.
You also mentioned resource limitations that impact hospitals in rural areas. So could you give us some examples of those resource limitations?
Yeah, we are often limited by personnel factors. We often don't have OB-trained nurses to keep our department open and face diversion issues. We are limited by our equipment in terms of having one ultrasound available and one tech available, and if that person or that machine isn't working, we may not be able to provide that test to the patient's needs. On occasion, I'm limited by what medicines are in my pharmacy at my hospital. For example, we had a Pitocin shortage, and Pitocin is a standard common drug that is necessary for treating pregnancy and pregnancy complications. So on any given day, I may walk into my job and have to deal with these types of factors and sort of troubleshoot.
I want to object to any portion of that answer getting into the physician shortage issue.
All right. The answer will not be considered for that purpose.
If I may, Your Honor, Dr. Lyons was talking about before the bans went into effect, so this is not related to that issue that Mr. Grigsby is concerned about. Dr. Lyons, are the resource limitations that you just described typical of rural hospitals?
Yes, these are typical of critical access hospitals.
And how do those shortages impact your ability and your colleagues' ability to care for pregnant patients?
Same objection.
Overruled.
I mean, they make my job harder and more stressful.
I'd like to talk about your next opinion now, Dr. Lyons, the second one. Could you remind us what that was?
Oh, my second opinion. Yes, this opinion is in regards to the fact that the abortion laws have created significant confusion and fear amongst myself and my physician colleagues in Idaho.
Can you tell us what's the basis of that opinion?
The basis of this opinion is based on my own personal experience, as well as conversations with my local colleagues and my colleagues throughout the state, knowing that I was trained here and have a lot of colleagues I talk to.
Have you attended any professional organization meetings concerning the laws?
Yes, I've attended meetings with the Idaho Academy of Family Physicians and the Idaho Coalition for Safe Healthcare, as well as meetings that have been offered by my healthcare system.
Dr. Lyons, I want to start with the confusion point. So tell us what in particular about the abortion bans is causing confusion in your expert opinion?
Objection to the extent it calls for testimony outside of her personal knowledge.
Your Honor, Dr. Lyons is an expert witness. She's testified to the bases of this opinion, and she can speak not only to her own personal experience, but also to the observations that she's made of her colleagues.
Overruled. You can answer.
Repeat the question.
Of course. What in particular about the abortion bans is causing confusion amongst physicians?
Well, the plain and simple fact is that they are not written with any medical terminology. They do not follow any kind of standard of care, and they are ethically and morally wrong.
We put up slide 9, Your Honor.
Go ahead.
Dr. Lyons, looking back at slide 9, The total abortion ban, as you mentioned, allows doctors to provide abortion care if it's necessary to prevent the death of the pregnant woman. So I'll ask you, is preventing death part of the standard of care when treating a pregnant patient?
No, absolutely not. My goal, my duty, my oath is to keep my patients healthy and safe and to prevent complications and deal with the complications as soon as they happen and not wait until a patient is dying.
When the abortion bans first went into effect in 2022, do you know whether there was an exception that allowed physicians to provide abortion care to treat an ectopic pregnancy?
No, there was not.
And do you know if that's allowed now?
Yes.
Has there been any confusion among you or your colleagues related to that?
Yes, there's been extreme confusion amongst colleagues in Idaho, especially to some of the physicians that may not be following the changes in the law as closely. And it also creates confusion amongst the other members of my healthcare team, including my nurses and technicians and administrators. And so if a patient with an ectopic pregnancy comes in, I'm telling you that it is a bit of a chaos situation.
Dr. Lyons, to your understanding, do the medical exceptions as they exist today allow doctors to provide abortion care if a patient's received a fatal fetal diagnosis?
They do not.
In your professional opinion, has that confused physicians in Idaho?
Yes.
And in your opinion, how could the lack of an exception for fatal fetal diagnoses harm your pregnant patients?
Patients who have a fatal fetal diagnosis and remain pregnant put their health at risk in many circumstances, and the longer they remain pregnant, the higher likelihood they are of developing further pregnancy complications, which can lead to things like future infertility and damage of other parts of their body, and not to mention the mental health risk that happens when you are faced with this.
Were physicians in Idaho confused about in what situation they could provide a patient with abortion care before the abortion bans went into effect?
No, they were not.
Given the confusion that's resulted, to your knowledge, has the state provided any official guidance seeking to help doctors interpret the scope of these medical exceptions?
No.
Before the abortion bans were passed, Dr. Lyons, can you recall any other law passed by the state of Idaho that prescribed the scope of the care that you and your colleagues could provide to pregnant patients?
No.
Can you recall any law passed by the state of Idaho that prescribed the scope of care you could give to any patient?
No.
Do hospitals have legal counsel who could potentially assist in interpreting these laws?
Yes, mine does, and I assume others do as well.
Dr. Lyons, does having legal counsel at your hospital solve the problem of physician confusion in your experience?
No offense, but no.
Tell us why not, please.
It's another burden. It's another barrier to care. My training and my expertise is to make the medical decision that is necessary for my patient and not to consult a lawyer to ask them what is the medically necessary, recommended treatment for this patient.
I assume the answer is no, but are these attorneys trained medical providers?
No.
Action leading.
Overruled.
Dr. Lyons, you also said that in addition to confusion, the abortion bans have caused a great deal of fear amongst Idaho physicians who treat pregnant women. So separate and apart from the confusion, what about the abortion bans is causing you and your colleagues to be fearful?
Frankly, it's very scary to know that if you provide care to someone, you could go to jail, you could be sued, you could lose your livelihood, and you could lose your license.
Do those fears impact the way that you and your colleagues interact with your pregnant patients?
Yes, absolutely.
Are you aware of any concerns, either that you have or among your colleagues, that the abortion bans could impact your ability to be credentialed in the state of Idaho?
Yes, as chief of staff, I'm aware of the credentialing process quite well, and if a member of the community were to file a complaint against a physician at the Board of Medicine, and this ultimately comes back into our credentialing, even just a complaint can make a credentialing a physician hard, which can, again, create limitations on where we can practice and work.
Could you give us an example of a time in your own experience in which this confusion and fear impacted the care that was provided to a pregnant patient under your care?
Yeah, I have a patient story
In
from.
relevance as to any specific individuals, it's not before the court, not related to the claims at issue, so we would object to any stories about a specific individual.
Your Honor, again, this goes directly to the experience of the patients on whose behalf Dr. Lyons is suing. She'll testify that this situation occurred within the last year, so this is very relevant.
Overruled. You can answer.
Dr. Lyons, please continue telling us about how this fear and confusion impacted one of your pregnant patients.
I was on call one night and received a call from the emergency room to come and help attend a 14-week patient who was heavily bleeding. This patient had developed a massive subchorionic hemorrhage. That's where the placenta rips off the side of the uterus. And she had developed this earlier in the week and had been into the emergency room several times and had been seen by her OBGYN as well. The patient had also had multiple ultrasounds and a consultation with a maternal fetal medicine specialist here in Idaho, saying that this pregnancy was not going to survive. However, the patient had not, to no discredit of my colleagues, had not been even counseled on whether to have an abortion or not, because my colleagues are so scared and confused to even mention the word. It's like a hot potato, like pass the patient around and hopefully something will happen, and declare itself. And so this patient had become increasingly anemic. She had incurred three visits to our ER, multiple lab tests. She was actually a member of one of our populations we spoke of previously, and I happened to be on call on a night where I was working with some amazing nurses, and we decided as a team that we were going to break our hospital's rules and admit her, even though she wasn't 20 weeks pregnant, because I just couldn't send her home again and hope for the best. And so we admitted this patient to our labor and delivery floor, and a few hours later, she aborted her fetus, and she hemorrhaged and required a blood transfusion.
Dr. Lyons, I'd like to talk about your next opinion. Could we display slide 10 again, Your Honor?
Go ahead.
Dr. Lyons, could you remind us what your third opinion was?
My third opinion is that these abortion laws exacerbate problems that physicians and providers. Sorry.
You want to take a moment?
Take your time. This also would be fine to take the morning break at this point if you like. So
Absolutely, Your Honor. Let's take a break.
why don't we do that? We'll take 15 minutes. We'll reconvene about 10:40. We'll be in recess. Please be seated. Counsel, you may resume with the direct examination of Dr. Lyons.
Thank you, Your Honor. Dr. Lyons, before we took a break, we were about to look at your third opinion in this case. So, Your Honor, if we could display slide 10.
Go ahead.
Dr. Lyons, please remind us about your third opinion in this case.
Yes, my third opinion is that these abortion laws exacerbate and worsen problems for patients and for doctors in Idaho, including creating significant delays in care and putting patients at harm and patients at their safety at risk.
Could you explain for us, with respect to delays in care, how the abortion bans have impacted your practice and your colleagues' practices?
In terms of delays of care, you know, this has been expressed in several different ways. Not only is there delay in accessing subspecialty care because we have a limited number, especially initially, of subspecialists, but also just in particular in when we reach a diagnosis, now we are sort of forced to practice defensive medicine, and many times are over-ordering tests, over-ordering ultrasounds, and kind of delaying care in the patient just so that we can protect ourselves as physicians and not be liable and go to jail.
Let's start by talking about the over-ordering of tests. Can you explain a bit more why you personally are doing that?
Yeah, so personally, prior to the bans, if a patient comes in with maybe something like a miscarriage, I would order tests to confirm it, an ultrasound to confirm it, and offer her treatment. Now, due to the bans, most of us are fearful to declare it a miscarriage too soon. We are having her come back for additional tests, additional ultrasounds. This is increasing cost to the patient and to our healthcare system in Idaho. And really, it's not practicing the standard of medicine, but we want to make sure that we have all the evidence that is in the chart and shows that we were not actually providing an abortion to this patient.
You mentioned wanting to have evidence in the chart. Dr. Lyons, have the abortion bans impacted how you document your patient's care?
Yes, I spend a lot more time documenting on all of my pregnancy complications now.
These changes you've described to your practice, have you observed your colleagues making similar changes after the abortion bans went into place?
Yes.
Based on your experience, how do those changes in the way that rural physicians are treating pregnant patients impact health outcomes?
Well, when I spend more time documenting, I'm spending less time at the bedside, less time taking care of my patient. Increased documentation also is clearly linked to physician burnout and dissatisfaction, which is a driver in keeping our workforce happy and healthy as physicians. Patients themselves are being, put at risk by delaying necessary care so that we can ensure our license is protected.
Objection relevance, getting at the court's order on general physician.
Your Honor, this wasn't talking about physician flight. This was talking about the provision of care to patients. Physicians can be burned out and continue practicing.
Understood. To any extent it went beyond those bounds, it won't be considered for that purpose.
Dr. Lyons, earlier we spoke about your hospital's legal counsel. So I want to ask you, before the abortion bans were in place, did you and your colleagues consult legal counsel at your hospital when deciding what care to offer to a pregnant patient?
No.
Did you ever consult hospital administration in deciding what care to offer a pregnant patient?
No, I on occasion have to work with hospital administration for transfer and triage reasons, but ultimately the decision of the medical treatment was left up to the physician.
After the abortion bans went into effect in 2022, have you noticed changes to that practice among your colleagues?
Yes, I think our colleagues myself and colleagues throughout the state are, again, delaying care by consulting the legal team, by working with our hospital administrators, We have to get everybody on our healthcare team on the same page. And, you know, I spend a lot of time educating my nurses and those working with me as to why it is safe to treat an ectopic or why it's necessary to transfer this patient. And before the bans, you know, that wasn't the case.
What impact does that have on your pregnant patients?
You know, this delays their care and they're not getting quality, safe care, and this will drive up their morbidity and mortality rate, which is already extremely high in Idaho anyway, especially in the rural setting.
Dr. Lyons, in your opinion, if the scope of the medical exceptions were clarified as plaintiffs are seeking in this case, would your colleagues continue to consult legal professionals and hospital administration when deciding what care to give to a pregnant patient?
Objection calls for speculation, lack of personal knowledge.
Your Honor, again, this is based on Dr. Lyons' observations of her own colleagues and discussions with them.
Overruled. You may answer.
Clarifying the laws would let myself and my physician colleagues do what we do best, which is take care of patients.
Would you continue to have to delay patient care if the laws were clarified?
No.
Dr. Lyons, I want to talk about your fourth and final opinion now. So could you remind us what that was?
Yes, my fourth opinion is simply that these bans do not allow physicians in Idaho to practice safe, evidence-based healthcare.
Dr. Lyons is someone who's been practicing in this state for almost 20 years, not 20 decades, I apologize. Knowing what you know now,
My skin looks good.
would you choose to do it all again, come back to Idaho to practice if you knew what the state of the laws were?
No.
And what would need to change to ensure that Idaho physicians could once again practice safe, evidence-based health care in connection with treating their pregnant patients?
At the bare minimum, we need to change the laws to have exceptions, to be able to provide abortions to patients who need them because they have been diagnosed with a fatal fetal condition. We need to broaden the exception to allow patients who have other health conditions, but by being pregnant puts their health at risk and it does not allow them to treat their other health problem. And we need to clarify the laws and really put the health of a woman first. We cannot wait until it's too late.
Thank you, Dr. Lyons. Your Honor, I have no further questions at this time.
All right. Thank you, counsel. Mr. Grigsby, cross-examination.
Good morning, Dr. Lyons.
Good morning.
What is an emergent medical condition?
An emergent medical condition is a condition in which doctors need to intervene in a timely manner in order to prevent a patient from suffering consequences.
What sort of consequences?
Objection vague.
Overruled. You can answer.
Well, I mean, some would consider a broken arm an emergency, and if we don't straighten it, you will continue in pain. Others may consider, bleeding in pregnancy an emergency. I mean, there's a wide range of emergent conditions. Which ones would you like me to spell out for you?
You have treated close to 1,000 pregnant patients, correct?
Mm-hmm.
And you have delivered or attended deliveries for close to 1,000 babies.
Yes.
You have never personally performed an abortion in your current employment, correct?
No,
You have personally performed an abortion in your current employment.
I have not personally performed an abortion in my current employment.
Okay. And you do not personally perform abortions in your current employment, correct?
I do not.
You do not perform abortions, correct?
I do not perform abortions.
You recall testifying to challenges related to providing care in a rural setting.
Yes.
Those challenges that you testified about, they have existed for decades in the Wood River Valley, correct?
Yes.
Moving to before you joined St. Luke's, you were a medical assistant at Planned Parenthood before becoming a physician?
During my, after I was teaching in Oregon as a science teacher, I knew that to go to medical school, I needed to obtain some clinical experience. And I applied broadly and throughout Oregon for a clinical
I'll
position.
ask my question again.
And I obtained a job at Planned Parenthood.
Hold on just a moment. We can't have people talking over each other. I'm going to let you know, Dr. Lyons, that if your counsel wishes, she can ask a follow-up question on redirect concerning why you took that job, which was what you were getting to. But if you would just answer the question as to that he asked, which was whether you were a medical assistant at Planned Parenthood before becoming a physician.
Your Honor, I would just also request that Mr. Grigsby not interrupt the witness while she's in the middle of an answer.
Well, as a general matter, that might be the case, but what he was essentially saying is that the answer was not responsive to the question. And he's trying to get a concrete answer to that question. So if you can answer that question in a yes or no way, please do so.
Yes.
After completing your medical residency, you worked at Planned Parenthood as a locum physician, correct?
Yes.
A locum physician works for an organization but isn't a full-time employee, correct?
Yes.
You have donated to Planned Parenthood before?
Objection, relevance.
I suppose the notion is that it's somehow relevant to bias or credibility, I suppose. It may be very passingly relevant to that topic. I won't permit granular questions on that subject in terms of the amount of money or donation dates, but I'll permit a broad, the question be answered in a broad way. Did you donate? Have you donated to Planned Parenthood or not? That was the question. You can answer.
Yes, I frequently donate to nonprofits, including Planned Parenthood.
You donate to Planned Parenthood when you remember, correct?
Yeah, if I remember, on occasion I donate to Planned Parenthood.
No further questions.
All right, thank you, Mr. Grigsby. Any redirect?
No, Your Honor, we'd ask that Dr. Lyons be excused.
All right, thank you, Dr. Lyons. You may step down. Plaintiffs may call their next witness.
Good morning, Your Honor. Plaintiffs call Professor Shannon Withicombe.
All right.
I'll object to Dr. Whitcomb's testimony as a whole. Her testimony, her opinion as expressed in her expert report are simply not relevant. We made this argument in our opening trial brief. It's not helpful to the court for her to contradict what the Planned Parenthood Idaho Supreme Court case has held, and in fact, where she contradicts case law. Other case law specifically held that that is not helpful to the court and should not be allowed. So I'll object to her testimony as a whole.
Understood, and I'm going to permit the testimony to be rendered subject to ruling on that objection on the back end as part of the post-trial decision process. And this is the kind of thing that, to me, if we were going to engage in these sort of broad arguments that disclosed expert testimony is entirely irrelevant. And in limine motion would have been an appropriate way to get at that. Now, not making an in limine motion certainly doesn't mean your objection's waived, but what it does mean is that it's easier to, at this point, and more efficient to simply hear the testimony and decide the objection on the back end than try to investigate what the testimony is before it's been presented. And when, as far as I know, I don't have Dr. Withicom's report, expert report, available to me to review in advance. So there's really not a good alternative to simply listening to the testimony and deciding the relevance objection on the back end. So you've got a standing relevance objection to the entirety of Dr. Withicom's testimony, and it will be, as I said, evaluated ultimately on the back end. All right. Good morning, Doctor. You may proceed.
Thank you, Your Honor.
Doctor, I don't know if that was a correct designation. All right. Go ahead.
Thank you. Good morning, Professor Withicombe. My name is Anna Pletcher, and I represent the plaintiffs in this case. Would you please introduce yourself to the court by stating your name for the court reporter?
Shannon Withicombe.
We're going to start off today talking a bit about your background, then we'll get into your assignment in this case, your analysis, and your conclusions. Does that sound okay?
Yes.
Great. Professor, where do you work?
I work at the University of New Mexico
How long have you worked there?
for about 10 years.
What is your position?
I am a tenured associate professor of history and a director of graduate studies.
What are your responsibilities as an associate professor?
I teach 2 classes a semester. I also serve on a variety of service committees, both for the department and for the university, and I conduct my own research for publication.
What are your responsibilities as director of graduate studies?
I am in charge of all of our graduate students and advising them and helping them get through the program successfully.
Have you served in other academic roles?
Prior to coming to the University of New Mexico, I had a 2-year postdoctoral fellowship at Duke University.
What is your educational background?
I got my bachelor's at Mount Holyoke College. I got my master's at the University of Wisconsin-Madison and my PhD in history at the University of Wisconsin-Madison, specializing in the history of medicine, science, and technology.
What exactly is the history of medicine, science, and technology?
This is where historians are choosing topics that have something to do with history, medicine, and science, whether it be studying Isaac Newton or looking at 19th century public health.
During your PhD, did you write a dissertation?
I did.
What was your dissertation about?
It was on the personal writings and medical understandings of miscarriage in 19th century America.
Did you publish that dissertation?
Yes, I did.
You have a particular subspecialty within the discipline of the history of medicine, science, and technology.
Yes, a lot of my teaching and most of my research is on the history of reproductive health in 19th century America.
How many years have you been studying in that subspecialty?
For about 19 years.
Does that area of specialization include the history of the regulation of abortion in the United States?
Overruled.
Yes.
Really a background matter, I believe. Go ahead.
Have you studied the history of laws affecting abortion in the United States?
Yes.
Have you studied the history of abortion laws in Idaho?
Yes.
As part of your studies of these histories of abortion laws, have you studied historical social norms and popular perceptions of abortion in the United States?
Yes.
Have you authored peer-reviewed publications relating to the history of abortion?
Yes.
Objection leading.
Overruled.
You authored publications for the general public relating to the history of abortion.
Yes.
You teach any courses at the University of Mexico that include the history of abortion?
Objection leading.
All right. This is as background as it gets. So if there are going to be more leading objections, let's at least limit them to what the meat of the testimony, which is the opinions. All right. Overruled.
Yes.
Have you given any academic lectures about the history of abortion?
Yes.
Professor, have you ever been retained as an expert in a lawsuit?
No.
Have you ever offered expert testimony in court before?
No.
Professor, would you please open your binder that you have? Oh, sorry, one moment, please, Your Honor. I have some binders to distribute. Professor, would you please open the binder that you have in front of you to the exhibit that's marked Plaintiff's Exhibit 18. It should be marked as tab 18 in your binder.
Yes.
Recognize this document?
Yes, I do.
What is it?
This is my curriculum vitae.
Does it accurately summarize your professional background?
Yes, it does.
Your Honor, plaintiffs move to admit Exhibit 18.
Any objection?
Not as long as it's only to go to her qualifications and nothing else.
Okay. Exhibit 18 is admitted for that limited purpose.
Professor, let's talk about your task in this case and how you went about approaching it. What were you asked to do in this case?
I was asked to research the historical context of the 1864 and 1887 Idaho territorial abortion laws and how they were likely practiced or operated in practice rather throughout this time and during the time in which the Idaho Constitution was written.
Did you reach conclusions based on that research?
Yes, I did.
Professor, would you please summarize the conclusions that you reached for the court?
Yes, I reached 3 conclusions. The first one was those Idaho territorial laws of 1864 and 1887 were supported and motivated by regular physicians as part of a larger national movement for regular physicians to gain a professional monopoly in the United States. My second conclusion is in 1889, when the Idaho State Constitution was ratified, it was widely understood in America that abortion was a legitimate medical practice and that physicians had full discretion over when they thought it was necessary to preserve the life or health or future fertility of a woman. And thirdly, whenever physicians were faced with choosing between the life of a pregnant woman or the life of a fetus, they consistently chose the life of a pregnant woman.
Professor, how did you go about reaching your conclusions in this case?
As I do for all of my historical research, I start with the secondary literature, so what other historians have written about the topic. I then go out and locate and find and collect a bunch of primary sources, so historical documents on this topic that I can analyze and then put together and look for patterns and trends.
From the point of these secondary sources, could you elaborate on what secondary sources you relied on?
I relied on a number of books and articles coming from university presses and articles coming from academic journals, which we usually, as historians, academic historians, we rely on because they've all been peer-reviewed. In this case, 2 of the primary works I relied on was James Moore, Abortion in America, and Leslie Reagan, When Abortion Was a Crime.
Did you rely on any other secondary sources?
Yes, as well as there was a law journal article that I looked at because it had a great appendix that contained a lot of state laws, abortion state laws.
Who was the author of that particular law journal?
Eugene Quay, I believe.
What primary sources did you analyze?
I primarily had 3 categories of primary sources that I was looking at. I collected a bunch of medical writings, so physicians writing in medical textbooks as well as medical journal articles and transactions from state to state medical society meetings. I also looked at newspapers that were printed only in Idaho that were reporting upon individual abortion cases. And finally, I looked at all of the state abortion laws that I could find throughout the 19th century, as well as a few other laws on medical regulation.
How did you locate the primary sources that you analyzed?
For the medical writings, I utilized Google Books, which is a very reliable source for primary sources. For the newspaper articles, I relied on two of the largest newspaper digitized databases, Chronicling America, which comes from the Library of Congress, and newspapers.com. For the state laws, I gathered a lot of them from that Quay article, as well as I cross-checked with the appendix in the Dobbs decision. And I think there were 3 laws from Virginia that were provided to me by the legal team.
What is Google Books?
Google Books is a project that Google started about 20 years ago with what they were attempting to do is preserve and digitize as many books as they could before the books started to deteriorate themselves. So they went around the country to, I believe they at least approached all university and college library and archives in order to completely digitize, reproduce as many books as they could that were not protected by copyright. And this is a database that all historians use because it is such a large database that includes a variety of types of writings, including quite a bit of medical writings.
Do historians typically rely on Google Books as a reliable source?
Absolutely.
How do you know that documents sourced from Google Books are reliable?
So if you look at the digitized source, it includes every piece of the book, including the front cover, the title page. Often you can see the spine of the book that has the library call number on it. And it's absolutely agreed upon among historians that this is just as good as holding the physical copy in your own hands.
If you went to a library and held that physical copy in your hand, would that to you be more reliable than looking it up on Google Books?
It would be the same reliability, and I've actually looked at some physical copies that I've also looked on Google Books and have found no difference at all.
You also mentioned that you used newspaper databases.
Mm-hmm.
What specifically were those?
Chronicling America and newspapers.com.
How reliable are those 2 databases considered to be by historians?
Just like Google Books, they are considered to be exact replicas, digitization of the entire newspapers.
Did you review the Idaho Supreme Court's opinion in Planned Parenthood Great Northwest v. State as part of your analysis in this case?
Yes, I did.
Why did you review that decision?
I reviewed it primarily to cross-check the primary sources that they were referencing to make sure that I had them and I in my list of primary sources that I was considering.
Finally, how did you use your expertise and training as a historian to reach your conclusions in this case?
So part of the training in a history PhD program is we're taught how to find as many primary sources as we can, so a variety of databases, visiting archives. We're then taught to take primary sources and analyze them. So how do we read them deeply? How do we use historical context to better understand the language or the author or the intent of the piece? And then to collect a number of primary sources and put them together and look for trends or patterns among them.
At this point, Professor, we're going to shift gears and focus on your first conclusion. Mm-hmm. Can you remind the court what that was?
Yes, that the Idaho territorial abortion laws of 1864 and 1887 were primarily motivated and supported by regular physicians as part of this national movement for regular physicians to gain a professional monopoly over healthcare in America.
Objection. That opinion calls for a legal conclusion and therefore is beyond the scope of expert testimony.
Overruled. The opinion is to the motivation behind a statute, not to the meaning of the statute. All right, you may continue.
Professor, how was abortion treated under the law before this movement began?
So before about 1820, there weren't any abortion laws on the books in various states, that primarily in court cases. It was relied upon British common law, which was primarily laws that were passed in order to protect women from poisoning, and stated that abortion was not illegal prior to quickening.
What is quickening?
Quickening is the first felt motions of the fetus by a woman, usually around the 4th or 5th month of gestation.
Were there any specific state laws that outlawed abortion throughout the entire 19th century?
Yes, so starting in the 1820s, states began to pass laws about abortion, and they only sort of increased in number as the century progressed.
Now, to provide some background, what did the landscape of medical providers look like in America before this movement began?
So in the first half of the 1800s, it was an extremely crowded medical marketplace. There were a variety of practitioners, and there was no regulation on medical education, on medical practice, on drugs as well. So really anyone could be a health practitioner. And so there was all of these different groups, such as homeopaths, eclectics, Thomsonians, as well as what they were calling regular doctors at the time. And there was lots of competition between all of those groups.
What is a Thomsonian?
A Thomsonian is someone who follows the teachings of Samuel Thompson, who was a Missouri practitioner. His general idea is there are currents that run through the body, and so illness or injury could sort of disrupt those currents, and you needed to realign the currents.
What were the regular, or I should say, who were the regular physicians?
So regular physicians were typically elite white men who really wanted to align themselves with a much older medical profession in Europe, which by that time was centuries old. And in Europe, these elite white men who had been able to go to university and gain medical degrees were really the authority over healthcare in most of Western Europe. This model was a little bit hard to replicate in the United States because there wasn't that many medical colleges. And so these physicians who wanted, again, sort of to rise to the top in terms of both professionalism and authority in the country were searching for for different kinds of strategies in order to convince the American public that they were really the best at healthcare.
So how popular were these regular physicians compared to the other types of providers that you mentioned?
They weren't that popular, mostly because of their treatments. So regular doctors were still using treatments that had been used for centuries, things that were not very comfortable to the patient. So causing vomit, causing diarrhea, bleeding, these sorts of things. Whereas the alternative practitioners typically had much more gentle methods that they were using herbal remedies for. So it felt better. So more patients went to these alternative or irregular practitioners.
How did the regulars react to the popularity of the, as you said, irregular practitioners?
They were quite outspoken in their scorn for these other practitioners.
I'll ask you to turn to exhibit number 127 in your binder.
Okay.
What is this document?
It's an excerpt from a medical journal called The Transactions of the American Association of Obstetricians and Gynecologists.
What is that publication?
It's a nationally circulated publication to other physicians, primarily those that are interested in obstetrics and gynecology.
When was the original document published?
This was published in 1897.
Where did you source this document?
This one came from Google Books.
How do you know that?
It has a stamp at the bottom of each page that says digitized by Google.
Is there a particular article within this journal that you relied on in forming your opinion?
Yes, there's an article titled The Treatment of Peripheral Infection.
What does peripheral mean?
Peripheral is a medical term that means anything to do with childbirth.
Who's the author of this particular article?
Dr. H.W. Longyear,
Where was he from?
Detroit.
Who was the audience for this article?
This would have been for other physicians.
What was the general subject on which he was writing?
In this one, he was sort of providing advice to other physicians on what were the new sanitary measures that could help prevent or treat peripheral infection.
Your Honor, I move to admit plaintiffs 127.
Any objection?
Yes, I'll object on hearsay, and typically experts can rely on stuff, but you don't typically have the sources admitted into evidence.
Response.
Your Honor, we'd admit this under the hearsay exception, 803.16, which is the ancient document exception.
All right, and so that pertains to statements in documents that are at least 30 years old and whose authenticity is established. You're welcome to present any particular argument you might have as to the application of that rule to this situation, Mr. Craig.
So that I think is more to actual factual matters, those types of things, not these types of medical journals that are relied upon by an expert historian in this case. And so I don't think that would actually apply to the types of statements that are being made in these types of medical journals.
All right, if you have anything else you want to say on the topic, go ahead.
Well, Your Honor, I certainly disagree. This is a fact that we are submitting to the court to consider as evidence in this case, and we believe that it meets the requirements of 803.16 as well as the foundational requirements of 901B8.
And it's the document as a whole, as opposed to some isolated statement or statements in it. You're
correct.
seeking admission?
We're seeking to admit the entire document for the full context.
All right. Well, I'm going to withhold ruling at this point on the item, and I'll do that to give myself an opportunity at some point here to refresh my recollection as to the scope of Rule 803.16. On its face, it would seem to be satisfied. I'm just not immediately familiar with any case law standards that suggest how the rule operates, and I suppose also, obviously, a rarely invoked rule. I can't remember if I've ever had it invoked during the 10-plus years I've been on the bench at this point.
Well, if it helps the court, I will offer some case law for the court to consider. U.S. v. Mandis, 447, F3rd, 951, Penn State 966, a Sixth Circuit case from 2006, finding that although Rule 901B8 requires a document be free of suspicion, the suspicion goes not to the content of the document, but rather to whether it is what it purports to be. So this goes to the foundational element. And hopefully that will assist the court. I think the rule is pretty straightforward.
All right, and it may be as straightforward as it looks on its face. If authenticity is established, which it has been by this testimony, the only other requirement would seem to be that the document be at least 30 years old, which this one is. So if it's that simple, the document, it would seem, comes in. Again, I suppose subject to Mr. Craig's overarching relevance objection to all of the testimony. All right, you may continue.
Your Honor, in terms of the presentation of this document, the professor has created a series of demonstratives to ease in the presentation, but if the professor has access to the screen in front of her, it may be easier just to pull out snippets to highlight from the exhibit as opposed to using the demonstratives. So I do not know if the screens are working this morning.
Should be working. Now she can't. She can look on the screen in front of her. She can't do anything with it to she can't point at it or something like that and have that be communicable to anyone else in the courtroom, including to me. But.
Right. Well, let's try it this way because I think it will be more streamlined and we can move a little quicker.
Right.
Okay. Okay. So, Your Honor, if this document has been offered for admission but not yet admitted, may I still publish portions of it?
That is perfectly fine since there's no jury to protect from it. I think is not a concern to display the document.
Thank you. Okay, Professor. Looking at Exhibit 127, we could turn to the page Bates stamped .0008, which is page 265 of the document itself. See that page?
I do, but it doesn't have any highlighting on it. Were these highlighted?
It's going to appear on your screen, the section that you had highlighted. Okay. Do you see it on your screen?
Yes, I do.
Okay, good. So, Professor, did you select an excerpt from this article to read to the court this morning?
Yes, I did.
And is the excerpt on the screen the one that you selected?
Yes.
Okay. Would you please read it?
The uneducated midwife or ignorant self-styled physician allowed by the laxness or total lack of laws on this subject in many of our states to practice without evidence of education, ability, or fitness is responsible for most of this wanton and reckless waste of human life. Medical men throughout this country should work unceasingly until by the education of the people, and especially of the lawmakers, every state in the Union shall have laws enacted that will protect its women against this kind of fiendish ignorance and incompetency. The writer speaks feelingly on this subject, as he comes from a state that is unprotected in this respect, and in consequence is the dumping ground for quacks, medical ignoramuses, and self-made midwives of many of the adjoining states whose enlightened legislators have passed laws which have resulted in purging their territory of these death-dealing parasites.
Professor, what is the significance of that excerpt you just read to your conclusions?
So this is a representative of how regular physicians were writing at the time and how much scorn they had for irregulars, for midwives, for anyone who was not a regular physician.
Professor, is there a term for the various types of non-regular physicians that was used in the 19th century to encompass all of those other types of practitioners?
Typically, regular physicians did use the word irregular to differentiate from themselves.
Who among the irregular practitioners provided reproductive health care?
That would have been under the purview of midwives.
And what kind of health care did midwives provide at the time?
Midwives were the main practitioners who attended childbirth cases. They also would have helped with things like miscarriage support or infant care, as well as providing fertility aids and fertility control measures such as contraception and abortion.
How was abortion viewed in the medical community at the time?
It was pretty much wrapped up in lots of other reproductive health care matters and wasn't necessarily seen as a distinct category, if that makes sense.
How did regulars approach the fact that midwives were so integral in providing reproductive health care?
It definitely became one of the sites that regular physicians saw that might help them gain that professional authority if they could somehow drive midwives out of business, since midwives had sort of this large business. And regular physicians really thought if they could get in on reproduction, it would get them into a family, and that family would then call on them for any health ailment.
Are you familiar with the American Medical Association?
Yes, I am.
Did the American Medical Association have any role to play in this effort to drive out these irregular physicians?
Yes. So in the late 1840s, a group of elite Northeast physicians gathered together to form the American Medical Association. The idea being if there was one unified group, that they would have more political power. They could use it for lobbying, but also they could be more in charge of medical ethics and medical pricing at the time.
What role, if any, did the AMA have in passing licensing laws?
So the AMA was very interested in pushing through state licensing laws in all states, as well as laws that regulated medical education.
Did Idaho follow that trend?
Yes, it did.
Can you explain how?
Yes. Idaho passed its first state licensing law in 1887. Territorial licensing law.
How do you know that these laws were driven by regular physicians?
So, for example, in the Idaho 1887 law, it stipulates that Only physicians who went to reputable universities and got their diplomas there were allowed to practice in the territory of Idaho, because one of the things that these regular physicians and the American Medical Association were fighting against is there were a number of for-profit medical schools that they called diploma mills, where someone could pay $30 and receive a medical degree in exchange, sometimes maybe 3 weeks of classwork, sometimes not even that.
Professor, would you please turn to Exhibit 154?
Okay.
What is this document?
This is a short book titled The Status of Medical Education in the United States.
Was this pamphlet available nationwide at the time?
Yes, absolutely. This would have been a national publication.
When was the original document published?
This one comes from 1891
And where did you source this document?
from Google Books.
Who was the author of this particular document?
The author was Dr. W. W. Watkins.
Who was Dr. Watkins?
Dr. Watkins was originally from New Hampshire, and then he went to St. Louis for his medical education and practiced there for a while before moving out west for his health. And he ended up in Idaho, where he became fairly prominent in the medical community. He started as a surgeon at the Leda County Hospital. He then was the founder and the first president of the Idaho State Medical Society, as well as the vice president of the State Board of Medical Examiners. He also was fairly politically connected as well. He was the first chairman of the state convention in 1890.
And who was the audience for this article that Dr. Watkins wrote?
This would have been to other physicians across the nation, urging them to take up this problem of medical education.
What was the general subject matter of his writing?
It was really his sort of call to arms, calling on other physicians to join this fight to compel states to pass new laws for medical regulation.
Okay. I'm going to ask you to look at the page that ends in Bates stamp 8, which is actually page 2 of the original document. Did you select an excerpt from this page to read today?
Yes, I did.
Okay, can we pull that up, please? Actually, I'm sorry, before we do that, Your Honor, of course, I would like to admit 154. My apologies.
All right. Mr. Craig, you're welcome to make an objection.
Same objections as before.
All right, understood. So I've had limited opportunity to at least call up the Sixth Circuit case that counsel cited, and it describes the issue in essentially as Ms. Pletcher indicated it does. It also refers to a particular rule on authentication of ancient documents, and that's it's speaking of the federal rules 901B8, but there is an analog, the same rule in Idaho Rule of Evidence 901B8. It speaks to what's required to authenticate the document. And then if the document is authenticated, all that's left is the document's ancient status, whether it is of a certain age. So it appears that the rule does operate essentially as simply as it appears to look on its face, Rule 803.16. So I'm going to admit the document, Rule 154. I'll also go back and admit document 157, Exhibit 157. And these admissions are subject to Mr. Craig's relevance objection to Dr. Withicom's testimony as a whole, which has not been ruled on, but they're provisionally admitted, leaving that objection aside.
Thank you, Your Honor. I believe it was Exhibit 127.
Yes. I'm looking, I apparently said 157. I meant to say 127.
Okay, maybe publish this excerpt, Your Honor?
You may.
Thank you. Okay. Professor, would you please read the excerpt from this Dr. Watkins article?
In 1848, the American Medical Association sprang into existence, its great fundamental idea being the improvement of our system of medical education. At this period, the necessity of active measures for self-protection among regular practitioners was as plainly apparent as perhaps at any time in the history of our country up to date.
And what is the significance of this passage to your opinions?
This is showing Dr. Watkins being not only interested and knowledgeable about American Medical Association, but in showing the role that the AMA played in its self-protection, as he says, among the irregulars.
Thank you. We can take that down. Was Dr. Watkins a regular physician?
Yes, he was.
How do you know that?
He referred to himself as a regular physician, and he also graduated with a medical degree.
How many regular physicians were practicing in Idaho in the late 1800s?
According to one book I found, which was a national compilation of regular physicians throughout the country, it listed 2 physicians from Idaho.
Did the national trend that you described to professionalize the practice of medicine extend to Idaho?
Yes, it did.
I ask you to turn to Plaintiff's Exhibit 122.
Okay.
What is this document?
This is an excerpt from a medical journal titled The Medical Standard.
And what is that publication?
This would have been a national circulating medical journal aimed at doctors.
When was the original published?
1893,
Where did you source this document?
from Google Books.
Is there a particular article within this journal that you relied on informing your opinions?
Yes, this is an article entitled State Items, which is a compilation of reports from various states throughout the nation.
Who authored this compilation?
Most likely each of the states would have submitted their report to the journal for publication.
Is there a particular report on Idaho?
Yes, there was.
What was the general subject matter on which the report pertains?
For the state of Idaho or the whole thing? For the state of Idaho, it is about this efforts by regular physicians to drive out irregulars.
Your Honor, I offer Plaintiffs 122.
All right. Same objections, Mr. Craig?
I'll withdraw those objections, Your Honor.
Okay, understood. It'll be admitted provisionally, subject to the relevance objection. I assume that one's not withdrawn, so.
Correct. Yes, I'll continue the objection on relevance. Thank you.
All right.
May I publish, Your Honor?
You may.
Pull up the excerpt related to Idaho, please. Professor, would you please read the excerpt related to Idaho?
The State Medical Society, in its war on quacks, has already drawn out Dr. Hansel, a practitioner on a dead man's diploma from a German medical school. Dr. Watkins of Boise is conducting the war with rare skill.
What is the significance of this excerpt to your opinions?
This is showing that Dr. Watkins in the state of Idaho is working alongside all of these other regular practitioners across the country in trying to gain a professional authority and drive out these so-called quacks.
See that down. Professor, did the efforts by the regular physicians to professionalize medicine affect reproductive health care?
Yes, they did. As I mentioned before, one of the targets of the regular physicians was midwives, and one of the strategies they took up was if they could outlaw something like abortion, then that would take away enough business from midwives that they would drive them out of business.
When did the first laws prohibiting abortion come into place?
Those laws started in the 1820s.
What, if any, trends regarding this, withdraw that. Were there additional waves, if you will, if that's the right term, of laws that were also passed throughout the 19th century?
Yes, historians typically look at, I would say, two waves. So starting from 1820 to about 1860 is the early wave. The second wave really from 1860 to 1880, where most of those laws were passed, or when most of those laws were passed.
What research did you do on the history of those laws?
I looked at and collected and compiled a full list and a timeline for all of the state laws that I could find.
I ask you to turn to Plaintiff's Exhibit 44, please.
Okay.
What is this document?
This is the timeline of state abortion laws that I compiled for my expert report.
Where did you get the information located in this timeline?
So these laws came from the appendix of that Eugene Quay Law Review article. I also, again, cross-checked with the appendix of the Dobbs decision and was provided with, I think, 3 laws from the legal team.
Who created this timeline?
I did.
Did you review it for accuracy?
Yes, I did.
Did you find it to be accurate?
Yes, I did.
How were the laws organized in this timeline?
They're organized chronologically.
And how many laws are summarized in it?
I haven't counted, but I would say at least 50, if not more.
Why did you create this timeline?
I created it because it was helpful for me to visualize the laws all together so I could look for patterns or trends between them and compare them.
Did you create it for the purpose of this case?
Yes, I did.
Your Honor, I offer Plaintiff's Exhibit 44.
Other than the overarching relevance objection, any other objection?
Yes, Your Honor, this is, one is calling for a legal conclusion, her opinions on what the laws of other states are. 2, understanding the relevance is a continued objection. The only issue in this case is Idaho's laws, not the laws of any other state, and so it's especially irrelevant to opine on what other states do. And so I'd object and ask court leave it out.
All right. You're welcome to respond, Ms. Pletcher.
Thank you, Your Honor. There are no legal conclusions in this exhibit or in any of Professor Witheycomb's testimony. Second, the fact that Idaho laws are part of a larger trend is part of Professor Witheycomb's theory in this case, and she'll be offering evidence to support that opinion. And this chart meets all the requirements under Rule 1006 for admissibility.
Okay, understood. I had assumed that the exhibit was being offered under Rule 1006. It does appear to be proper under that rule. I'll leave aside the relevance issue until after the trial. I don't consider the exhibit to amount to legal conclusions. So Exhibit 44 is admitted.
Professor, what was the reaction of the general public to the first wave of abortion laws?
As far as I was able to see in the historical documents I looked at, there was no public outcry that these laws did not seem to be written in response to sort of a public reaction about abortion. And for the most part, these laws were all passed in collections of criminal codes and weren't standalone laws.
Let's talk now about the second wave of criminalization. How did that come about?
So that was a continuation of these regular physicians who were trying to gain professional authority and professional monopoly. The second wave itself was primarily spearheaded by a physician by the name of Horatio Storer.
Who was Horatio Storer?
Horatio Storer was a sort of elite Bostonian who got his medical education in Boston and then trained more in Europe and came back to the United States and opened a private practice. And he's sort of the epitome of a regular physician at the time.
What role did Dr. Storer play in relation to the second wave of abortion laws?
So in the late 1850s, Dr. Storer began to speak up first in his local medical society and then eventually going to the AMA, calling for physicians to recognize the frequency of abortion as well as pushing them to think about or to compel their lawmakers to create new state laws against abortion.
Are you familiar with the term criminal abortion as used in the 19th century?
Yes, I am. That's actually a phrase that was coined by Storer in the late 1850s.
What does that term mean?
Criminal abortion, according to Storer, was an abortion that was carried out by someone who was not a regular physician and not for health reasons.
Why did Dr. Storer coin this term?
So prior to the 1850s and really throughout the 1800s, the word abortion did not carry any inherent criminality. Abortion was actually a word that was used fairly interchangeably with what we would now call miscarriage, with some physicians arguing that a miscarriage happened in the termination of an early pregnancy, whereas abortion was later pregnancy. Some physicians wrote that abortion was the word that physicians used, whereas miscarriage was the word that women used. But there was no sort of general agreement on one meaning of the word abortion. And again, it wasn't seen as criminal, so he had to create this new phrase.
Why did Dr. Storer create this distinction between criminal abortions and other types of abortions?
As seen in his writings, he wanted to make sure to differentiate between criminal abortion and therapeutic abortion.
What is the distinction between the two?
Through the physicians' writings at this time, they referred to therapeutic abortion as any abortion that was provided by a regular physician for medical care.
We're going to talk more about therapeutic abortions later in our discussion here today. How did Dr. Storer go about advancing his efforts to criminalize abortion?
He went to an AMA meeting and brought forth, first he was able to create a committee on criminal abortion where he was able to handpick the physicians, so he knew which physicians would be supporting him. So that committee doesn't necessarily represent the full membership of the AMA, but that committee created 3 resolutions for the AMA to vote on, which they passed.
What were those 3 resolutions?
The first resolution was a call for AMA members to publicly protest abortion. The second one was for AMA members to bring this matter to the attention of state lawmakers. And the third was that these regular physicians should use their local medical societies to put pressure on lawmakers to pass new laws.
How did regular physicians react to Dr. Storer's efforts to criminalize abortion?
We can see that many physicians were supported Horatio Storer's efforts in their sort of interests of professional gains, but certainly did not take everything he believed whole stock.
I ask you to turn to tab 148, please.
Okay.
What is this document?
This is a book published by Horatio Storer called On Criminal Abortion in America.
Was this publication available nationally?
Yes, absolutely. It was very widely read across the nation.
When was the original book published?
In 1860.
Where did you source this document?
Google Books.
Who is the audience for this book?
This is really the 2 main audiences. He's writing to other physicians to convince them of his position, as well as he's writing to lawmakers and lawyers.
Is there a particular portion of this book that you relied on in forming your opinions?
Yes.
And what was that portion?
Would you like me to find the excerpt in particular?
No, I will direct you to the page, which is generally speaking.
This is the model bill that Storer proposed for each state to vote upon and pass.
Okay. Your Honor, I offer Exhibit 148.
On the overarching relevance objection, any other objections?
No additional objections.
All right, Exhibit 148, provisionally admitted like the others, subject to the relevance objection, which will be addressed later.
And may I publish?
You may.
Going to ask that we put up just the model bill, please. Dr. Withicombe, could you please, let me ask you before you read it, what was the purpose of this model bill?
Again, STORR presented this model bill to the members of the AMA in hopes that regular physicians would take these to their local lawmakers to pass this law.
I ask you, and for reference, we're on page Bates stamp 148.0108, and that's page 99 of the original book. Okay, would you please read the model bill?
Whoever with intent to cause and procure the miscarriage of a woman shall sell, give, or administer to her, prescribe for her, or advise, or direct, or cause, or procure her to take any medicine or drug or substance whatever, or shall use or employ or advise any instrument or other means whatever with the like intent, unless the same shall have been necessary to preserve the life of such woman or of her unborn child, and shall have been so pronounced in consultation by 2 competent physicians, and any person with the like intent knowingly aiding and assisting such offender or offenders shall be deemed guilty of felony, etc., etc. And if such offense shall be committed by a physician or surgeon or person claiming to be such, or by a midwife, nurse, or druggist, such punishment may be increased at the discretion of the court.
Thank you. Now, which pieces of this bill were adopted widely by other states?
Primarily the first section that ends at life of such woman.
Were there certain provisions of this bill that were not widely adopted?
Yes, there were 3 sections I would say that I did not find at all or found extremely rarely in the list of state laws. The first one being of her unborn child. The second one being by 2 competent physicians. Most laws just mentioned a physician. And the last line about punishment can be increased if it was a physician, surgeon, or person, et cetera, et cetera.
Was Idaho one of the states that based their law primarily on STORR's model bill?
Yes, it did. It shared much of this language of that first part.
And ask us to go back to Exhibit 44, which has already been admitted. Professor, in Exhibit 44, did you list the text of Idaho's 1864 abortion law?
Yes, I did.
Okay. May we please publish Idaho's 1864 abortion law, just the text?
Go ahead.
Thank you. Professor, how is Idaho's let me ask you first, when did Idaho first implement a criminal abortion law?
In 1864.
And is this text that we're looking at the text of that 1864 ban?
Yes.
How is Idaho's 1864 ban similar to STORR's model law?
It carries most of that introductory part. It as well says that it also includes a medical exception for physicians who are trying to preserve the life of a woman.
Are there any notable differences between Idaho's 1864 law and STORR's model bill?
Yes, this 1864 Idaho law does not mention the unborn child.
Could you put Idaho's 1864 law into the broader context of the abortion laws that were being passed during this second wave?
Yes, this law shares a number of similarities with laws that were passed throughout the country in the 1860s. And actually, this law is almost exactly verbatim of the law that was passed in California in 1850 and then a variety of other Western and mountain states at the time.
What is the significance of the fact that Idaho's abortion law was almost verbatim the same as California's?
It shows that this law was basically cut and paste from other laws, and it did not arise out of some particular Idaho situation.
At some point, did Idaho amend its 1864 abortion law?
This 1864 law was recodified in 1866 and 1874 with no change to it. And then a new law was passed in 1887.
Is the text of the 1887 law also included in your Exhibit 44?
Yes, it is.
May we put up the 1864 law side by side with the 1887, please? Thank you. Professor, what are the differences between the 1864 law and the 1887 law?
The primary differences are in 1887, the word physician was removed, as well as the medical exception changed from in order to save her life to in order to preserve her life.
What is the significance of starting with the removal of the term physician? What is their significance?
So by the 1880s, and if you look through the list of the state laws that I included here, all states were getting rid of the word physician by the 1880s and 1890s based on the assumption and the sort of power that regular physicians had gotten to that point, that they were the only ones who were qualified to make that decision if a therapeutic abortion was required to save or preserve a woman's life. Also, the change from save her life to preserve her life reflects...
I'm going to ask you a separate question. What was the significance of the change between save her life and preserve her life?
So this reflects what I saw in medical practice and in medical...
All right. Well, I'm going to consider this to be an opinion on the historical evidence that sheds light on why this change was made, as opposed to a definitive interpretation of the statute for whatever that's worth. You may continue your answer.
Okay. This reflects medical practice and medical writings at the time that talked about a range of conditions and ailments that a woman might have that would indicate a therapeutic abortion.
Were those two changes that you just described part of larger national trends at the time in these abortion laws?
Just as with the 1864 law, the 1887 law shared quite a bit of language with other laws. And again, the 1887 Idaho law was almost verbatim a law that was passed in California in 1872.
Thank you. We can take down the laws. This trend that you described, where Idaho was part of a larger national trend, were you the first one to come up with that theory?
Oh, no.
How widely accepted is it among historians?
It's extremely widely accepted. It was perhaps first proposed in James Moore foundational book, Abortion in America, and has been taken up by as all of the historians of abortion that I know of.
Okay, we're going to switch gears at this point, and I'm going to ask you about a different subject. Were regular physicians ever prosecuted for abortions?
In my research in the newspaper articles printed in Idaho, I never found a case in an individual abortion case where there was a report of a physician being prosecuted for providing a therapeutic abortion.
Did you find any evidence of regular physicians being prosecuted for criminal abortions?
I would say the sort of closest I found to that were physicians who were being prosecuted after the woman had died if they provided an abortion, but not for criminal abortions.
What Idaho specific sources did you look to answer that question?
I looked through, again, a number of newspaper articles that were published in Idaho newspapers.
Okay, we're going to switch gears again. We have one more brief topic here to cover before we go on. In the research you did for this case, how did you find that doctors addressed the moral question of abortion?
So, through all of the medical writings that I looked at, including Horatio Storer's books, for the most part, what I saw was a separation of personal moral feelings about abortion and medical practice or professional practice, sort of that many physicians would talk about their moral position and then they would describe what they did actually in practice.
Do you have an example that you could provide the court on that point?
Yes, I do.
All right, would you turn to Exhibit 138, please?
Okay.
What is this document?
This is an excerpt from a medical journal titled The Atlantic Medical Weekly.
What is that publication?
This is a publication for physicians that was nationally circulated
When was the original document published?
in 1898
And where did you source this document?
from Google Books.
Is there a particular article within it that you relied on in forming your opinion?
Yes, there was.
And what article was that?
It's titled Justifiable Abortion.
Who was the author?
J. Perkins, MD,
Where was he from?
Providence, Rhode Island.
What was the audience for this article?
This would have been physicians.
What was the general subject on which Dr. Perkins was writing?
Dr. Perkins was describing particular case studies as well as his recommendations for when a therapeutic abortion was justifiable.
Your Honor, I offer Exhibit 138.
Other than the relevance objection, any?
No other objections.
All right. Exhibit 138 is provisionally admitted, subject to a later ruling on the relevance objection.
May we publish?
You may.
If we can put up an excerpt found on page 138.0005, that would be the first page of this medical journal. Professor, would you read this excerpt, please?
The moral and religious questions involved in the class of abortion which are illegal are questions for the individual to answer himself. And while I have fairly well-defined opinions of my own on this subject, I have them for my own guidance and am not trying to bring the world to my ideas. The foundation for the opinions of this nature are found outside of medical science.
What is the significance of this excerpt to your opinions?
So this is a representation of one of those physicians who is separating his own sort of moral position from medical science or his medical practice.
Thank you. We can take that down. Your Honor, this would be a good stopping point for lunch.
All right. That sounds fine to me. And just for my own information, if you'd ballpark for me the length of time approximately may be remaining on the direct examination of this witness.
Let's see. It's hard to say. Say less than an hour.
Understood. That's fine. Not holding you to it. Just curious. All right. We'll take our noon recess at this point. We'll reconvene at 1:50.
All rise.
Please be seated. All right, Ms. Pletcher, you may resume your direct examination of Dr. Withicum.
Thank you, Your Honor. Professor, we're going to pick up with your second conclusion. Could you remind the court what that was?
That in 1889, when the Idaho Constitution was ratified, it was widely understood across America that abortion, therapeutic abortion rather, was an accepted medical practice, and that physicians had complete discretion over when to perform an abortion to help preserve a woman's life, health, and her future fertility.
What do you mean when you said that physicians had complete discretion?
That all of the medical writings that I surveyed, physicians were discussing in particular case reports, case studies, or just in general, that in ways that indicated that they were not talking to anyone else when they were making these decisions. They were pretty much making them on their own in a case-by-case basis.
Despite the fact that abortion laws were in place, as we discussed earlier today, what evidence did you find that regular physicians continued to provide abortion care?
There's a range of evidence in medical writings of physicians, again, reporting particular case reports where they were using abortion as a therapeutic, as well as larger discussions at medical society meetings and other discussions between doctors where they were proposing what the indications were for providing abortion.
You mentioned the term therapeutic. What did you mean by that?
A therapeutic abortion was essentially an abortion that was provided by a regular physician who deemed it necessary.
Are there other terms used to refer to the same type of abortion?
Yes, justifiable, obstetric, and therapeutic were pretty much used interchangeably in terms of abortion at the time.
I'm going to ask you to turn to Exhibit 117.
Okay.
What is this document?
This is an excerpt from a medical journal by the title of The Medical Standard.
And what was that publication?
This was a medical journal for physicians, and it was published nationally.
When was this edition originally published?
1899.
Where did you source this document?
From Google Books.
Is there a particular article in this journal that you relied on in forming your opinions?
Yes, it's titled Justifiable Abortion.
Who wrote that article?
The original report was by Dr. W.D. Haggard, Jr., that was published in Southern Practitioner, and this is basically a summary of that article.
How common was it to have a journal republish an article that had been published in a different state?
It was extremely common. I mean, most physicians, when they published in a medical journal, understood that they were entering into a national conversation, so they could be reprinted in other journals around the country, really.
Who was the audience for this article?
This would have been for physicians.
What was the general subject upon which Dr. Haggard was writing?
He was providing a list of indications for when a therapeutic abortion was deemed necessary.
How do I offer Exhibit 117?
Other than relevance, Mr. Craig, any objections?
No, Your Honor.
All right, Exhibit 117, is admitted provisionally admitted subject to the relevance objection, which will be determined post-trial.
May I publish?
You may.
Okay. I'd like to put up page 0002 of the exhibit, which is also page 59 of the original article. Professor, is this the article from Dr. Haggard that you just described?
Yes, it is.
And would you read the first paragraph, please?
Dr. W.D. Haggard, Jr. from Southern Practitioner, discussing abortions in general, defines the conditions which, in his view, justify the induction of abortion.
Would you read those conditions, please?
Uncontrollable vomiting, renal disease, pulmonary disease, cardiac trouble, chorea, pelvic deformity, cancer of the uterus, and hemorrhaging.
Okay.
Let's start with that first one, uncontrollable vomiting. What does that mean?
It was usually understood when a pregnant woman was vomiting so much, she was actually losing weight rather than gaining weight throughout her pregnancy.
What does renal disease mean?
That would be kidney problems.
What is pulmonary disease?
That would be lung problems or issues.
What is cardiac trouble?
Heart disease or heart ailments.
What is chorea?
Chorea is a mental health condition that was understood at the time as involuntary movements of the body or of muscles, and most physicians at the time wrote about how chorea was sort of an early indication that if it was untreated, it would progress into sort of full-blown insanity.
What is a pelvic deformity?
Usually this was some malformation of the pelvis that meant that it might be difficult for the fetus to be passed through naturally through the birth canal.
And what does cancer of the uterus mean?
This would mean cancer that was found in the uterus or potentially in other parts of the reproductive organs.
Finally, uncontrollable hemorrhage. What does that mean?
That is just bleeding to a degree that physicians are worried that she might have placenta previa, which was a very serious condition.
What is the significance of this excerpt that we just discussed to your conclusions in this case?
So this provides a representation of what I found over and over again, which were these lists of indications when physicians deemed an abortion necessary. And for a lot of these, they would have been understood as protecting a woman's health and not necessarily as something that was going to instantly kill her or immediately kill her.
Thank you. Professor, are there other examples that you can provide of common conditions that justified abortions at that time?
One of the most frequently, and it was actually identified by Horatio Storr as probably the most frequent indication for a therapeutic abortion, was a craniotomy.
What is a craniotomy?
A craniotomy is when a woman got to full term and was laboring, and it seemed to take a long time, and physicians determined that the fetus would not be able to pass through naturally and that it put both the woman and the fetus in danger. They would carry out an operation where they would take metal instruments and they would crush up the fetus, including the skull, and extract it in pieces.
So how is it that practitioners justified abortion for craniotomy?
Physicians did not want to perform craniotomies, and it also placed the woman at danger as well. And so if a physician determined that a fetus would not be able to pass naturally through the birth canal, they recommended an abortion as a safer procedure for the woman than craniotomy.
Was risk of future fertility ever a justification for abortion?
Yes, generally speaking, physicians understood that most pregnancy complications carried a danger to a woman's future fertility. So using therapeutic abortion as a way to address pregnancy complications meant it could also protect fertility.
Was mental health ever a justification for abortion?
Yes, it was. As we saw on the previous slide, chorea was often mentioned. Another condition that was often mentioned as an indication for therapeutic abortion was peripheral insanity.
What is peripheral insanity?
Peripheral insanity is a mental health condition, again, related to childbirth. So it would have manifested itself after childbirth in a way that a woman was not able to care for her newborn or the rest of her family. So if that had happened in the past, physicians might perform a therapeutic abortion with the understanding that she likely would develop it again.
Professor, could you turn to Exhibit 114 in your binder, please?
Okay.
What is this document?
This is a book by the title of Pregnancy, Labor, and the Peripheral State.
What was that publication about?
This would have been a teaching textbook that would be used in medical schools.
Would it have been available nationwide?
Yes, absolutely.
When was the original book published?
1895.
Who is the author?
Egbert H. Grandin, MD, and George W. Jarman, MD.
Where did you source this book?
From Google Books.
Did you rely on portions of this book to form your opinions today?
Yes, I did.
Your Honor, I move for Plaintiffs' Exhibit 114.
Other than relevance, any objections?
No, Your Honor.
All right, Exhibit 114 is provisionally admitted, subject to the relevance objection to be determined after trial.
May I publish?
You may.
Thank you. Okay. I'd like to put up page 6, 114.0006, which is page 64 in the original document, please. Professor, could you please read the excerpt from this book that is on the screen?
Melancholia to a greater or less degree is not infrequent. Much may be done by firm conduct on the part of the physician to lessen the anxious fears of the woman, and yet, in a proportion of the cases, the melancholia deepens, and it will become a question of the induction of abortion or of premature labor in order to prevent the development of insanity of possibly a permanent type. In the event of the melancholia deepening, then after consultation, sorry, the slide is interrupted by it may seem advisable to empty the uterus.
What is the significance of this excerpt to your conclusions in this case?
So this is a representation that shows that mental illness was used as an indication for therapeutic abortion, and again, that in cases where a woman's health was being threatened and not necessarily her life.
Can you explain what melancholia is?
It was usually used for what we would now diagnose as depression.
Professor, was uncontrollable vomiting a condition that justified abortion?
Yes, as we saw in the first list, it showed up, but also it showed up in many, many other lists that I saw of physicians providing indications.
I'm going to ask you to turn to plaintiffs 146. That's 146.
Okay.
What is this document?
This is the transactions of the Washington Obstetrical and Gynecological Society. So this would basically be the reprints of speeches given before this medical society.
What was that medical society?
The Washington Obstetrical and Gynecological Society.
At Washington State?
Yes, it is.
Was this a publication that was available nationally?
Yes, it definitely would have been.
Was this a publication physicians in Idaho, for example, would have had access to?
Yes, there was a lot of interactions between the medical societies of Idaho, Oregon, and Washington.
When was the original document published?
1882.
Where did you source this document?
From Google Books?
Is there a particular article that you relied on?
Yes.
What was that?
Excessive vomiting in pregnancy.
Who wrote that article?
Dr. T.C. Smith.
Who was the audience?
This was other physicians. Well, this was a speech given at the Washington's Obstetrical and Gynecological Society, so it would have been other members of that society and other physicians who were attending that meeting.
What was the general subject on matter of which he was writing about?
This was a case study that he was publishing in which he used excessive vomiting in pregnancy as an indication for therapeutic abortion.
Your Honor, I offer plaintiffs 146.
Other than relevance, any objection?
No, Your Honor, thank you.
All right, Exhibit 146 is provisionally admitted, subject to the relevance objection.
May we publish?
May.
I'm going to ask you to put up the slide ending Bates number 9, and that's the original page 39 from the original document. Before we read what's up on the screen, Professor, could you explain what the author of this article was discussing that you wanted to highlight for the court?
Sure. This was a case in which he had a patient who had excessive vomiting throughout pregnancy. He tried a variety of treatments, hoping that they would work, and they didn't. And he eventually determined that the only solution to the problem was a therapeutic abortion.
And can you now please read the excerpt?
I had exhausted all my remedies. The patient had nearly exhausted her vitality. It was hoped that as pregnancy advanced, the vomiting would subside, and consequently my aim had been to sustain the patient until nature should come to her aid. But in this we were disappointed, and I told the family nothing could be done but induce abortion. In reviewing the history of this case, I can see but a single point in which there is reason to believe that an error was committed, and that is the delay in inducing abortion.
Professor, how does this excerpt support the conclusions that you reached?
Again, is showing some of the indication or one of the indications for physicians to perform a therapeutic abortion. And in this case, I think it's good to show that the physician, after the case, determined that he should have done it a lot earlier. So again, not because her life was in any immediate danger.
Thank you. We can take this one down. Professor, I'd like you to turn to Exhibit 157.
Okay.
Okay, and what is this document?
This is the Texas Medical Journal.
What is the Texas Medical Journal?
This is a journal intended for physicians that would have been circulated nationally.
And when was this document published?
1900.
Is there a particular article in it that you relied on for your conclusions?
Yes, abortion, spontaneous and induced.
Who's the author?
J.A. Winfrey, MD.
Who's the audience for this article?
Other physicians.
What was the general subject matter on which he was writing?
He was talking both about treatment of miscarriage as well as when physicians should perform a therapeutic abortion.
Your Honor, I offer Exhibit 157.
Other than relevance, any objection? 157 is provisionally admitted, subject to the relevance objection.
May I publish?
Go ahead.
Before I do that, Professor, could you explain specifically what Dr. Winfrey was discussing in this article?
He was discussing a case study he had where after he had seen a patient of another physician who died after 3 months of vomiting during pregnancy, he was approached by a woman who had been vomiting for 3 weeks early in her pregnancy, and he determined that he should perform an abortion right away.
Please read the excerpt on the screen.
Question: when must we operate in such cases? When medicines fail to do good and before the patient approaches the danger line from exhaustion.
What is the significance of that excerpt to your opinions?
So this is again showing a physician using the indication of excessive vomiting for therapeutic abortion, but his recommendation is not even to get close to potential death, but to do it much earlier.
Professor, who determined whether an abortion was justifiable or therapeutic?
A regular physician.
And how do you know that?
In all of these case studies, as well as in teaching textbooks and reports from medical societies, physicians never mentioned any other person that was involved in their decision-making process.
I ask you to turn to Exhibit 155.
Okay.
What is this document?
This is an excerpt from the medical journal Medical Council.
And what is that medical journal?
It's a nationally circulating journal for physicians.
Is there a particular article within this excerpt that you relied on in forming your opinions?
Yes, it's titled Abortion, Its Treatment.
And who wrote the article?
Dr. William F. Waugh.
Where was he from?
Illinois.
Who was the audience for this article?
Other physicians.
What was the general nature of the article?
He was providing his advice on what indications there were for physicians to perform abortion, as well as his advice on treatment of miscarriage.
Your Honor, I offer Exhibit 155.
Other than relevance, any objection? 155 is provisionally admitted, subject to the relevance objection. You may publish it.
Okay, I'd like to publish page ending in Bates stamp number 4 and page 55 in the original document. Thank you. Professor, could you please read the excerpt from this article?
If the doctor is willing to plainly state the case with the concurrence of counsel and publish openly his reason for advising abortion, he may rest easy. If he is unwilling to face the world with such a statement, he is doing a wrong act.
What is the significance of this excerpt to your opinion?
So this is a physician who is saying that as long as an individual regular physician feels that it's right to provide abortion, then it is right.
Thank you. We can take,
I think that misstates what it says.
the question was, what is the significance to her opinion of this particular excerpt?
All right, so I suppose we've heard what her opinion is. I mean, I think it might be a slight restatement to say that as long as the physician is willing to let the world scrutinize his reasons for conducting the abortion, then it's all out in the open and is something he can feel comfortable with. But if he wouldn't be comfortable with the world knowing why he did it, then maybe it's not on the up and up. I think that's the kind of the equivalent of what Dr. Whitcomb has said. In any event, you may proceed.
Thank you. We can take this one down. Professor, will you turn to Exhibit 143, please?
Okay.
What is this exhibit?
This is an excerpt from the medical journal Northwest Medicine.
What was that publication?
This was a publication that was for the medical societies of Washington, Idaho, and Oregon that was nationally circulated.
And when was this volume originally published?
1907.
Is there a particular article that you relied on within this journal?
Yes, the moral qualifications of the physician.
Who wrote that article?
Dr. J.H. Lyons, MD.
Who was Dr. Lyons?
Dr. Lyons was the president of the Washington State Medical Association, and this was his outgoing address.
What's the significance of the fact that this was his outgoing address?
I think many people who are in a role such as president and they're outgoing their office, they tend not to consider the same sorts of public reactions to what they're saying.
What do you mean by that?
It's sort of, I would say it's less of a consideration. It's maybe less important to them about the political ramifications or results of their speech.
Who was the audience for this speech?
This would have been other physicians, primarily ones in the Pacific Northwest, but also nationally.
Your Honor, I offer plaintiffs 143.
Other than relevance, any objection? Exhibit 143 is admitted provisionally subject to the relevance objection. You may publish relevant excerpts.
I'm going to publish an excerpt that is on page ending in Bates stamp 4 and 291 in the original document. Okay. Professor Whitcomb, could you read the excerpt, please?
We know full well that in the matter of obstinate or uncontrollable vomiting of pregnancy, or in the various pelvic deformities which interfere with the course of normal labor, the attending physician formulates a plan of treatment or course of action, and is left to him to determine whether the living but unborn child shall be sacrificed or saved. If he chooses sacrifice the child, the law will hold him guiltless.
What's the significance of this excerpt to your opinions?
It shows a physician who is recognizing that regular physicians who carry out therapeutic abortions are protected by the law.
Is there another article in this same journal that you would like to discuss today?
Yes, it is the very next article.
Is that on page 009? It's the Bates stamp and page 296 of the original?
Yes, an article titled Criminal Abortion.
Who's the author?
Montgomery Russell, MD.
Where was he from?
Seattle, Washington.
What's the general subject matter on which he was writing?
Montgomery Russell was writing about criminal abortion, so he was very interested in abortions that were provided by whoever was not a regular physician, who he frequently called professional abortionist, and how he thought that was very wrong.
Who was his audience for this article?
Other physicians?
Okay. Let's turn to an excerpt in this article. The excerpt is on page ending Bates stamp 16, and that's page 303 in the original document. Pull that up, please. Thank you. Professor, could you read the excerpt, please?
The law leaves it entirely to the judgment of the medical profession to determine when it is necessary and warrantable to produce abortion.
And how is that excerpt significant to your conclusions?
This is a representation of physicians arguing that they had discretion over when to perform an abortion and that they were protected by the law.
Thank you. We can take this one down. Professor, what evidence do you have that physicians in Idaho had discretion to provide justified abortions?
Dr. W.W. Watkins wrote upon this as well.
Is this the same Dr. Watkins that you described earlier in today's testimony?
Yes.
Okay. Let's look at Exhibit 153.
Okay.
What is this document?
This is a medical journal titled Medical Sentinel.
And what was that publication?
This publication was the official publication of the Idaho Medical Society as well as Washington and Oregon before they moved to the previous journal we looked at, Northwest Medicine.
When was this article originally published?
1901.
Is there a particular article that you relied on in forming your opinions?
Yes, it's titled Abortion and Infanticide from a Medico-Legal Standpoint.
Who was the author?
W.W. Watkins.
Who was the audience that Dr. Watkins was writing for?
This is for other physicians.
What was the purpose of his article?
He was providing instructions for physicians who might be called on to serve as expert witnesses in cases of abortion or infanticide.
Your Honor, I offer plaintiffs 153.
Other than relevance, any objections? No, Your Honor. Exhibit 153 is provisionally admitted, subject to the relevance objection. You may publish excerpts you consider relevant.
Thank you. I'd like to turn to page 1 with ending Bates stamp 7 and page 110 in the original article, please. If we could pull up the excerpt. Thank you. Professor, would you please read this excerpt?
The law does not formally recognize the right of the physician to provoke labor no matter what the environments may be, yet the court morally justifies it. When it can be proven that the life of either the mother or child would be put in jeopardy, should nature be allowed to run its course. We are at times as much justified in inducing abortion as in extirpating a cancerous breast or amputating a diseased or injured limb.
Professor, what's the significance of this excerpt to your conclusions?
I believe this is a representation of physicians who are discussing indications of abortion that, again, are not for impending peril or death of a woman, especially by his comparison to, say, amputating a limb.
Thank you. We can take this one down. Professor, was abortion taught in medical schools where regular physicians trained?
Yes, it was.
I'd like you to turn to Exhibit 137.
Okay.
What is this document?
The Science and Art of Obstetrics. It's a medical textbook. Sorry, and it's an excerpt from it.
And was that medical textbook available nationally?
Yes, this was definitely one of the popular medical textbooks that were used throughout the country.
When was the original published?
1895.
Where did you source this textbook from?
From Google Books.
Who wrote the textbook?
Theophilus Parvin, MD.
Who was the audience for it?
This would have been used in medical schools, so medical students.
Were there certain parts of this book that you relied on?
Yes, I relied on Chapter 6, which is Diseases of the Ovum, Death of the Fetus, Abortion, and Premature Labor.
Your Honor, plaintiffs move Exhibit 137, which is just this chapter of this book.
All right. Other than relevance, any objection?
No, Your Honor.
137 is admitted provisionally, subject to the relevance objection. You may publish the excerpts, Ms. Pletcher, that you consider relevant.
Thank you. I'd like to turn to Bates stamp 24 of this document, which is page 465 of the original. Pull up that excerpt. Thank you. Professor, could you read this excerpt, please?
Abortion has been divided into spontaneous or natural and accidental, By the former, a miscarriage occurring from obscure or latent causes is designated, and by the latter one that has an obvious cause. But this distinction is in many cases impossible to be made. A better division is into spontaneous and artificial. The latter class is divided into therapeutic and criminal. Therapeutic abortion is that which is done by the physician in the interest of the mother's life or health, while criminal abortion is without this or any other justification.
Professor, what's the relevance, or what's the significance of this excerpt to your opinions?
So this is showing that in medical schools, students are learning about therapeutic abortion, and they're learning that they should be doing it in the interest of a mother's life or health as a legitimate medical practice.
Thank you. You can take this down. Professor, I had one more question I meant to ask you about Dr. Watkins. Was Dr. Watkins a member of the American Medical Association?
Yes, he was. He wrote into the Journal of the American Medical Association. At one point, he wrote in to inform them that they had left the Idaho State Medical Society off of their list, and he informed them that he had helped to organize this medical society that was, and he, as I believe his words were, strictly in line with the American Medical Association.
Okay. At this point, we're going to move on to your final conclusion, Professor. Could you please remind the court what was your third conclusion in this case?
So when physicians were faced with the choice between saving the life of the pregnant woman or saving the life of the fetus, they consistently chose saving the life of the pregnant woman.
What evidence did you find to support that conclusion?
Again, through the medical writings, there were physicians who were reporting on case studies in which they chose the life of the woman involved, as well as general discussions on making this choice.
Let's turn to exhibit number 104, please.
Okay.
What is this document?
This is an excerpt from a medical journal by the title of the International Journal of Surgery.
What was that journal?
This was a nationally circulating journal that would have been of interest to physicians who were particularly interested in surgery.
When was the original published?
1895.
Where did you source this document?
Google Books.
Is there a particular article within this journal that you relied on?
Yes, it's titled A Recent Craniotomy.
Who wrote that article?
Dr. Wilmer Brinton,
Where was he from?
Baltimore.
What was the audience for this article?
This was to other physicians.
What was the general subject on which Dr. Brinton was writing?
This was a case study in which Brinton determined that a craniotomy was necessary.
Your Honor, I offer plaintiffs 104.
Any objection other than relevance?
No, Your Honor.
Exhibit 104 is provisionally admitted subject to the relevance objection. Ms. Pletcher, you may publish the portions you consider relevant.
Thank you. So let's publish Bates stamp ending in number 5, which is page 108 of the original document. Professor, would you please read this excerpt?
Still, as far as I am concerned, individually on the question of craniotomy, I do not hesitate to put myself on the side with those who will agree with Dr. Lusk when he said, if the life of the mother is at stake and the sacrifice of the child is necessary to her preservation, few at the present day would dispute the superiority of the mother's claim to existence.
What's the significance of that excerpt to your opinions?
So this is a representation of physicians making that choice and choosing for the mother. I'll also point out that Dr. Lusk was an extremely prominent obstetrician in New York.
We can take that one down. I'm going to ask you to turn to exhibit 111.
Okay.
What is this document?
This is an excerpt from a medical journal titled Medical Record.
What is that publication?
It's a nationally circulating medical journal.
When was the original published?
1890.
And where did you source this document?
From Google Books.
Is there a particular article you relied on in forming your opinion?
Yes, it's an article titled "The Surgeon's Duty in Extrauterine Pregnancy."
Who wrote that article?
Sorry, that's at the end. Dr. R. Ellis,
Where was Dr. R. Ellis from?
Danbury, Connecticut.
Who is the audience for this piece?
Other physicians.
What was the general subject matter on which Dr. Ellis was writing?
He was providing advice to what a doctor should do in the case of ectopic pregnancy.
Your Honor, I offer plaintiffs 111.
Other than relevance, any objection?
Your Honor.
All right, Exhibit 111 is provisionally admitted, subject to the relevance objection. Ms. Pletcher, you may publish the excerpts you consider relevant.
You. So, going to publish the Bates number ending in the number 3, and that is the original, page 718. Professor, would you please read the excerpt?
From the standpoint of the theologian, it has been decided that cesarean section should always be preferred to destruction of a living child, but cesarean section is not always done. The mother's right to live forbids it. Should we leave the question of the treatment of extrauterine pregnancy to the theologian, he would necessarily advocate the expectant plan. He believes it morally wrong to destroy even the germ of life, no matter where it may be. But we do not. Physicians believe that mature life has the right to live, if necessary, at the expense of the beginning of life.
Thank you. We can take that one down. And Professor, please turn to Exhibit 112.
Okay.
What is this?
It's an excerpt from a journal titled the Philadelphia Monthly Medical Journal.
What was that journal?
This was a medical journal that was nationally circulating.
What was the date of original publication?
1899.
Where did you source this document from?
Google Books.
Is there a particular article that you relied on?
Yes.
Who wrote that article?
Dr. Clarence E. Ide,
Where was he from?
Buffalo, New York.
And who was the audience for the article?
This was other physicians, and I don't think I said yet the title, which is When is Justifiable Abortion Indicated?
What was the general subject on which Dr. Ide was writing?
So Ide was presenting his advice to other physicians on what the indications were for therapeutic abortion.
Your Honor, I offer plaintiffs 112.
Other than relevance, any objection? Exhibit 112 is provisionally admitted, subject to the relevance objection. Ms. Pletcher, you may publish the results you consider, or the excerpts you consider relevant.
Thank you. Turning to the page that ends in the Bates number 7, and that is 577 in the original document. Professor, would you please read the excerpts here?
A woman's duty to her husband and children, which are already in the world, is greater than to those which are simply prospective, provided the bringing forth of the latter is certain or even very likely to kill her. If a doctor informs a woman with reason that another labor will kill her, if her husband will not cooperate, and unless she is willing to sacrifice her life for the sake of giving her husband a motherless child, that very act of the doctor makes it his duty to relieve her of her pregnancy after consultation.
Professor, what's the significance of this excerpt to your opinions?
This is showing that physicians are not only making the choice between a woman, or choose for the woman's life rather than the fetus life, but it's also showing that physicians were making this decision not only based on purely medical factors.
Thank you. We can take that down. We have a moment, Your Honor.
That's fine.
Thank you, Your Honor. We pass witness.
All right. Thank you, Ms. Pletcher. Cross-examination, Mr. Craig.
Thank you, Your Honor. Good afternoon, Dr. Whitcomb.
Good afternoon.
You're right on page 64 of your report, quote, "When lawmakers drafted and ratified the Idaho Constitution 2 years later, they They sought no further restrictions on abortion, continuing the tradition of allowing physicians complete and unfettered discretion over their medical practices, including providing abortions. Is that correct?
Yes.
You wrote in paragraph 20 of your report, quote, "At the time the Idaho Constitution was written and ratified in 1889, it was widely understood within American society, including Idaho, that regular physicians had complete discretion to provide obstetric, justified, or therapeutic abortion care when they deemed necessary to preserve a pregnant patient's life or health, including the patient's future fertility. Criminal abortions, however, were defined as abortions provided by other medical practitioners or for non-therapeutic reasons." Is that correct?
Yes.
How do you define an obstetric abortion?
An obstetric abortion was understood at the time as a abortion that was carried out by a regular physician when he deemed it necessary.
And how do you define a justified abortion?
It was used pretty much interchangeably by physicians at the time, so it would have been an abortion that was provided by a regular physician when he deemed it necessary.
And how do you define a therapeutic abortion?
Same thing, it would have been an abortion provided by a regular physician when he deemed it necessary.
You compared Idaho's laws to other laws across the country, specifically California's laws. Are you aware of how many of Idaho's laws were copied from California early on in Idaho State?
I'm not aware of that. That was beyond my purview.
So you only looked at that one law?
I was asked to look at abortion laws, so those are the ones I looked at.
Are you aware that many, if not most, of Idaho's laws at statehood were copied from California?
Again, I was only asked to look at the abortion laws.
All right, let's explore those two quotes that I read from your report. Can you turn to Exhibit 143, please? And Exhibit 143, you quoted earlier, was an article from Dr. Montgomery Russell. Is that correct?
Yes.
And in your report, you quote him, Dr. Russell, to support your opinion that, quote, "The law leaves it entirely to the judgment of medical profession to determine when it is necessary and warrantable to produce abortion," correct?
Yes.
Can you please turn to page 303?
Yes.
Dr. Russell wrote that a therapeutic abortion is only allowed when justified to save the life of the mother, correct?
And where is that?
Could you look at the bottom of page 303? I'll just have you read it. So there is a halfway through the last paragraph, it starts with, "There is immorality." Do you see that?
There is no immorality?
Sorry, there is no immorality, yes.
In just that sentence?
Yes, please.
There is no immorality in producing an abortion therapeutically if it gives a chance of saving the life of the mother, when if it were not done, it would be almost certain that both mother and child would perish.
So in this part, he does not write about an abortion justified to preserve the health of the mother, does he?
I think that the phrase "giving a chance of saving the life" is also about health.
So you think that preserving the life or saving the life is beyond and goes to just health, not just saving the life?
I believe that given the evidence that or the sources that I looked at where physicians were actually practicing abortion, I think it clearly shows that a woman's health was also a consideration.
Can you turn page 297?
Okay.
Okay, bottom paragraph. About 6 lines down, there's a sentence that starts, "But we as physicians."
Okay.
Can you read that sentence, please?
But we as physicians know that the individual has life and therefore the rights of a separate being from the moment of conception, and that the earliest part of that life is, if anything, fuller of developmental incidences and changes than any of the latter periods of existence.
Can you go back to page 303, please? Second full paragraph. Starts off, the crime being perpetrated secretly. You see that?
Yes.
Can you please read that sentence?
The crime being perpetrated secretly by parties whose mutual interest it is to cover up their guilt. An arrest is seldom made unless the woman dies, while juries, reasoning from some obscure pathologic process, seldom convict the abortionist.
That was psychologic as opposed to pathologic?
Oh, I'm sorry, psychologic.
And the crime that he's referring to here is crime of abortion, correct?
Criminal abortion, yes.
Turn to the next page, 304, please. Can you read the first sentence of the very last paragraph? Starts off with criminal abortion.
Criminal abortion is undoubtedly an abhorrent and villainous crime against the infant, the mother, the family circle, society, and nature.
And go ahead and read the next sentence.
Except therapeutically, the destruction of the fetus is absolutely indefensible.
Immediately after Dr. Russell's article in the same journal, there was an article by Dr. C.N. Suttner. Is that correct?
I believe so, but I don't have that document, so I can't say for sure.
Okay, I do have that document, if I may have it handed to the witness. You've already testified this medical journal is one that you rely on, and experts in your field rely on informing your opinions, correct?
Yes.
And could you please turn to page 305?
Okay.
And what is the title of this article?
A plea for the protection of the unborn.
Who is the author?
C.N. Suttner,
Where does it say Dr. Suttner is from?
Walla Walla, Washington.
And you don't cite this article in your report anywhere, is that correct?
I don't believe I did.
Could you please read the highlighted portion on page 305 going on to page 306, please, at the bottom there?
Intentional abortions are of two classes, criminal when performed for social reasons, and obstetric when performed by the physician to save the life of the mother. We all consider it, gross blunder against the science of obstetrics to sacrifice the life of the infant, unless it be the only means to save the life of the mother.
Can you turn to Exhibit 146, please? And this is one that you testified about earlier on direct, correct?
Yes.
And this was, I think, in the context of uncontrollable vomiting, is that correct?
Yes.
And there was a case report of having to do an abortion on a woman who had uncontrollable vomiting, is that correct?
Yes, it is.
And at the top of page 39, he actually referred to her situation so bad as to, quote, justify the appellation living skeleton when applied to the patient, correct?
Yes.
Can you turn to Exhibit 117, please? And this one you were quoting an article by Dr. W.D. Haggard, correct?
Yes.
And where does Dr. W.D. Haggard, where did he practice?
It does not say here.
Reason to believe he practiced in Idaho?
No, I have no reason to believe he practiced in Idaho.
Can you please turn to Exhibit 127? And you talked about this article on direct by Dr. Longyear, correct?
Yes.
And where did Dr. Longyear practice?
Detroit?
In your report, you also cite Alfred Swain Taylor, a manual of medical jurisprudence. Is that correct?
I believe so, but I'd have to double check in my report. I haven't memorized the titles.
Do you have a copy of your report in front of you?
Yes, I believe so.
Look at paragraph 77 of your report.
Yes, I see that reference.
And you see your reference to Dr. Taylor?
Yes, I do.
And you refer to this article as one of the most widely read texts on medical jurisprudence throughout the latter half of the 19th century, correct?
Yes.
And Dr. Taylor's article or book is the only citation that you have for this paragraph, correct?
Yes.
In that paragraph, you write, quote, "For many physicians, the best justification for an obstetric abortion was simply the fact that a regular physician deemed it was necessary," correct?
Yes.
And you wrote in paragraph 77, quote, "Taylor added that an induction of premature labor could be carried out safely only by someone with a most accurate knowledge of the anatomy of the ovum and the maternal structure, and could be successful only in the hands of persons who have complete anatomical knowledge of the parts," correct?
Correct.
I want to hand you a copy of his article. This is Plaintiff's Exhibit 151, Your Honor. I don't see it in the small binder that they provided, but it was in one of their other binders.
All right, understood.
Can you please turn to page 538?
Yes.
And so your quote in terms of an induction of premature labor can be carried out only by someone with most accurate knowledge of the anatomy of the ovum. That's under the heading mechanical means. So mechanical means of providing an abortion, correct?
I'd have to find the quote in here. Do you know where the quote is exactly?
Your quote is on page 539. It's highlighted.
Oh, thank you. Yes, it looks like it's under a subheading, mechanical means.
Okay, could you please turn to page 556?
Okay.
Please read the top highlighted section. It starts off with, "But it is impossible to admit."
But it is impossible to admit that there can be any immorality in performing an operation to give a chance of saving the life of a woman when by neglecting to perform it, it's almost certain that both herself and the child will perish.
You read the next highlighted section there, please. It starts off with the necessity.
The necessity for the practice ought to be apparent. Thus, for instance, it should be shown that delivery was not likely to take place naturally without seriously endangering the life of a woman.
And towards the bottom, there's another highlighted section there, and in that he writes that before a physician induces premature labor, he should consult with other physicians, and, quote, "Before it is performed, he should feel assured that natural delivery cannot take place without greater risk to the life of the woman than the operation would itself create," correct?
Yes.
Can you turn to Exhibit 153, please? And this is,
Excuse me, Your Honor, before we move to the next exhibit, was this Taylor article marked as an exhibit?
Exhibit 151, that's the one he had inquired about previously?
This article on medical jurisprudence by Dr. Taylor that we were just discussing, I don't believe it's been marked for reference yet.
I believe it was previously marked as Exhibit 151 from plaintiff's exhibit. I don't think they included the whole article, but I just had to read portions of it.
Yes, so Exhibit 151 in the exhibit binders the plaintiffs presented contained, I believe, the first exhibit Mr. Craig asked the witness to read, but not the second. The second excerpt. I said the first. Let me restate that. The first excerpt Mr. Craig asked the witness to read was within Exhibit 151 as presented by the defendants in their exhibit binders. The second wasn't. It was on a further page. So I don't have a copy of the entire document, and whether that's, I guess, consequential to anyone, I don't know. The excerpt has been read into the record one way or the other.
Thank you. It just hadn't been marked, but now I understand what it is, so we can continue. Thank you.
Okay. Now you were about to inquire as to Exhibit 153, Mr. Craig?
Yes, Your Honor. So, Dr. Whitcomb, you write about Dr. Watkins in paragraph 78 of your report, correct?
Yes.
In your report, you write this article as, quote, his affirmation of the clear separation between abortion and infanticide signals that he did not believe that the existence of a fetus was the same as the existence of an infant, correct?
Yes.
In the first paragraph on page 108, he defines three terms: abortion, infanticide, and feticide, correct?
In the first paragraph, you said?
Correct.
I see a definition of feticide and infanticide. What was the other one you mentioned?
And abortion. That's in the first sentence.
Yes.
He defines abortion, that paragraph, as, quote, the premature casting forth or expulsion from the womb of the product of conception, correct?
Yes.
And he defines a criminal abortion as, quote, an unlawful or criminal interference with the natural course of gestation so as to cause the expulsion of the contents of the womb, conception being established, correct?
Yes.
He defined feticide as, quote, a destruction of the life of the fetus before it is born and before it has a separate existence from its mother, correct?
Yes.
And he defined infanticide as, quote, the early destruction of a newly born child which has a separate existence from its mother, correct?
Yes.
Can you please read the highlighted section on the, sorry, you're looking, I have my own separate copy. Second column on page 108. 7 lines from the top of the second column, 7 lines down, it starts off, but modern law has traced. Can you please read from there to the end of the paragraph?
But modern law has traced the human embryo as a distinct being dating from conception, and legally as well as physiologically, life is postulated from the first moment of impregnation.
And much of this article, if you read through the whole thing, discusses how to obtain evidence to show whether an abortion has taken place or whether infanticide has taken place, correct?
Yeah, he's providing advice for physicians who might be in that position.
And at one point on page 109, he actually describes using a rope and a lantern to climb into what he termed a vault to obtain a 2-month-old fetus that was disposed of in the vault, correct?
Where is that?
Page 109, first column, second paragraph from the bottom, starts off, I recall to mind a case happening over 25 years ago.
Sorry, did you say the second paragraph on the second column?
Second column, second paragraph from the bottom.
Oh, from the bottom. On 109?
Correct.
I'm sorry, I'm really
First column.
not seeing it.
Sorry, it is the
Oh,
first column.
okay.
Thank you, Your
Yes,
Honor.
I recall to mind. Yes, I see that.
Thank you.
And what was the question?
He describes climbing into a vault to obtain a 2-month-old fetus that was disposed in the vault, correct?
Yes.
And from your understanding as a historian, what does he refer to as, what is he referring to as the vault when he climbs into a vault?
I think he is most likely referring to a privy.
Or toilet or outhouse or
Yeah,
something similar?
exactly. Yeah, a restroom of the 19th century.
Can you turn to page 110, please? The very last paragraph of, on page 110, he's talking about criminal abortions, correct?
Yes.
You read the very last sentence on that paragraph. It goes from 110 onto page 111.
The law is shamefully violated every day in the year in our land, and the peculiar surroundings of a criminal operation of this kind are generally so completely secreted that it is only at rare intervals that conviction follows, because direct evidence cannot be obtained.
Turn back to page 109, please. In the first column, last paragraph in the first column, it starts off with most of the criminal abortions take place. Can you please read that sentence?
Most of the criminal abortions take place during the first 3 months of pregnancy, for even those who are so unfortunate as to practice this nefarious business hesitate to act when viability is established.
Go back to page 110, please. In the second column on page 1, he talks about 2 instances of when an abortion is justifiable, correct?
Yes.
And what are those 2 instances that he says justify an abortion?
Whenever there is such mechanical obstruction that the birth of a viable child is impossible, whenever the mother is suffering from such grave diseases that her life is in imminent peril and can be saved only by the arrest of gestation.
Turn to exhibit 112, please. You testified about this on direct examination, correct?
Yes.
Can you turn to page 576, please?
Yes.
Lines down from the top, the first paragraph.
Okay.
There's a sentence that starts justifiable abortion. Do you see that?
Yes.
Can you please read that sentence?
Justifiable abortion is that which is performed for the purpose of saving the mother's life.
Can you please turn to exhibit 114? This was the article that you talked about as discussing melancholia, correct?
Yes.
Page 64, can you please turn to? Okay, can you please read the last 3 sentences of the first paragraph? It starts off with, "It goes without saying."
It goes without saying that the greatest care is requisite not to be deceived by a simulated melancholia. The cunning of women illegitimately pregnant should always be remembered. She will attempt to persuade her physician by every possible means into emptying the uterus.
you please turn to Exhibit 143? This is an article where you quoted from Dr. J.H. Lyons from Seattle, Washington, correct?
Yes.
Last full paragraph at the bottom on page 291. Can you read that, please? It starts off with one of the greatest obstetricians.
One of the greatest obstetricians whom the world has produced has said, "The life of the child does not belong to the physician." The truth of that statement cannot be successfully controverted. The mere fact of the existence of a human being carries with it the right to a continuance of that existence, and this is an inalienable right, a natural right which is incorporated in every fiber of our being, and not one, not even the physician, can justly deprive a human being of that right.
Paragraph 75 of your report. Can you turn there?
Okay.
And this is a paragraph where you're talking about physicians stating that it's okay to do an abortion for severe mental health conditions, correct?
Yes.
You're quoting an article from Dr. Robert Campbell Eve, correct?
Yes.
And you know where Dr. Eve practiced, what state he practiced in?
I would have to see if it's listed on the article, which I don't have.
Can I hand this to the witness, please? This appeared to be the article that you cited.
Yes, this appears to be it.
And where did Dr. Eve practice?
Augusta, Georgia.
Can you turn to page 518, please? And look at the end of, so the second full paragraph, it starts with "now having reviewed this phase." You see that? Mm-hmm. And at the end of that paragraph, the last sentence.
I shall aim, that one.
Yes. So the last line actually makes it clear that he is opining on the laws of the state of Georgia for his opinion, correct?
And its relation. He cites the Code of Georgia, but I'd have to read the whole article again to see if everything in the article is only in relation to Georgia.
Okay. Could you go ahead and read that last sentence? It starts with "I shall aim."
I shall aim to dwell upon them in their regular order of succession, and in doing so it shall be my main objective to develop the situation in its relation to what is of greatest moment to us, the law as it obtains in our own state, those laws embodied in the Code of Georgia.
Can you please turn to page 520? The first highlighted section at the top of the page starts off with the terms authorized or justifiable. Can you please read that paragraph?
The terms authorized or justifiable abortion are interchangeable and are to compass all conditions necessitating the induction of abortion, where the object to be obtained is the preservation of the life of the mother or child or both.
Another article that you cite is the editor's table of the Obstetric Gazette. Do you recall that?
It sounds familiar, but I'd have to look at my report.
I'm going to hand you, sorry, you just sat down. I apologize, I did not write down what paragraph in my notes that you cited that in, but you said it sounds familiar. Can you take a look at what was just handed to you? Does that look familiar?
Again, I would really like to see where it is in my report, just because I looked at so many sources.
If you could give me just a moment. Sure.
Objection, Your Honor, I'm not sure what exhibit this is that we're looking at right now.
Sure, it's an exhibit as such, or it's being presented as such. I think it.
It is not being presented as an exhibit, Your Honor.
Even just for reference, we could mark it. That would help.
Fine by you to mark it, even if you don't intend to offer it as an exhibit, Mr. Craig.
I was not planning on offering it. I was not planning on having it marked as an exhibit. If council wants to mark it as an exhibit, you know, in their direct or in their redirect, they can do that. But yeah.
Fine by me.
Page 75. Thank you, Kyle.
Is that page or paragraph?
Sorry, paragraph 75.
Yes, I see it in my references.
And I've handed you a copy of that. Does that appear to be the same same article that you cite?
Yes.
And this was an 1882 article published from a journal from Cincinnati, Ohio, correct?
Yes.
And you were citing this to support your statement that physicians believe that severe mental health conditions might warrant an abortion, correct?
Yes.
And in this article, the editors are responding to a doctor who wrote to the British Medical Journal arguing that abortion would be justified to prevent puerperal mania, correct?
Where is the section on puerperal mania, just so I can see?
So if you look at the page 369, the title is Induced Abortion versus Puerperal Insanity. See that? And it talks about a Dr. Strahan who sent a letter to the British Medical Journal, correct?
Yes.
And in that first paragraph says the question asking whether in the case of puerperal mania breaking out with increased violence and duration in 2 consecutive childbeds, it would be justifiable to procure early abortion in case pregnancy should occur again.
Yes, I see that.
And just for the, to refresh your record, what does puerperal mean?
Puerperal is anything to doing with childbirth.
Could you read the highlighted section at the bottom of page 369?
To us, the argument of Dr. Strahan seems overdrawn. He has apparently lost sight of the fact that abortion is criminal whenever the sacrifice of the child's life is not made to directly preserve that of the mother.
And could you go to page 370, please? Read that first highlighted section at the top.
The prevention of any amount of misery saddled on both mother and offspring could not, under our present laws, justify the taking of a life.
Second highlighted section, can you read that, please?
Though all that the doctor has said of puerperal insanity and its evil consequences may be true, still, in the eyes of the law, it's not so bad as the act of procuring abortion.
So you turn to page 38 of your report, please.
Page 38?
38, correct.
Yes. Okay.
In a footnote 115, you quote, or you cite to Dr. Harris, modern indications for therapeutic abortion from the neurologic standpoint, correct?
Yes.
And that report was published in 1936, correct?
Yes.
That was published in the state of Texas.
It was published in the Texas State Medical Journal, or Journal of Medicine, yes.
And 1936 was 46 years after Idaho became a state, correct?
That is my understanding, yes.
Turn to page 80 of your report, please. Or, I'm sorry, paragraph 80. In paragraph 80, you cite to Dr. William Parrish, criminal abortion, correct?
Yes.
That was published in the Maryland Medical Journal, correct?
Yes.
And you cite to that article for the proposition that the medical profession is entrusted with the ability to determine what is justifiable abortion, correct?
Yes.
All right, I'm going to hand you a copy of that article. Thank you. And you've just been handed, does that appear to be the same article?
Yes.
Could you please turn to page 89 on the article? It should be the first article.
The first page, yeah.
And there's a highlighted section there in the second column. Can you please read that?
I will not argue before this society the great moral criminality of what is known under the law as criminal abortion. The medical profession looks upon this crime as one of the most heinous and as closely allied to infanticide.
Could you please turn to page 91. Sorry, let's go to page 90 first. Apologize. First column, there's a highlighted section towards the bottom. Can you read that highlighted section?
Whenever it is necessary to terminate pregnancy in order to save the life of the mother, such a procedure is justifiable. If thus not necessary, the procedure is criminal.
It's your turn to page 91 now, please. And if you could just read that paragraph silently to yourself. You might need to go on the previous page, but just I want you to get the context before I ask you the question.
Okay.
And in that paragraph, he's talking about a pregnant woman who sought an abortion from him, and he consulted with a colleague on that case, correct?
It's not clear if they came to him or if they went to another physician who consulted with him.
And they determined that they were not able to perform the abortion because it would not be justifiable, correct?
Yes.
So she went to a different city, correct?
Yes.
Can you please read the highlighted section that starts with "she returned to her former home"?
She returned to her former home in a distant city, and there the abortion was produced by a regular practitioner. I saw a letter from this physician in which he attempted to justify on medical grounds not only this abortion, but also 2 previous ones on the same lady. His plea was that of justifiability because of apprehended insanity. Such and similar cases seem to me to quite merge into criminality.
Dr. Storer quite a bit in your report, correct?
Yes.
And you, paragraph 9 of your report, you wrote that he argued, quote, he quote, argued that abortion should be criminal if performed by anyone other than a trained physician, correct?
Yes.
You cite to his book, Criminal Abortion in America, correct?
Yes.
I've handed you a copy of that book. Does that appear to be excerpts from that book, Criminal Abortion in America?
Yes, it does.
Please turn to page 59.
Yes.
Read the highlighted section at the top there.
Premature labor or obstetric abortion may be justifiably induced by the physician for one of 2 reasons, either to save the life of the mother or that of her child. In each case, it must be absolutely and only to save a life.
Can you turn to paragraph 89 of your report?
Okay.
Paragraph 89, you wrote, quote, although Storer tried to convince his audiences that abortion laws can also protect the vulnerable lives of unborn children, his argument was rejected by most regular physicians at the time. You see that?
Yes.
And you cite James Moore's book, Abortion in America, for this principle, correct?
Yes.
I handed you a copy of an excerpt of that book. Does this appear to be a copy of portions of that book?
Yes.
Can you please turn to page 153? Can you read the highlighted section at the bottom of 153, please?
Medical journals around the nation began to endorse Storer's proposals, and some of them, like the Medical and Surgical Reporter of New Jersey, urged physicians in their areas to make a public protest against the practice of abortion.
And can you turn to page 154, please? According to this, one of his main critics even had to, quote, claim that his statements had been misinterpreted and that he had been a longtime personal foe of abortion, correct?
Yes.
Can you read the highlighted section on page 154 that starts with Boston's regular?
Boston's regular physicians endorsed Storer's report early in the summer of 1857.
You turn to paragraph 24 of your report, please. paragraph 24, you wrote, quote, abortion was thus criminalized throughout the latter half of the 19th century, not as a response to widespread public or political attitudes about pregnancy and abortion. Do you want me to start over? Abortion was thus criminalized throughout the latter half of the 19th century, not as a response to widespread public or political attitudes about pregnancy and abortion, nor as a method to restrict the freedoms of pregnant women, but rather as part of a broader strategy to restrict the practice of medicine to regular physicians. You see that?
Mm-hmm. Yes.
You turn to page 162 of the excerpt from Moore's book, please. Can you please read the highlighted section from page 162 on to 163?
Time and again, medical writers demanded punishment for any regular willing to perform abortions and urged their fellow doctors to testify against erring brethren in court. Also striking was the large number of anti-abortion writers who accused the medical societies of harboring, or at least tolerating, members known to be frequent aborters. Such tolerance, claimed the professionalizers, harmed the good name of all regular physicians, and those who aborted were regarded as hateful traitors to the prolonged war over the future of American medicine.
Turn to page 164.
Yes.
Please read the highlighted section from 164 going on to page 165.
Compelling personal factors certainly added to the substantial professional motives for an anti-abortion crusade on the part of America's regular physicians. The first was no doubt sincere belief on the part of most regular physicians that abortion was morally wrong. The fact that this belief coincided nicely with their professional self-interest is no reason to accuse physicians of hypocrisy on the issue. Instead, the convergence probably helps us explain the intensity of their commitment to the cause.
Could you read the highlighted section at the bottom of page 165, please?
Most physicians considered abortion a crime because of the inherent difficulties of determining any point at which a steadily developing embryo became somehow more alive than it had been the moment before. Furthermore, they objected strongly to snuffing out the life in the making. Only a fully realized life, that of the mother, would surely be lost without their intervention could they morally justify the termination of another already developing life.
Turn to page 45 of your report.
Okay.
Sorry, I want to back up. Can you go to paragraph 80 of your report? Paragraph 80, you write, quote, medical writings freely discuss the use and appropriateness of obstetric abortion and showed the wide range of conditions and situations in which physicians deemed it necessary, but also noted that the ultimate determination was a job for physicians and physicians only, correct?
Yes.
And you cite to William H. Parrish for this, correct?
Yes.
You should still have a copy of Parrish's article in front of you.
Yes.
Please turn to page 90. Please read the highlighted section in the first column on page 90.
Whenever it is necessary to terminate pregnancy in order to save the life of the mother, such a procedure is justifiable. If not thus necessary, the procedure is criminal.
Please read the highlighted section on the second column on page 90.
It is quite generally accepted that there are cases of disorders of the kidneys or of the heart or of degenerations of the ovum as myxoma of the chorion and polyhydramnios and very rarely instances of uncontrollable vomiting in which the production of early or late abortion is demanded and justifiable, because it is necessary to save the life of the mother, and also because the death of the mother always involves the death of the embryo and usually that of the child approaching maturity.
You look at paragraph 86 of your report.
Yes.
Paragraph 86, you wrote, when faced with having to choose between preserving the life or health of a pregnant woman, I think that should be woman
I
instead
believe
of
so,
women,
yes.
or that of her fetus, 19th century physicians consistently chose to prioritize the pregnant woman. You see that?
Yes.
And then you list several examples to support your opinion in paragraph 86, correct?
Yes.
And in paragraph 87, you quote a statement from the editors of the Medical Times and Gazette, correct?
Yes, I believe so. Yes, sorry.
You quote them as saying, quote, the life of a healthy young wife and mother ought to outweigh in the balance of any number of immature fetuses, correct?
Yes.
In that same paragraph, you quote Dr. Perkins, correct?
Yes.
And you quote him as saying, quote, when it comes to a question of danger to the life of a wife, and then ellipses, how can there be any hesitancy as to doing that which will save the life of the woman, correct?
Yes.
Dr. Perkins practiced in Providence, Rhode Island, correct?
I would have to double check on that.
I'll hand you another article. And does this appear to be the article from Dr. Perkins that you were citing?
Yes, it does.
And Dr. Perkins is listed as being from Providence, Rhode Island, correct?
Yes.
And can you please read the highlighted section there on the first page in the first column?
The cases I wish to consider are those where the life of the mother is endangered by the longer continuance of pregnancy, and would like to hear your opinions as to when the life of the mother is endangered by the longer continuancy of the pregnancy.
And so with this article, he was simply asking the question, when is the life of mother in danger, correct?
I wouldn't say that's the only thing he's doing with this article.
Okay, can you read that quote again there on that first page?
The cases I wish to consider are those where the life of the mother is endangered by the longer continuance of pregnancy, and would like to hear your opinions as to when the life of the mother is endangered by the longer continuance of the pregnancy.
You look at paragraph 88 of your report.
Yes.
There you quote a textbook from Dr. Barton Hurst was instructing students, quote.
Yes.
Correct?
Yes.
And you write, quote, that if a woman's life was endangered, it is only justifiable, but it is the physician's duty to terminate, it is not only justifiable, but it is the physician's duty to terminate gestation and thus save one life, correct?
Yes.
That same paragraph, you quote a Dr. Clarence Idle, correct?
Yes, I believe.
Clarence Ide, thank you. And you quote him as saying that a physician has a, quote, duty of saving a mother's life by performing an abortion, correct?
Where's the quote? He's asking a quote from him?
That's your,
yes.
that's
yes,
your
sorry.
report,
I was looking
correct?
for a quote from him. Yes, I do see that.
Fulfill his duty of saving a mother's life by performing an abortion.
Yes.
You also quote a Dr. Charles Reed in that same paragraph, correct?
Yes.
You quote Dr. Charles Reed as saying that physicians must be ready to treat an ectopic pregnancy because an ectopic pregnancy poses, quote, great peril to the mother's life, end quote, correct?
Yes. Sorry. Can you repeat the question?
Quote, Dr. Charles Reed is saying that physicians must be ready to treat an ectopic pregnancy because an ectopic pregnancy poses, quote, great peril to the mother's life, end quote.
Yes, yes,
Is that correct?
yes,
You also quote Dr. Ellis in that same paragraph, correct?
yes,
Dr. Ellis is from Connecticut.
yes,
You quote Dr. Ellis is saying, quote, physicians believe mature life has a right to live, if necessary, at the expense of the beginning of life, correct?
yes,
Paragraph 89, you're quoting Dr. William Brinton's A Recent Craniotomy, correct?
yes. Wilmer Brinton.
So what's that?
Wilmer is his first name, but yes.
Okay, thank you. You quote Dr. Brinton is saying, quote, if the life of the mother is at stake and the sacrifice of the child, if necessary to pervert to her preservation, few at present day would dispute the superiority of the mother's claim to existence, correct?
Yes.
Paragraph 64, you wrote in your report that there was a tradition of allowing physicians complete and unfettered discretion over their medical practices, including providing abortions, correct?
Sorry, what paragraph was that?
64?
Okay, and can you repeat it?
Yes, you say that there was a, quote, tradition of allowing physicians complete and unfettered discretion over their medical practices, including providing abortions.
Yes.
Isn't it true, however, that newspapers from Idaho's territorial days through the early 1900s show that abortion was not condoned, but was treated as a serious criminal offense?
The vast majorities of newspapers that I found in my research showed that abortion cases were usually reported on when some other crime had happened, like the death of a woman or something, or incest or some other more serious crime, I believe. Thank you.
You indicated that you reviewed the Planned Parenthood Great Northwest versus State of Idaho case from the Idaho Supreme Court, correct?
Yes.
Can you turn to, on the printout, it's page 57 at the bottom. For the reporter, Your Honor, it'd be 171 Idaho, page 425, 522 P3rd, page 1183. Can you read the highlighted section at the bottom of the page there, please?
In sum, the newspapers from Idaho's territorial days through the early 1900s show that the abortion was not condoned but treated as a serious criminal offense.
And in fact, isn't it true that physicians fled the state of Idaho to avoid prosecution at even the suggestion that they had performed an abortion?
I would have to look through all my sources. I don't remember off the top of my head if I found evidence of that.
Can you turn to page 56 of the handout that you have? And Your Honor, for the reporter citation, this would be 171 Idaho, page 422 going on to page 423, and 522 P3rd going from page 1180 to 1181.
Thank you.
Can you please read the highlighted section at the top of that page?
1 year after that, in 1888, another Idaho newspaper reported that the local Dr. Biggers had made a hurried departure from town after he was accused of performing an abortion.
That was in the Wood River Times, July 14th, 1888, correct?
Yes.
You testified that you saw no evidence of a regular physician being prosecuted for an abortion unless someone died. Is that correct?
Unless someone died or there had been some other serious crime, I think. That's what I just said.
Please turn to please turn to page 57. This would be 171 Idaho 424, 522 P3rd, page 1182 of the Planned Parenthood case. And here the Planned Parent case talks about, or is quoting from an Idaho statesman article reporting about a case of an abortion that occurred in the state penitentiary, correct?
Yes, that's my memory.
And it refers to a prosecution against the prison physician amongst others, correct?
That is, I believe, what I remember of this particular case, yes.
Read the highlighted section. It's the first one. It starts with, although convictions.
Although convictions were not secured, the prominent individuals like the warden and physician of the Idaho State Penitentiary were prosecuted at all indicates a strong public sentiment against any abortion, not necessary to preserve the life of a woman.
Did you read the State versus Alcorn, Idaho Supreme Court case from 1901 during your research?
No, I did not.
Your Honor, she said she did not read this, and this is a legal case. It is not a historical or factual document that he's going to be asking her about.
I can ask her questions, lay foundation.
That's fine. It would appear to be about time to take a break. How much time do you think you have left of your?
About 2 or 3 questions left, so I'm almost done.
All right, let's try to finish up with the cross then. Go ahead.
Do you consider the Idaho Supreme Court to be a reliable authority?
Yes.
Your Honor, vague question.
I suppose it is vague as to in what way the Idaho Supreme Court is a reliable authority. So I'll sustain the objection, disregard the answer. You can ask another question.
Opinions of the Idaho Supreme Court, opinions and facts that can be relied upon by historians to determine what occurred at the time?
I would say sort of my experience is in primarily deciding on medical history, and I don't know if I'm necessarily qualified to answer that question.
Do you have any reason to believe that the Idaho Supreme Court would not accurately represent the facts of a case that's presented before them?
Objection, Your Honor. She is not a lawyer and has no opinion on the accuracy of the Idaho Supreme Court's historical citations.
I'll let her answer that question. We'll see how much farther it goes.
Again, I would say this is beyond my expertise.
Your Honor, I'll ask the court to take judicial notice that the Idaho Supreme Court is a reliable authority under Rule 803.18.
I don't think I could call a Supreme Court opinion a learned treatise. So I'll decline that request.
Well, it's a learned treatise.
The authority itself may be relevant to deciding the legal issues in the case.
So it's treatise, periodical, or pamphlet, I think, statements. I think certainly the Idaho Supreme Court case would count as a reliable authority under Rule 803.18.
Your Honor, I object. Even if this article is what it purports to be, there's a divisibility problem here. There's a relevance problem as well.
All right. Well, this is not to denigrate the Idaho Supreme Court opinion, but frankly, you could ask the same question as to any court in the country, and I don't think I could fit it. I don't think I could fit it within this hearsay exception. So,
Dr. Whitcomb, you testified that you reviewed the Planned Parenthood case, correct?
Yes,
And that was from the Idaho Supreme Court?
I believe so.
In fact, you relied on the Idaho Supreme Court's recitation of the history of Idaho's territorial laws in writing your report, correct?
I think I relied on the descriptions of the legislative sessions.
And the Constitutional Convention?
I would have to look at it again, but I think so.
So you considered the Idaho Supreme Court to be a reliable authority for those portions of your report? You considered the Idaho Supreme Court to be a reliable authority for those portions of your report?
I relied on their, reliability on the descriptions of the legislative sessions.
So At this point, I'll ask you if you could read some sections from the State versus Alcorn case.
Objection again, Your Honor, same objections. Hearsay, relevance.
Sustained. I'm amenable to, obviously, to considering the opinion in that case for whatever precedential value it has, but that's as far as it goes.
So, Your Honor, she testified that she's not aware of very many prosecutions of physicians for crimes involving criminal abortion, and this, from the Idaho Supreme Court, directly impeaches her testimony and the reliability of her methods for searching, and I think it is important for the court to consider it. Whether the court considers it from her own words or whether the court just reads it and considers it that way, I don't think it matters, but I think this directly impeaches her testimony.
All right, so I don't think I understood the purpose for which you intended to use the opinion. If you were going to use the opinion, I guess, as some sort of historical, some sort of authoritative historical pronouncement, then I think the ruling I had made before would be justified. If you are going to, if what you're doing is pointing out this as a historical example of a prosecution that Dr. Withicum said were rare or non-existent, then that's a different matter. So I will permit use of the opinion for that purpose.
Thank you, Your Honor. Could you please read the highlighted sections on page 3 of the printout, please?
The appellant was tried upon an indictment charging him with the murder of one Cora A. Burke, resulting from a criminal operation performed by appellant for the purpose of bringing about an abortion.
Read the next highlighted portion underneath that, please.
Sometime in May 1899, Mrs. Martha Johnson, at the request of the deceased, introduced the deceased to the appellant, who had been practicing medicine for a short time in the town of Harrison in said Kootenai County.
I believe that'd be Kootenai County.
Okay, Kootenai County. Thank you.
Can you please turn to page 7? Read the highlighted portion at the bottom of page 7 going on to page 8, please.
The crime for which appellant had been convicted is one of the worst known to the law. An unnatural abortion brought about by means of drugs or instruments violates decency, the best interests of society, the divine law, the law of nature, the criminal statutes of this state, and is not only destructive of a life unborn, but places in jeopardy the life of a human being, the pregnant woman.
That's all the questions I have. Thank you.
All right, thank you. So, Ms. Pletcher, unless your redirect is likely to be under 5 minutes, we will take a break. If you can get done in under 5 minutes, I'll let you press forward.
We can take a break, Your Honor.
All right. We'll take 15 minutes. We'll be in recess.
All rise.
Please be seated. Fletcher, please proceed with your redirect examination of Dr. Withicombe.
Thank you, Your Honor. Professor, on cross-examination, you were asked about an Idaho Supreme Court case called State v. Alcorn. Do you recall that?
Yes.
And you were asked specifically about the facts of a criminal matter described in that case. Is that correct?
Yes.
Okay. Did the facts of that case in any way affect your conclusions in this matter, where you stated that physicians were generally not prosecuted for criminal abortions?
No.
And why not?
I believe, if I'm remembering correctly, that the woman died in that case.
Let's take a look. Do you still have the document in front of you?
I don't. Oh, thank you.
State directed you to the first paragraph.
Yes, what I see, again, not being an expert in this realm, is that he was charged with the murder of Cora Burke.
Does this prosecute? Oh, okay. You're saying that she was charged with the murder.
Yes.
Okay. In your professional opinion, is this an example of a prosecution for a therapeutic abortion?
I don't see words that would indicate that.
Okay, we can put that down. Now, Professor, you were also asked about certain articles in newspapers that were cited in the Planned Parenthood opinion. Do you recall that?
Yes.
Okay. I'm going to ask you to look at the excerpt of the Planned Parenthood opinion that the state provided to you, and to look at page 57. Are you there?
Mm-hmm.
The state directed you to an example of an article from the Idaho Statesman,
Yes.
and had you read the first paragraph, the first sentence of a paragraph starting, although convictions were not secured. Do you
Yes.
recall? Could you please read that paragraph, that first sentence?
Although convictions were not secured, the prominent individuals like the warden and the physician of the Idaho State Penitentiary were prosecuted at all indicates a strong public sentiment against any abortion not necessary to preserve the life of a woman.
Please put those facts into the context of prosecutions of physicians for abortions in Idaho at that time.
That I didn't find any evidence of physicians being prosecuted for therapeutic abortions.
Does this newspaper article in any way change your opinion that physicians were not prosecuted for therapeutic abortions?
No, it does not.
That aside. Professor, on cross-examination, you were asked to revisit Plaintiff's Exhibit 143. Can we go back there, please?
Yes.
Specifically, you were asked about two articles that had been published in this edition of Northwest Medicine, one by Dr. Russell and one by Dr. Suttner. Do you recall that?
Yes.
In this particular article of Northwest Medicine, this edition, what were the articles generally about?
They were generally about criminal abortion.
Well, who was the president at the time of the Physicians Association identified in this journal?
Of the Washington State Medical Association, the president would have been J.H. Lyons, who was the author of that first article.
And what was J.H. Lyons' role, if any, in choosing the articles that were in this particular journal edition?
Most likely as an outgoing president, this would have been sort of a celebration of him a little bit, so he probably would have chosen the other speakers.
In your opinion, how likely would Dr. Lyons have been to choose authors who disagreed with his views?
Very unlikely, I would say.
I object. Calls for speculation.
Made as well without the answer as it is with the answer. So I'm going to sustain the objection.
Professor, do you have any understanding of the relationship between Dr. Russell and Dr. Lyons?
Again, my belief is that they were most likely, that Lyons believed that Russell followed Lyons's opinion, and that's why he chose him to speak at this.
Calls for speculation, lack of foundation as to how she knows that.
State the question, please.
I have to ask the court reporter to read back my question, or I'm happy to restate, right, ask a new question.
All right. And if you could supply the answer so far as it was given, please.
I'm going to direct you to a quote that the state asked you to look at with respect to Dr. Suttner, and it was on page 305 of this exhibit. That's page 305 of the original, not the Bates stamp. It would be in the copy the state provided to you.
Sorry. Okay, what was the page number again?
305. It's actually the first page of Dr. Suttner's article.
Yes.
Okay, so we look down at the highlighted portion that the state highlighted. The bottom of page 305, could you just read the first sentence, please?
Intentional abortions are of two classes: criminal when performed for social reasons, and obstetric when performed by the physician to save the life of the mother.
Okay. Does that statement at all change your opinion with respect to the difference between therapeutic and criminal abortions?
No, it does not change my opinion.
Could you clarify for the court the difference between the two?
As set out by Storer and discussed by multiple physicians, therapeutic abortion was an abortion provided by a regular physician when he deemed it necessary, and a criminal abortion was an abortion provided by someone else or for, as is stated here, social reasons.
On the side. On cross-examination, you were asked about some quotes from a book by James Moore. Do you recall that?
Yes.
Okay. And those quotations generally related to the morality of abortion. Do you recall that?
Yes.
How widespread was it among regular physicians that their moral views on abortions should dictate their choices as a physician in terms of healthcare treatments?
Out of all of the medical writings that I found, I don't remember seeing that in any of them.
I'm going to ask you to turn to Plaintiff's Exhibit number 136, which is not in your binder, but it was one of the documents that the state handed to you. It is an article by Dr. Parrish. The state highlighted a paragraph on the very first page of this document. It is the Maryland Medical Journal. And they highlighted a paragraph. I'm going to ask you to read the highlighted paragraph again and ask you a question about it.
I will not argue before this society the great moral criminality of what is known under the law as criminal abortion. The medical profession looks upon this crime as one of the most heinous and closely allied to infanticide.
Does that excerpt in any way affect your opinions in this case?
No, it does not.
Why not?
Because they're talking about criminal abortion, which is not the same as therapeutic abortion, which was provided by physicians.
I'm going to ask you to look at the next page of the same exhibit, page 90. Very bottom of the page, on the column on the left side, the very last sentence. If you could read that piece, which is that piece starting with the word "the resort to an abortion." So left-hand column, all the way at the very bottom, the last sentence, starting with the word "the resort to an abortion."
The resort to an abortion may be reprehensible, though not criminal. For instance, when it is performed by a practitioner of medicine under the mistaken, though honest, opinion that an abortion is necessary to save the life of the mother.
So how does that excerpt relate to your opinions in this case?
I would say this again shows that physicians were able to use their own discretion in providing therapeutic abortions.
That's fine.
Okay, thank you, Your Honor. Professor, I'm going to have you go back to the article by Dr. Watkins that the state referred you to. And I believe that that is Plaintiff's Exhibit. I'll tell you in 1 second. Just a moment to look that up so I can direct you exactly where. Thank you. Plaintiff's 153. Okay, do you recall this article from Dr. Watkins?
Yes, I do.
Okay, so I'm going to have you look at what's page 110 in the original document, but that's Bates stamp 153.0007. And the state asks you to read into the record a quote that is on the upper right-hand side of the right column, starting, "When is the induction of abortion justifiable?" Do you recall that?
Yes.
Yeah, actually, I'm going to ask you to read that again so we can discuss it.
Just starting at point 1.
Starting when is the induction?
When is the induction of abortion justifiable? I quote, "Whenever there is such mechanical obstruction that the birth of a viable child is impossible, whenever the mother is suffering from such grave diseases that her life is in imminent peril and can be saved only by the arrest of gestation."
Does this quote in any way change your opinions that you've given in this case so far?
No, it does not.
Why not?
I would say multiple reasons. One, this is a quote from someone else that Watkins doesn't identify, so I'm not sure who this is.
I'm just going to pause you there. How do you know that this is a quote from someone else?
He uses quotation marks, and he says, I quote. Also, if you read it in the context of that whole column, you can see he talks more about how he views therapeutic abortion as akin to amputating an injured limb.
And how does that,
Which
what does that mean in terms of your opinions?
which I think indicates that he is considering therapeutic abortion in not as something that is needed to give it to a woman who is in danger of immediate death.
You're also asked to read a quote at the very bottom of this page. That starts with, "The law is shamefully violated." Do you see that?
Yes, I do.
Okay. Can you just read that sentence?
"The law is shamefully violated every day in the year of our land, and the peculiar surroundings of a criminal operation of this kind are generally so completely secreted that it is only at rare intervals that conviction follows because direct evidence cannot be obtained."
I'm going to pause you there. And does that quote change your opinions in the case you've given today?
No, it does not.
Why not?
Because this is in reference to a criminal operation, which, and most of my conclusions were about therapeutic abortions provided by regular physicians.
Now, was Dr. Watkins writing about Idaho specifically in this article?
No, he was not.
How do you know that?
One of the ways I know that is he discusses abortion law, and he says that it is legal to, or actually it is illegal to provide an abortion even if a woman is not pregnant. And that goes against the Idaho state law, which says a woman must be pregnant.
Thank you, Your Honor. No more questions.
Thank you, Ms. Pletcher. Anything else for this witness, Mr. Craig?
I have just 1 minute, Your Honor.
That's fine.
No, Your Honor, no additional questions. Thank you.
All right. Thank you, Dr. Withicum. You may step down. Plaintiffs may call their next witness.
Your Honor, Nicholas Cabot on behalf of the plaintiffs from the Center for Reproductive Rights. The plaintiffs call Dr. Jennifer Payne to the stand.
Good afternoon. Go ahead, Mr. Cabot.
Just have to binder for the court and for the witness.
Thank you.
Good afternoon, Dr. Payne. Would you please state your name and spell it for the record?
Sure. I'm Dr. Jennifer Payne, and it's Jennifer, and Payne is Payne.
Dr. Payne, what do you do for work?
I am a psychiatrist. I'm a professor of psychiatry at the University of Virginia. I consider myself a reproductive psychiatrist. I also conduct clinical research, and I teach.
I'd like to give the court some information on your experience, but before I jump into that, could you please tell us why you are here today?
I'm here to give my opinion as a reproductive psychiatrist on the potential increase in mortality and morbidity for pregnant patients with psychiatric patients, given Idaho's abortion bans.
Dr. Payne, would you please open your binder to tab 1? What do you recognize Plaintiff's Exhibit 17? This is pre-marked Exhibit 17.
Yes, it's my curriculum vitae.
Who created Exhibit 17?
I did.
Exhibit 17 is dated March 12th, 2024, correct?
Yes.
Does it truly and accurately summarize your educational and professional history as of that date?
It does.
Do you regularly maintain Exhibit 17 up to date?
I do.
At this time, plaintiffs offer Exhibit 17 for the purposes of demonstrating Dr. Payne's qualifications.
Any objection?
Same objections as the other CVs.
All right, meaning you don't object to its admission if it's considered only for the purpose of establishing the witness's qualifications.
Yes, Your Honor.
All right, Exhibit 17 is admitted for that purpose.
Thank you, Your Honor. How many years, Dr. Payne, have you been practicing as a reproductive psychiatrist?
About 21.
Are you board certified?
I am.
In what?
In psychiatry and neurology.
And who is it that certified you?
The American Board of Psychiatry and Neurology.
In what states are you licensed?
Virginia and Maryland.
Would you please explain what reproductive psychiatry is for the court?
Sure. So reproductive psychiatry is a subfield of psychiatry that's become more and more prominent over the last 2 decades. In the early 2000s, there were a number of research studies that began looking at reproductive depression and reproductive mood disorders, which are mood disorders that are triggered by times of reproductive hormonal change.
Are there fellowships in reproductive psychiatry?
There are over 20 now across the U.S.
Are there any professional associations for reproductive psychiatrists?
There are.
What are those?
Well, 2 of them are the International Marseille Perinatal Mental Health Society and the Marseille of North America Perinatal Mental Health Society.
Are you involved in those associations?
I am. I'm the current president of the International Society, and I'm the immediate past president of the Marseille of North America Society.
Do you know if there are any reproductive psychiatrists in Idaho?
To my knowledge, there are not.
How do you know that?
When I was retained for this opinion, I actually tried to find a reproductive psychiatrist in Idaho. I'm having a time. And I searched our membership for the Marseille of North America Society, and no one is a member from Idaho.
I'd like to turn to your educational history. Where did you attend medical school?
I went to Washington University in St. Louis.
Did you complete a residency?
I did.
Where did you complete your residency?
Johns Hopkins.
Where did you work next after completing your residency?
I did a clinical research fellowship at the National Institutes of Mental Health in the Mood and Anxiety Disorders program.
And after that fellowship, where did you work next?
I was recruited back to Johns Hopkins and joined there as junior faculty.
Did your work at Johns Hopkins involve treating pregnant patients?
It did. I founded and directed the Women's Mood Disorder Center, which had a very big focus on the perinatal population.
Would you briefly describe for the court your work with pregnant patients at Johns Hopkins?
Sure. So the Women's Mood Disorder Center was a clinical and research and educational enterprise. We evaluated women who were pregnant or postpartum who were struggling with psychiatric disorders. We also did pre-pregnancy consultations for women with psychiatric disorders who wanted advice on how to manage their psychiatric disorders during pregnancy and lactation.
Where do you currently work?
At the University of Virginia.
What are your titles at the University of Virginia?
I am a professor of psychiatry and neurobehavioral sciences. I'm also a professor in the OB-GYN department. I'm vice chair of research in the Department of Psychiatry. I direct the perinatal mental health clinic, and I also direct the reproductive psychiatry research program.
You mentioned that you were a professor in the OBGYN department at UVA.
Yes.
Why are you a professor in that department?
It's an honorary title that the OB-GYN department offered me to really emphasize my expertise and that they work with me frequently.
In your current work, do you work with pregnant patients?
I do.
Could you describe your practice with these patients for the court?
Sure. So I currently supervise, I direct.
Hold on just a moment. There was an objection. I couldn't hear the grounds.
I'm sorry.
Objection relevance.
All right. Overruled. You can continue your answer.
Thank you. I direct the perinatal mental health clinic, and I have trained a nurse practitioner and other residents to see patients in that clinic, and I supervise them on a weekly basis.
Over the course of your career, approximately how many pregnant patients have you treated?
That number would be in the hundreds.
In addition to working directly with patients, do you consult with any OBGYNs on the treatment of pregnant patients?
I do. At the University of Virginia, I frequently get calls or emails from OB-GYNs. I also get something called e-consults, which is sent through our electronic health record, and all of those e-consults from OB-GYN come directly to me, where they can ask specific questions about patients.
And what do those questions typically entail?
I have a patient who's suffering from postpartum depression. Should I start an antidepressant like an SSRI, or should I use one of the new drugs like zuranolone would be an example.
Do they sometimes come to you with questions when a patient is pregnant?
All the time.
And what would be the nature of those inquiries?
Really managing psychiatric symptoms, what kind of medication they should be using, what medication could they start during pregnancy that could be continued during lactation.
Are you a member of the American Psychiatric Association?
I am.
Have you been involved in the work of the American Psychiatric Association?
I have in various ways. Currently, I'm a member of the Council on Women's Mental Health. And I've also been involved in revamping or rewriting the Diagnostic and Statistical Manual, which is produced by the APA.
What is the Diagnostic and Statistical Manual?
It is essentially the manual that describes our psychiatric illnesses and gives very specific definitions and criteria that a patient has to meet in order to receive that psychiatric diagnosis.
What did your work with, may I call it the DSM?
Please.
What did your work on the DSM entail?
I worked with a committee to help rewrite some of the language throughout the volume.
Dr. Payne, are you familiar with the topic of maternal mortality in Idaho? I
am.
How do you come to be familiar with that topic?
I reviewed the Maternal Mortality Committee report from Idaho.
As part of that familiarity, do you have an understanding of the leading causes of maternal mortality in Idaho?
I do.
Relevance does not relate to plaintiffs' as-applied claims.
Overruled. You can answer.
I do.
Ask another question.
Thank you.
What is that understanding?
The leading cause of maternal mortality in Idaho are mental health conditions.
And what is that understanding based on again?
That is based on the report from the Maternal Mortality Committee of Idaho.
Dr. Payne, would you please open your binder to tab 2? This is pre-marked Exhibit 584.
Yes.
Do you recognize Exhibit 584?
Yes, this is the report from the Maternal Mortality Committee.
Did you rely on Exhibit 584 for your expert opinions in this case?
I did.
Relevance.
Overruled.
Are MMRC reports considered a reliable authority in the medical field?
They are.
Plaintiffs at this time offer Exhibit 584.
We would object on relevance grounds.
Okay. Overruled. I'll admit Exhibit 584.
Your Honor, would the court permit a continued objection on relevance grounds?
I am willing to do that, yes. All right. Go ahead and continue.
Dr. Payne, I'd ask you to turn your attention to page 50. And this is page 49 of the document, but page 50 of the exhibit number.
Yes.
Your Honor, we ask permission to publish figure 24 on page 50 on the screen.
Go ahead.
Dr. Payne, what is your understanding of what Exhibit 584 says about mental health conditions and maternal mortality in Idaho?
This is a figure that compiles the maternal mortality deaths from 2018 to 2021, and it shows that mental health conditions are the leading cause of maternal mortality in Idaho during those years.
How many maternal deaths between 2018 and 2021 were caused by mental health conditions?
11.
For deaths in 2021 from mental health conditions, do you have an understanding of the cause, the manner of death?
I do.
What is your understanding?
They were suicides.
And what is that understanding based on?
That is based on the Maternal Mortality Committee's decisions reports.
Dr. Payne, before I move on, did you work with counsel to prepare a slide deck to assist with your testimony today?
I did.
Did you provide the content for those slides?
I did.
How many slides did you make?
3.
We discussed earlier that you are the reproductive psychiatry expert in this case.
Yes.
What is your understanding of why you are testifying here today?
It's to give my opinion and my clinical experience on working with pregnant patients with mental health conditions and how the abortion bans in Idaho would affect them in terms of receiving abortion care.
Dr. Payne, please look at slide 1 in your binder. This would be tab 3. Just briefly, what does slide 1 show?
This shows my opinions in this case.
Your Honor, I asked to publish slide 1 to assist in Dr. Payne's testimony.
Go ahead.
We'll dive deeper into your opinions in a moment, but Dr. Payne, would you briefly give an overview of your opinions in this case?
Sure. So I have 3 main opinions. The third opinion is divided into 2 really for clarity. The first opinion is that pregnancy can trigger, worsen, or initiate a significant psychiatric disorder in susceptible women. Those women should not be excluded from abortion care for health or life-threatening psychiatric symptoms. My second opinion is that some women require teratogenic medications in order to control their psychiatric symptoms, and those women should not be excluded from abortion care when it's appropriate. And then my third opinion is that the language of the abortion bans is unclear and narrow and really excludes women with psychiatric conditions from receiving abortion care, and that particular fact will lead to increased mortality and morbidity for women who are pregnant with psychiatric conditions in Idaho.
Thank you, Dr. Payne. What is the basis for your opinions today?
The basis is my clinical experience working with pregnant patients with psychiatric conditions, as well as the literature on this subject.
What materials did you review in preparing for your testimony today?
So I reviewed the complaint. I reviewed the language of the abortion bans. I reviewed the Planned Parenthood decision. I reviewed the Maternal Mortality Committee's report and decisions paperwork. I also talked to Dr. Lyons and Dr. Corrigan. Sometimes I forget names. And I also reviewed the literature. I'm always reviewing the literature surrounding psychiatric conditions during pregnancy.
Did you review, move on. Dr. Payne, what do psychiatrists do?
Psychiatrists are tasked with diagnosing psychiatric conditions and providing recommendations for treatment after they formulate exactly what is going on with a particular patient.
How do psychiatrists, in your professional opinion, evaluate a patient when they first see them?
Well, we take a very thorough psychiatric history, and that can last anywhere from 1 to 2 hours and includes a history really from the time the person is born up through the time that they are before the psychiatrist. It involves taking a thorough psychiatric history, including what medications they've had, whether they've been hospitalized, et cetera. But it also includes taking a medical history, a history of substance use, a family history, and really understanding who that patient is and where they come from.
You mentioned earlier the DSM. Are these agreed upon diagnostic criteria for mental health conditions?
They are. When the DSM was first founded, it was founded really to make sure that psychiatrists across the United States and even in other countries were making the same diagnoses based on the same criteria. Prior to the DSM, a patient might be diagnosed with schizophrenia in one place and with bipolar disorder in another. And the DSM really standardized our clinical criteria for making psychiatric diagnoses.
Is it used across this country?
It is.
And is it considered the leading and reliable authority in your field?
It is. It's really considered the standard of care of making a psychiatric diagnosis.
Do you have an understanding of how the diagnosis of psychiatric conditions compares to the diagnosis of other medical conditions?
Yes, so many medical conditions are made based on a clinical diagnosis. And psychiatric diagnoses are made on the basis of a clinical interview. We often get blood tests or other tests such as a CT scan. We also can require neuropsychological testing. Sometimes we get lumbar punctures, et cetera. It really depends on the needs of the patient. But in my opinion, psychiatric diagnoses are just as accurate and reliable as medical diagnoses.
How do psychiatrists determine the appropriate treatment for a given patient's condition?
Well, first of all, you have to formulate the case. So you have to make sure that you understand what you think the patient is meeting criteria for. So the treatment for major depression is very different from the treatment for bipolar disorder. And in general, there are groups of medications that are generally used for different psychiatric conditions. We also tend to choose medications based on their side effect profile in a way that's advantageous for us. So if a patient has major depression, is having trouble sleeping, we will tend to pick an antidepressant that may help them sleep in addition to treating their depression. We also have something called gene site testing, which is essentially a DNA test that really gives us information on how a particular patient metabolizes a particular psychiatric medications that can help us pick a medication that will cause fewer side effects for them.
In your experience, how do you determine if a patient is suicidal?
Well, you do so based on asking them. But also, it's important to take into account their psychiatric history and whether you think that they're meeting criteria for psychiatric diagnosis. So most patients, if you ask them about suicidal thoughts, will be forthcoming about whether they're having them or not. And then it's important to really dive deeper with them, to really have a conversation. It's not a matter of one question. So if they are reporting having suicidal thoughts, you want to know how serious those thoughts are, how frequently they're having them. Are they having them every day, most of the day? Are they disturbing to them? You also want to know if they have a particular plan, what that plan is, and if they've taken steps towards executing that plan. It's also important to note if they have had a history of suicide attempts. And so taking a thorough history about previous suicide attempts is important. There are also other particular risk factors that make it more likely that a particular patient will act on suicidal thoughts. So having a family history of suicide, for example, we know there's a genetic basis for impulsively acting on suicidal thoughts. Also, there are other clinical factors that go along with a patient being more likely to act on suicidal thoughts.
Would that analysis be any different for a pregnant patient?
No, it would not.
In your experience, how would you determine if a patient is malingering?
That is a great question. And I will tell you that psychiatrists encounter patients who are malingering fairly frequently. And there are a number of ways that you can tell that someone is malingering. For example, a patient who comes in and lists the symptoms that are listed in the DSM verbatim is probably malingering. And in addition, our mental status exam is an important part of our diagnosis. So when I'm interviewing a patient, I'm seeing how they're interacting with me, whether they appear to be psychomotor retarded, whether their eyes look abnormal. So when someone's depressed, their eyes look kind of dead and non-reactive, and they look very different if they have psychotic symptoms or if they're manic. So I'm evaluating all of that when I'm interviewing someone. And I will say that with experience, I think most of the time, most psychiatrists can tell when someone's lying.
Can we pull up slide 1 again of the demonstrative? I'd like to turn to your first opinion. Your first opinion is that pregnancy may cause the onset, worsening, or recurrence of psychiatric conditions that may present with life or health endangering symptoms, and abortion can alleviate those symptoms. What is your basis for this opinion?
Well, my basis is my clinical experience, but also the literature surrounding pregnancy and psychiatric disorders.
What is the basis for your opinion that abortion can alleviate life and health-threatening psychiatric symptoms?
That's been my clinical experience in a small number of cases.
What are examples of life or health-endangering psychiatric symptoms?
So there are several. Perhaps the most obvious are suicidal thoughts and suicidal attempts or actions. Those can certainly lead to health complications, but also can lead to the end of life. Psychotic symptoms are another category. Psychotic symptoms include hallucinations and delusions, and really an altered sense of reality. And when someone is suffering from hallucinations and delusions, their behavior often becomes erratic, and they can act on the basis of those hallucinations and delusions in a way that is either very dangerous or can end one's life. So an example of that is someone may be paranoid, having paranoid delusions, believe someone's trying to harm them or chase them. They may run into traffic or jump into a body of water to escape that person who is not real. In addition, some people have hallucinations that tell them to hurt themselves or to do something that's very dangerous.
So let me take you back to suicidal ideation and self-harm. How can those pose risk to a pregnant patient's life or health?
So if a pregnant patient is having suicidal thoughts and she acts on them, that can certainly lead to health endangering problems. So if someone overdoses on medication because they're suicidal, that can lead to respiratory arrest and the need for CPR, for example. And even if she survives that attempt, she can be left with health consequences. And then obviously a suicide attempt can end the life of the pregnant patient as well as her fetus.
You mentioned psychosis and some ways in which psychosis can pose threats to a patient's life. Just to understand this, even if it's not a risk to a patient's life, how does psychosis pose a threat to a pregnant patient's health?
So if a pregnant patient is psychotic, that's changing her brain. And if it goes untreated or unremitted, it becomes harder and harder to treat. And this is true for most psychiatric disorders. It leads to changes in the brain that make it more treatment resistant. And therefore, a patient, let's say if she were pregnant and decided that she absolutely did not want medications during pregnancy, and continued to be ill for all of her pregnancy, she could have trouble becoming well again after pregnancy.
Is catatonia an example of a life or health endangering psychiatric symptom?
It is.
What is catatonia?
Catatonia is a psychiatric or neurologic syndrome that most people are not really aware of. It's when a patient tends to become very unresponsive to the environment. They stop talking, they stop eating, they stop drinking. They may posture in unusual ways. They may resist doing particular movements. Sometimes they will repeat things that they hear in the environment. But it's a very specific psychiatric neurological syndrome that we see very commonly in psychiatric patients. Estimates range from 10 to 20% of psychiatric inpatients will have some symptoms of catatonia. It's life-threatening, it's health-threatening, and it's...
Stop you there and ask, how is catatonia life or health-threatening?
Thanks. It's health-threatening because these patients stop moving and they stop eating and drinking, so they can become severely dehydrated, they can have effects on their blood pressure. I just saw a patient in the hospital whose blood pressure dropped extremely low because he was not eating or drinking. And because they're not moving, they can develop blood clots that can then become pulmonary emboli. There's also something called malignant catatonia, in which the autonomic nervous system becomes dysregulated, and those patients can develop really high blood pressure and lead to strokes.
How does a psychiatrist identify that a pregnant patient is experiencing one of these three psychiatric symptoms?
Well, it's based on your clinical interview, but also your clinical observations. It's usually fairly obvious when someone is having catatonic symptoms. Sometimes it's a little subtle, but most of the time it's pretty obvious. With psychotic symptoms, patients with psychotic symptoms appear to be psychotic. I mentioned the eyes. The eyes look different. They appear to be responding to internal stimuli, is the phrase that we use, which generally means that they're talking to themselves or appear to be responding to things that aren't there. If you ask a patient specific questions, like, is something unusual going on? Are you afraid of something? They will usually open up and tell you, well, the FBI is following me. Or, yes, absolutely, someone's trying to harm me. And so they'll tell you if they're having psychotic symptoms, but you also observe that they're having psychotic symptoms. With suicidal ideation, it is based on a clinical interview, but you also take into account their previous psychiatric history, whether they've had suicide attempts, whether they appear to be engaging in self-harm, and whether they have risk factors that put them at elevated risk of acting on those thoughts.
Given your training and experience, describe how psychiatrists approach the treatment of pregnant patients with psychiatric conditions.
So we approach the treatment of pregnant patients very similarly the way that we approach the treatment of patients who are not pregnant, but we keep in mind that the patient is pregnant. So that means that we try to limit the number of medications that we use, but use the minimal number to get that patient well. We don't accept that a patient should be, can be depressed during pregnancy and only treat her with one medication. If she needs two to get well, we'll use two. But we still try to minimize the number of exposures for the baby.
From your perspective as a psychiatrist, why can abortion be a recommended treatment for life-endangering psychiatric symptoms?
So there's a number of patients that I've seen who clearly had their psychiatric syndrome worsened or triggered by pregnancy. And we know, based on several research studies, that there's a subgroup of women who are sensitive to times of reproductive hormonal change. And in fact, my research has identified blood-based biomarkers of that sensitivity to reproductive hormonal change. And a small number of women who are sensitive to times of hormonal change will really become treatment resistant during pregnancy. So prior to pregnancy, their psychiatric disorder was well controlled, or perhaps they didn't even have a psychiatric disorder. But during pregnancy, they can develop really severe symptoms that impair their functioning significantly, and they develop health and life-threatening severe psychiatric symptoms that then do not respond to standard psychiatric care. In that setting, abortion care can alleviate their symptoms.
You mentioned that psychiatric illness can worsen or be triggered in pregnancy. Could you describe how pregnancy can cause the onset, recurrence, or worsening of a psychiatric condition?
Absolutely. So there are several different ways. One is that many women will stop their psychiatric medications for pregnancy. And they will do so because they think they're doing the best thing they can for the health of their baby. But unfortunately, there's a very high relapse rate with psychiatric disorders during pregnancy when psychiatric medications are stopped. So that's on the order of 70 to 100% of women will relapse with their psychiatric disorder when they stop psychiatric medications for pregnancy. Secondly, some women will continue their psychiatric medications for pregnancy, but up to a third of them will relapse with their psychiatric illness anyway. And we think that is because metabolism really changes during pregnancy, so your liver revs up and you metabolize drugs in a very different way. And in addition, a woman's blood volume doubles during the course of pregnancy. And so the blood level of a particular psychiatric medication tends to drop across the course of pregnancy, and that can trigger a relapse in women with their psychiatric symptoms. And then finally, I've already mentioned being sensitive to times of hormonal change. It's pretty clear that some women develop psychiatric syndromes in the setting of reproductive hormonal changes.
Dr. Payne, can you provide an example from your clinical experience of a patient, how pregnancy can trigger the onset of a psychiatric condition?
Sure. So I had one patient who prior to pregnancy had never had depression and never had anxiety. And when she became pregnant for the first time, she developed very severe depression, very severe anxiety. She also developed restless leg syndrome, which probably was a marker for sensitivity to the rising progesterone levels across pregnancy. She really suffered through that pregnancy, but decided not to seek abortion care. However, after she delivered her child, those symptoms got better and much more easily treated. She then decided to not have more children. They had originally wanted to have at least 2 children, and she never had another pregnancy. She did, however, develop psychiatric symptoms again when she was started on some hormonal birth control and when she went through perimenopause, which I think was really showing us that she was sensitive to those hormonal changes that she experienced during pregnancy.
You mentioned earlier that some pregnant patients with diagnosed psychiatric conditions will stop taking their medications.
That's right.
In your experience, why are they doing so?
They are doing so because they have the idea that the exposure to the psychiatric medications will be dangerous in some way for the developing fetus. And many times their doctors, like their OB-GYNs, have told them to stop their medications. The reality, though, is that if you review the literature, it's extremely clear that being psychiatrically ill during pregnancy is associated with negative pregnancy outcomes, including preterm birth, low birth weight, C-section, preeclampsia, and even other complications.
What are other potential health implications of psychiatric relapse during pregnancy?
Well, when a woman, particularly if a woman has stopped her psychiatric medications, one of the things that we know in psychiatry is that when patients stop their psychiatric medications, either because of pregnancy or whether because they're feeling well and think they don't need them anymore, those psychiatric medications may not work as well the second time around. And we think that's because there are adaptive changes in the central nervous system when patients come off their psychiatric medications. So the literature is pretty clear that if you've had two depressive episodes, for example, that you really need to stay on an antidepressant for the rest of your life in order to minimize the number of times you have future depressive episodes.
Have you had at least one pregnant patient who experienced these health implications?
I have.
Would you please describe the health implications of psychiatric relapse for that pregnant patient?
Sure. So I have a patient who I continue to follow to this day who has a bipolar type illness. And before I started managing her, she developed a major depressive episode during every one of her pregnancies. And each subsequent pregnancy, that depressive episode got more serious. And also during her pregnancy, no matter what her doctor was prescribing for her, she really could not come out of that major depressive episode. And during her third pregnancy, she had such a severe depressive episode that she was really not functioning. She was suicidal. And she elected to seek abortion care so that she could care for her other two children more effectively. That did alleviate the major depressive episode. I managed her during her fourth pregnancy, and it was a battle. And we used a combination of medications as well as something called repetitive transcranial magnetic stimulation, which really required a lot of effort on her part. You have to get daily treatments for a while. And she's a physician. Today, she is, I will say, fairly treatment resistant. And I can't help but wonder if the fact that she really had repeated episodes of depression during pregnancy that really were not responsive to medications was a marker for the later treatment resistance of her mood disorder.
If a patient presents to an emergency room exhibiting life-threatening psychiatric symptoms, is abortion an appropriate emergency treatment for the patient's psychiatric condition?
Not in the emergency room.
Would you explain why that is?
Absolutely. So that is because really these patients need to be formulated, and you need to understand exactly what's going on with them. A patient can present to the emergency room with life-threatening psychiatric symptoms because they've stopped their psychiatric medications, in which case you'd want to restart their psychiatric medications. So it really takes formulating the case and then trying to treat the psychiatric symptoms to see if you can get them better. In the setting of a patient whose symptoms were clearly triggered or worsened by pregnancy, who then is suffering from treatment resistance, not responding to standard psychiatric care, that's when abortion care should be on the table. And then it's really up to the patient to decide what path she wants to take.
Let's turn to your next opinion regarding teratogenic medications and the patients who require them to treat a psychiatric condition. If we could pull up slide 1 again. Just briefly, remind the court of your second opinion.
My second opinion is that some patients with psychiatric disorders require the use of teratogenic medications, and they should not be excluded from abortion care when that care is appropriate.
And what is the basis for your opinion?
The basis is my clinical experience.
What is a teratogenic medication?
A teratogenic medication is a medication that, when taken during pregnancy, has a high likelihood of causing major organ malformation or other syndrome.
And what are some examples of teratogenic medications used in psychiatry?
The most common ones are valproic acid and carbamazepine.
In your clinical experience, if these two medications are known to be teratogenic, how does a woman of childbearing age come to be taking one of them?
Well, I would say that there are 3 different ways that happens. First of all, Many women will have tried these are typically mood stabilizing medications, and they're used in bipolar disorder and schizoaffective disorder. And a woman may have tried other types of mood stabilizing medications and failed them, in which case there really is no choice if they respond to valproic acid or carbamazepine to continue them on those medications. A second way that patients come to be on them is that a woman may have experienced mania with psychosis and ended up on an inpatient hospital setting. Valproic acid and carbamazepine work beautifully for an acute manic episode. And so they may have been started on them by the inpatient psychiatrist with the idea that once they were stabilized, they would be switched to a different medication that isn't teratogenic. In addition, unfortunately, some doctors still do not understand that those two medications are teratogenic and really should be used as a last resort in patients of childbearing age.
For patients who require one of these teratogenic medications, what are the potential risks to their life or health from becoming pregnant?
So if they become pregnant while taking one of these medications, their fetus can develop life-threatening major organ malformations. And continuing a pregnancy in that setting then increases risks to the mother's health and even life by going through with the entire pregnancy and delivery.
Do some patients, after becoming pregnant, stop taking these medications?
Some do, and that's always very dicey because it is likely that they will relapse with their psychiatric disorder and then suffer from having that active psychiatric disorder, which can include health and life-threatening psychiatric symptoms.
Have you had at least one patient who experienced these risks to their life or health from becoming pregnant?
I have.
Would you please describe an example from your clinical experience of a patient who required a teratogenic medication and for whom abortion was necessary?
Sure. So the most recent one was about a year ago, and I was supervising a resident taking care of a patient who had recently been inpatient with a manic episode with psychosis and had been started on valproic acid. She then transitioned to the outpatient setting. They had started talking about switching her to a different mood stabilizing medication when she found out that she was unexpectedly pregnant. She initially decided to continue the pregnancy. However, ultrasound revealed that the baby had anencephaly, which is when the brain does not form. And she then elected to have abortion care in order to avoid potential pregnancy complications associated with that condition.
Is there a reason why a pregnant patient can't simply switch from taking one teratogenic medication to a non-teratogenic medication?
So again, many of these patients are on a teratogenic medication because that's what works for them. And so switching them to a medication that they failed in the past makes very little sense because they will simply relapse with their psychiatric illness. In addition, even if a woman has not had trials of other non-teratogenic medications, switching is often complicated, particularly in pregnancy, as metabolism revs up and blood volume starts to increase. And so switching to a different medication often leads to relapse of the psychiatric condition.
And what are the health implications of psychiatric relapse in that scenario?
So if a woman becomes extremely ill and develops, health and life-threatening psychiatric symptoms such as suicidal ideation, psychotic symptoms, or even catatonia, those can affect her health and life.
Let's turn to your third and last opinion. Would you please state for the court again your third opinion?
Sure. So there's the first part is that the language of the medical exceptions for the abortion bans is both unclear and narrow, and excludes women who are having suicidal thoughts. And in my opinion, not having clear medical exceptions to the abortion ban, including exceptions for mental health conditions, will lead to an increase in mortality and morbidity from psychiatric conditions in pregnant women in Idaho.
Have you reviewed the total abortion ban, Dr. Payne?
I have.
Have you reviewed the 6-week ban?
I have.
In your professional opinion, do these laws use medical language?
No.
I'd like to direct your attention to the total abortion ban. If you'd open your binder again to your slides, this is slide 2. What is slide 2?
Slide 2 is focused on the medical exceptions to the abortion bans and is divided into the total ban and the 6-week ban.
And it looks like this is a little bit late, Your Honor, but permission to publish slide 2.
That's fine.
Thank you.
I'd like to direct your attention to the language in the total abortion ban that says, no abortion shall be deemed necessary to prevent the death of the pregnant woman because the physician believes that the woman may or will take action to harm herself. What do you understand the effect of that language to be?
In my opinion, the effect of that is to really ban abortion care for women with psychiatric conditions with serious health and life-threatening psychiatric symptoms.
As a psychiatrist, what is your understanding of the phrase, the woman may take action to harm herself?
That the symptoms that she's experiencing may include suicidal ideation, but could also include other types of psychiatric symptoms.
Based on your experience as a psychiatrist, what is your opinion of this carve-out to the exception for self-harm?
Yeah, I think it's a carve-out for mental health conditions across the board. I think most physicians are going to read that exception as abortion care is not available on the basis of severe, life-threatening, health-threatening psychiatric symptoms.
Are you aware of the criticism that removing this carve-out from the law would allow anyone who walks into a hospital to receive an abortion?
I'm aware of that.
What is your response to such criticism?
That, appropriate psychiatric evaluation can really tell the difference between someone who is malingering for a particular outcome and someone who is not. We do this routinely in the emergency room on a daily basis. There are patients who present to the emergency room for what we call 3 hots and a cot because they are homeless or going through a tough time in their life. And they will initially say that they are suicidal. But taking a thorough history, spending time with them, really trying to understand what the basis of their problems is, that suicidal ideation usually becomes clear as either malingering or they will even admit that they are not actually suicidal. I think that mental health professionals can tell the difference between those two situations.
Have you ever raised abortion as a treatment option to a pregnant patient who says they are suicidal?
I have. I will say it's been rare. But certainly my job as a psychiatrist is when I evaluate a patient and I understand their psychiatric condition, I go over what their treatment options are. And if I think that pregnancy is worsening their psychiatric symptoms and condition, and that undergoing abortion care might make it easier to get their symptoms under control, I will discuss whether that's an option for them or not.
I'd like to direct your attention now to the total abortion ban again, but it's language that abortion is permitted if it is necessary to prevent the death of the pregnant woman. Setting aside suicide and self-harm, do you have an opinion as to how this language applies to life or health-endangering psychiatric symptoms?
I think as a psychiatrist, it's very clear to me that psychotic symptoms and catatonia are both life and health threatening symptoms for psychiatric patients. I think for your average physician, it is not as obvious. And I think that abortion care will not necessarily be offered in the setting of psychosis or catatonia.
In your work, do you interact with physicians who do not specialize in psychiatry regarding the treatment of pregnant patients with mental health conditions?
I do on a daily basis.
And what is your understanding of the broader medical community's understanding of mental health conditions?
They are limited. Some individuals have better understandings than others, but on average, even physicians in the Johns Hopkins emergency room don't have a great understanding of psychiatric conditions and how serious and life-threatening they can be.
Are you clear whether or not, as a psychiatrist, catatonia and psychosis qualify under the exception?
I am not clear if they do or not.
Why are you not clear?
Well, certainly they're not listed as potential exceptions to the abortion ban. I think I can make an argument that they are life-threatening in certain situations. But I think your average clinician would not have a sophisticated understanding of that and be able to make that recommendation.
Based on your clinical experience, if I told you that there was no immediacy requirement and that medical certainty is not required, would that clear up any of your confusion?
Not for psychiatric symptoms. I think, again, psychiatric symptoms are not necessarily thought of as life-threatening or health-threatening. In addition, in the total abortion ban, it clearly says that no physician can deliver abortion care in the setting of thinking that a woman may or will take her own life. And I think for most physicians, that's going to eliminate psychiatric conditions as reasons for abortion care.
Briefly turning to the 6-week ban, I want to focus you on the language substantial and irreversible impairment of a major bodily function. Based on your professional experience, do you have an opinion as to whether psychosis or catatonia fall within that exception?
In my opinion, and I think if you read the research on exactly what happens in the central nervous system with catatonia and with psychotic symptoms, they do fall underneath that. But again, I think your average clinician is not necessarily going to know that literature.
In your view, can untreated psychiatric illness risk substantial and irreversible impairment of brain functioning?
Absolutely. So we know that when psychiatric symptoms go on for a long period of time, they become more and more difficult to treat. We occasionally see a patient who has been depressed for 10 or 15 years and never sought treatment. And getting them well is very difficult because their brain, even though our brains are plastic, they change all the time. But when they've been in a particular state for a while, it's very hard to move the brain out of that state. And that's what we see with ongoing untreated psychiatric illness.
In your experience, can untreated psychiatric illness impact the length of a patient's lifespan?
Absolutely. The literature clearly shows that. So patients with depression, particularly with recurrent bouts, have a shortened lifespan. We know that if patients have cancer and depression, their risk of dying from that cancer is twice the rate of patients with the exact same cancer in the same stage who don't have depression. Depression is an inflammatory response in the body, and it definitely increases the risk of death.
We also talked today about patients who require teratogenic medications to treat mental health conditions. Do you have an understanding of whether such patients can access abortion care in Idaho?
Again, I think it's unclear, particularly because of the carve-out exception for women presenting with suicidal thoughts. I think many clinicians will err on the side of, well, you can't have an abortion because you're on a teratogenic medication for a psychiatric condition.
I want to turn to the last part of your third opinion, that the narrowness and lack of clarity of the medical exceptions will increase maternal mortality and morbidity in Idaho. In your opinion, are there impacts from Idaho's abortion bans on pregnant patients with psychiatric disorders?
Yes, I think
Let me stop you there. What are those impacts?
I think the impacts are because of that mental illness, the suicidal ideation carve-out. I think patients with psychiatric conditions, with life-threatening and health-threatening psychiatric symptoms, will not be able to access abortion care. And we know that the number one cause of maternal mortality in Idaho, and quite frankly, the United States, are mental health conditions. And if patients who are pregnant who have psychiatric symptoms with life-threatening symptoms are not able to access abortion care in Idaho, I think it's an easy understanding that that will increase the mortality rate in Idaho.
And what is the basis for your opinion that the ban on abortion for patients who exhibit suicidality or self-harm will increase maternal mortality and morbidity in Idaho?
Well, we know that the number one cause of maternal mortality in Idaho is our mental health conditions, with suicide being the number one outcome that led to death.
Have you reviewed data from Idaho on pregnancy-related deaths due to mental health conditions?
I have.
And what was that data?
Well, the data was the Maternal Mortality Committee's report and their decisions paperwork.
Do you have an opinion on what impact Idaho's abortion bans will have absent a medical exception for self-harm and suicide or other psychiatric symptoms?
I think it will increase the mortality rate in patients who are pregnant and have psychiatric conditions.
Thank you, Dr. Payne. Your Honor, pass the witness.
All right. Thank you, Mr. Cabot. Cross-examination, Mr. Grigsby.
Good afternoon, Dr. Payne.
Hi.
It is your position that no psychiatric patient, regardless of condition, should be categorically excluded from obtaining an abortion, correct?
I don't believe that's what I said.
You recall taking a deposition in this case?
I do.
Okay. Provide this. It would be tab 18 in the binder. Yeah. This is Defendant's Exhibit 1028.
What page and line is it?
It will be page 88, lines 11 through 20.
I'm sorry, you said tab 18?
Tab 28.
Okay. And page 80?
Yeah, there's 4 pages shown in the condensed transcript per page, and it would be page 88, line 11.
Yes.
Can you read page 88, starting in line 11, and then going to line 20?
Okay. So, question, it shouldn't be withheld, in your opinion, categorically for those with a bipolar disorder. Is that correct? Mr. Cabot, objection vague. The witness, I don't think that abortion should be withheld categorically from psychiatric patients. Question by Mr. Grigsby, with bipolar disorder. Answer, with bipolar disorder and other psychiatric conditions.
Thank you. Dr. Payne, you agree that each pregnancy is unique?
I do.
And physicians must make complex, individualized determinations as to how to treat a pregnant woman based on each patient's particular circumstances?
I do.
What is an emergent medical condition?
I would define an emergent medical condition as a medical condition leading to urgent or emergency care.
You have not personally performed any abortions, correct?
Correct.
Your typical practice is not to instruct patients to have an abortion, correct?
Correct. I may talk to them about abortion as an option, but I never instruct someone to have an abortion.
Okay. I was asking a yes or no question there. Your typical practice is not to instruct patients to have an abortion, correct?
Correct.
Do you recall your expert report in this case, an earlier testimony, discussed some psychiatric patients taking teratogenic medications?
I do.
For at least some patients taking teratogenic medications, they could switch to a different medication, correct?
It could be attempted for some.
And a change of dosage can help at least some women better manage their symptoms.
I'm sorry, I find that vague. A change in dosage could be increased, decreased, what medication? I don't know how to answer that.
Okay. A change of dosage of teratogenic medication can help at least some women better manage their symptoms, correct?
Again, change in dosage, if you could define.
Okay. A change of dosage, whether increasing or decreasing.
Well, it would really depend on the patient and the symptomatology and the teratogenic medication and whether they had a therapeutic blood level or not.
Okay, and my question is that this change of dosage can help at least some women better manage their symptoms, correct?
I'm sorry, I don't think I can say that without having a specific example. A change in dosage could also destabilize some women, and sometimes we need to increase a dose because the dosage is subtherapeutic, and it would also depend on if a woman was partially responsive to the medication.
Okay. Can you turn to page 75 in the deposition that we just looked at and read lines 10 to 17?
So this was in a context, but I
can
will
you
read it.
those
So a
lines?
change of dosage for some women can help them better manage their symptoms. To be clear, some women on psychiatric medications don't need to increase their dose. But if they become ill during pregnancy, for some of them, increasing the dose will be helpful.
Thank you. There is no one best psychiatric medication for a particular condition, correct?
For a particular psychiatric illness, no.
Most of the time, if a psychiatric patient is not comfortable taking a certain medication, she could take other medications, correct?
Again, I find that really vague. I think it really depends on the psychiatric condition, her history, whether she's taken all the other medications available, et cetera.
So you would not agree that most of the time a psychiatric patient who's not comfortable taking a certain medication could take another medication?
I would say,
Objection, Your Honor, vague and asked and answered.
Overruled. You can answer.
I would say it's possible.
Okay. Can you turn to page 76?
Yes.
And read from lines 12 to 15.
Question, and there are certain medications that if a woman is not comfortable taking a certain medication, in some situations they could take other medications. Most of the time that's the case.
Thank you. Some women elect to stop taking medication during pregnancy.
Was there a question?
It's a question.
guess it was kind of a
Kind of a statement.
declarative with an implied question mark perhaps at the end. If you just restate it, please.
Yes, sir. Some women elect to stop taking medication during pregnancy.
Correct.
In your understanding, pregnant women usually decide not to take psychiatric medications out of a concern that the medication may harm their baby, correct?
I would say on average that's true.
That's usually the case.
On average, that's true.
Psychiatric hospitalization is often a treatment option for severely ill pregnant patients, correct?
It's an option for all severely ill psychiatrically patients if they are identified.
So is that yes? You agree?
If they come to psychiatric attention, yes.
When you look at group prevalence rates, the risk of psychiatric disorders does not increase during pregnancy, correct?
That's right, on average.
Isn't it true that for some mental health issues, symptoms improve during pregnancy?
Occasionally, we will have a patient whose psychiatric symptoms will improve during pregnancy.
You would agree that clinical risk assessment requires an individualized assessment encompassing many factors?
I would agree with that.
And you would agree that this goes beyond the formulation of a DSM diagnosis in the scope of the DSM manual?
I would agree with that.
You are aware Solicitor General Elizabeth Prelogger argued for the United States in the Moyle versus United States Intala Supreme Court case?
I am vaguely aware of that. I'm not sure who argued it, and I did not follow that closely.
You are aware that the United States government took a position on informed consent for psychiatric patients in the case?
Objection, Your Honor. This is outside the scope of her direct.
It is, but I guess I'm not sure where this leads. Where does this lead?
Your Honor, she testified during direct examination regarding treatment for psychiatric patients in emergency situations, and the statement is directly on point to that. Further, if she took a position that was against what the United States government was arguing in this case, it would affect her credibility.
All right, I'm going to sustain the objection. You can move on.
Can I have a moment, Your Honor?
That's fine, Mr. Grigsby.
Nothing further, Your Honor.
Okay, thank you, Mr. Grigsby. Any redirect, Mr. Cabot?
Nothing further, Your Honor.
All right, thank you for being here, Dr. Payne. You may step down. Just a few minutes left of our court day. I'm unsure what there is left of the plaintiff's case in chief.
Right, Your Honor. We have two witnesses that remain in our case in chief, and they're both state employees, and I don't anticipate they're going to be take up much time, and I think get through them efficiently in the morning.
All right.
Unless the court wishes to stay after 5, which I don't imagine you do.
I think probably I might be in the minority of people in the room if I were willing to do that. So I'm probably disinclined to do that. So you're looking at what, perhaps an hour of testimony tomorrow, something like that?
Yes, sir.
All right, and tomorrow sounds like maybe not quite an entire day available for the defense case tomorrow. What?
I think that's probably accurate. And Your Honor, I'd note that plaintiffs have now asked at least one of the state employees to come on 2 different occasions to come and sit out there for several hours. So if there's any way we could get through the witnesses today, I'm sure they would appreciate it so they don't have to come back again.
Well, it's a matter of, I guess, asking a whole lot of other people who are employed by the government to stay.
I understand,
that's
Your
the
Honor.
problem. That's the problem. And if you were to tell me we're going to roll through this and be done at 5:15 or 5:20 or something, that'd be one thing. I'd probably be willing to do that. If what you're telling me is we're going to be here at 6 o'clock still, then I think we're beyond.
I totally understand, and I don't know how long it'll take. It's their witness, but they've now inconvenienced that witness on 2 different occasions.
Yeah, and I will say, Your Honor, I mean, we've been very communicative with counsel about scheduling and bringing these witnesses over at a time where they wouldn't have to sit here for a long period of time. And we can't control how long, for example, his cross of Professor Withicom lasted. So we're ready to proceed. I mean, we could call a shorter witness right now and minimize the inconvenience to her. But I also recognize you have staff here, so.
How long's the shorter one going to take?
So 15, 20 minutes?
Let's get one. Let's try to get one done at least, and then we'll take stock of where we are. Go ahead and call your next witness.
Your Honor, plaintiff's call Jennifer Liposhak.
Good afternoon,
Yes.
Ms. Liposhak?
Yes.
All right. Go ahead, Mr. Cabot.
Your Honor, permission to treat this witness as adverse under Idaho Rule of Evidence 611.
Well, let's why don't you just go ahead and we'll see whether any leading questions elicit an objection.
Okay. Ms. Liposhak, please state your name and spell it for the record.
It's Jennifer Ann Liposhak, JenniferAnnLiposchak.
Who do you work for?
I work for the Department of Health and Welfare in the Division of Public Health.
And what is your role?
So I'm the Women and Infant Health Program Manager in the Maternal and Child Health section.
How long have you been in that role for?
I've been in this role for just over 3 years.
Since October 2021?
That's correct.
What do you focus on in your current role?
So currently, I'm focused on our Title V Maternal and Child Health Block Grant, so the administration of that grant, and then really focused on our priorities and initiatives in our state action plan related to women, maternal infant health, and our child health domain.
When you started in your current role, your responsibilities included oversight of the Maternal Mortality Review Committee program. Is that correct?
That's correct.
Is it okay if I call it the MMRC program?
Yes.
At the time, the Department of Health and Welfare ran the MMRC program, correct?
Yes.
And to object, none of the information from the MMRC is relevant to their claims.
Okay, understood, and I'll overrule the objection. You can have a continuing objection along that line during the testimony of this witness. There was a similar objection during the testimony of Dr. Payne, and some evidence along those lines was admitted. You may continue.
The MMRC program was established in 2019, correct?
That's correct.
The MMRC program sunset, correct?
Yes.
Did you stop overseeing the MMRC program after it sunset?
Yes.
When did the MMRC program sunset?
July 1st, 2023.
Elke Shaw-Tulloch is the administrator of the Division of Public Health, is that right?
That's correct.
And you've worked closely with Ms. Shaw-Tulloch?
I'd say we started working closely during the 2023 legislative session.
And what did you work with Ms. Shaw-Tulloch on?
So that's when we were working to remove the sunset date that was in the current statute that established the MMRC.
And if she had a question about an MMRC report, she would reach out to you and ask you, is that right?
Yes.
Let's turn to discuss that MMRC program. An MMRC is a committee typically made up of healthcare professionals that review pregnancy-associated deaths. Is that right?
Yes, typically. The positions on the Idaho MMRC committee were outlined in the statute.
A pregnancy-associated death is the death of a woman during pregnancy or up to a year after pregnancy, regardless of the outcome, correct?
That's correct.
During your time working with the Idaho MMRC, you were lead in working with the program, correct?
So I was the program manager, so really overseeing the administrative responsibilities, convening the group, requesting records, really putting the report together, but none of the case review and decision making, that all fell on the committee members.
You attended meetings of the MMRC?
Yes.
And you took notes at those meetings?
I assisted with filling out the decision form that the committee completes for each case, and that's provided by the CDC, or the Centers for Disease Control.
The MMRC reviewed all maternal deaths occurring in Idaho, correct?
Yes, we decided that it was best practice to review all pregnancy-associated deaths, as you just defined it.
Idaho's MMRC would determine if each death that was pregnancy-associated was pregnancy-related. Is that correct?
That's correct.
What does pregnancy-related mean?
So that was determined by the committee members. So they would determine that the pregnancy, ultimately contributed to the death of the woman in some way.
Idaho's MMRC also would determine if a maternal death was preventable. Do I have that right?
That's correct. Every pregnancy-associated death, the committee determined if there was some means of preventability.
And the MMRC's findings would be represented in a report, annual report. Is that correct?
That's correct.
When you worked with the MMRC, it was legislatively required to produce a report every year, correct?
Yes.
You wrote the reports for the 2020 and 2021 annual reports, correct?
Yes.
There are also reports for 2018 and 2019 maternal deaths, correct?
Yes.
But no reports on deaths in 2022?
Not currently, no.
And no reports on deaths that occurred in 2023?
Not currently, no.
Each of these MMRC reports was published on your department's website, correct?
Yes.
And each report is still available on the department's website?
Yes.
And you're familiar with each of these MMRC reports, correct?
Yes, there's a lot of information in those reports.
So why don't we turn to discuss the reports? I would like to turn your attention to tab 1 in your binder. This is Plaintiff's Exhibit 584. It was admitted into evidence during Dr. Payne's testimony earlier. You wrote the contents of the 2021 MMRC report, correct?
Yes, so yeah, writing and then really just displaying the decisions that the MMRC committee made and then the data that we requested from Vital Records and Health Statistics.
Okay. For efficiency's sake, I want to go through each of these reports and then I'll come back. So if you could flip to page 2 of your binder. This is pre-marked Exhibit 583. You recognize what has been marked as Plaintiff's Exhibit 583, yes?
Yes.
What is it?
This is the report on 2022 maternal deaths in Idaho.
You worked on the 2020 maternal deaths in Idaho report?
That's correct.
You wrote the contents?
Yes.
And the report is published on the department's website, correct?
Yes.
At this time, plaintiffs offer Exhibit 583.
Other than relevance, any objection, Mr. Craig?
Just relevance, Your Honor, thank you.
Exhibit 583 is admitted.
And that's the only objection I'll have to the remaining reports as well.
All right, understood.
Your Honor,
Well,
I
perhaps you
move
just
that-
simply want to offer them then.
Move to offer into evidence Exhibit 585 and 586.
All right, Mr. Craig's relevance objections are overruled. They are admitted into evidence as well.
I'd like to turn your attention back to the 2021 MMRC report. This was tab 1. If you could turn to page 7 of the report. And if you look at the bottom, there are numbers that say, 0.0007 or 007. Under the first header, key findings for 2021, the first bullet point says 17 women died in Idaho while pregnant or within 1 year of pregnancy. 16 of these deaths were reviewed by the MMRC. Did I read that correctly?
Yes.
The next bullet point says 15 deaths were determined to be preventable. Is that correct?
That's correct.
I'll object. The court can read through these reports and doesn't need Ms. Whippet.
All right. Well, that's certainly true as a general matter, but I assume you're going to be quite quick in hitting the highlights.
Your Honor, these are long reports. I'm trying to call your attention to the important points.
All right.
I want to direct your attention now. Oh, let me step back for a second. So 15 out of the 16 deaths that the MMRC reviewed were preventable, correct?
Yes.
I want to direct your attention now to page 19. The title is Pregnancy-Related Mortality Ratio. Do you see that?
Yes.
The pregnancy-related mortality ratio is a calculation of the number of pregnancy-related deaths per 100,000 live births, correct?
That's correct.
In the second paragraph on this page, it reads, pregnancy-related deaths in Idaho have also been increasing. Is that correct? This is, if you look at the second paragraph, and it's the second sentence in that paragraph.
Okay, yes, I see that. Thank you. Yes, it does say that.
It continues to say the 5-year average of Idaho's PRMR, that is pregnancy-related mortality ratio, correct?
Mm-hmm.
From 2003 to 2007 and to 2017 to 2021 increased by 41.8%, from 20.6 to 29.2 respectively. Is that correct?
That's correct.
The MMRC determined that nearly all pregnancy-related deaths between 2018 and 2021 were preventable, correct?
That's correct.
I want to turn to statistics in Appendix A to this 2021 MMRC report that compare 2018, 2019, 2020, and 2021. Please turn to page 50. Figure 24 shows the underlying cause of death for all pregnancy-related deaths from 2018 to 2021, correct?
That's correct.
The first leading underlying cause of death is mental health conditions, correct?
That's correct.
The second is infection, correct?
That's correct.
And the third is cardiovascular conditions.
Yes.
I want to turn briefly to deaths that occurred in 2022. If you would turn to page 41 of this 2021 report. The 2021 report contains a preliminary review of deaths that occurred in 2022, correct?
That's correct.
The second sentence on page 41 says, "This brief information was gathered from a limited number of records, which were only reviewed by the MMR program. There will not be an opportunity for a full review by the MMRC." Did I read that correctly?
Yes.
There was no opportunity for a full review of 2022 deaths because the program sunset. Is that right?
That's correct. But the new MMRC could choose to go back and review deaths occurring in 2022.
In your knowledge, have they done so?
No, not to my knowledge.
The next paragraph under header preliminary findings explains that there were 10 pregnancy-associated deaths after a preliminary review, correct?
That's correct.
The last sentence says, "For 8 of the cases, the woman was pregnant at the time of death."
That's correct, as indicated on the death certificate.
That is, 8 out of the 10 maternal deaths in 2022 happened while the woman was pregnant. Is that correct?
Yes, for the records that we had at the time.
Now, this is an unusually high percentage of deaths occurring in pregnancy than in the previous 4 years.
Objection, foundation, lack of personal knowledge.
Your Honor, she was running the MMRC program and was involved in writing this report.
Comparison of data in this report to data in prior reports. You can answer.
I'd have to go back and look at comparing the years, but that does seem to be relatively high compared to the years that we reviewed, yes.
We can very quickly do this. Turn to page 49 of the report.
How about let's not? If it
Okay.
empirically shows what you're saying,
It
you
does.
can point it out in your proposed findings and conclusions.
Okay. So let's turn to the effect of the MMRC sunset. For context, the MMRC sunset, as you said, on July 1st, 2023, correct? Yes. And the last MMRC report is the 2021 report that we just spoke about. Please open your binder to tab 5. This is pre-marked exhibit 226. You recognize exhibit 226, correct?
Yes.
It's an email chain between you and Greg Stahl and Elke Shaw Tulloch, correct?
That's correct.
Who is Greg Stahl?
Greg Stahl is our public information officer at the Department of Health and Welfare.
And the subject is KTVB Inquiry RE MMRC, correct?
Yes.
And responding to media inquiries is a part of your job, correct?
Yes, they typically go through our PIO and then we're asked to provide information or answer questions.
There's an attachment to the email. The parties have stipulated to authenticity. It's pages 3 and 4 of this exhibit. This is a response you drafted to questions from KTVB, correct?
Yes.
At this time, plaintiffs offer exhibit 226.
Objection, hearsay, relevance.
Your Honor, this is a statement of a party opponent. She is a state employee. This answers within the scope of her responsibilities, and she's making comments to the media on behalf of the department.
Neither Ms. Lipashek nor the Idaho Department of Health and Welfare are parties to this lawsuit. It's not a statement of a party opponent.
Question of whether as an estate employee, Ms. Lipashek's statements are attributable to the party, and so 801D to D. I suppose that is what you're relying on, statements made by the party's agent or employee on a matter within the scope of the relationship and while it existed.
Yes.
Seem to apply. I'll overrule the objection. I'll admit exhibit 226.
Please turn to page 4. There's a question titled, "How are we tracking the health of mothers without the MMRC and any increased risk posed by abortion laws?" Do you see that?
Yes.
The first line of the second paragraph says, "Without in-depth case reviews of maternal deaths or the collection of severe maternal morbidity data from hospital discharge data, it may be difficult to directly point to Idaho's abortion law as cause for an adverse maternal health outcome. Did I read that correctly?
Yes.
Would you please turn back to the 2021 MMRC report? And this is page 44. At the bottom of the page, under the heading Cause of Death, it reads, the third sentence, starting with the third sentence, of note, 6 of the cases had a cause of death related to pregnancy, childbirth, and the periperium, and none of the 10 deaths had an underlying or immediate cause of death related to mental health, suicide, or substance use disorder. It continues, the latter is different from findings from the previous 4 years of maternal death reviews and reinforces the need for the Idaho MMRC to continue to monitor the causes of maternal death in Idaho. Did I read that correctly?
Yes.
The preliminary review identified a different pattern for cause of death than in any of the previous 4 years. Do I understand that correctly?
So I had just noted that on the death certificates, that underlying cause of death, again, did not have any attributes to mental health or suicide or substance use disorder, which, as you pointed out earlier, was the main underlying cause of death in the previous years.
And the anomalous data for 2022 could be linked to abortion bans, the abortion bans we talk about, or not. But there's no MMRC report that can say that one way or the other, correct?
That's correct. Without in-depth case review, we just can go off what's on the death certificate.
Speculating as to what the data may or may not show.
Your Honor, I think I'm pointing out that, based on what she said, drawing the connection between those two issues.
Go ahead.
And you're unable to draw a link because the MMRC program sunset, correct?
I guess, yes, we are, but the new MMRC could go back and review cases.
Okay. In 2024, let's talk about that new MMRC. Idaho passed a new law creating an MMRC program in 2024, correct?
That's correct.
And the new MMRC law took effect on June 30th, 2024, correct?
That's correct.
The new MMRC is overseen by the Board of Medicine, is that right?
That's correct.
You don't have a role with the new MMRC, correct?
I do not know.
Your department doesn't have a role with the new MMRC?
We do not know.
The new MMRC has not issued a report, correct?
That's correct.
The new MMRC has not requested data from your department on maternal deaths in 2022, correct?
I don't know, because they could have requested records from vital records and health statistics.
But not to your knowledge?
Not to my knowledge, no.
You expressed interest in working for the new MMRC, is that right?
Yes, I did.
Your application was denied, correct?
That's correct.
What is your understanding of why you were not asked to be involved in the new MMRC?
I don't know the full reasons.
Please turn to pages 2 and 3 of the 2021 report. This is tab 1 again. Pages 2 and 3 list the members of the MMRC at the time that the program sunset, correct?
That's correct.
It is your understanding that at least some of the physicians here have asked to serve in the new MMRC, correct?
The only person I'm aware of is Dr. Magni Hamso. She's the Medicaid medical director.
What about Dr. Stacy Seib? Has Dr. Stacy Seib asked to serve in the new MMRC?
He is not, no.
Let's turn to, okay. Do you remember that that you attended a deposition in this case?
Yes.
And that occurred on October 23rd of this year?
Yes.
Quickly do this. If you would just turn your attention to page 95 of, this is the transcript of your deposition. Line 4, you mentioned Dr. Stacy Seib, who is chair of the old MMRC. Is he on the new MMRC? You answered, he is not. Question, did he ask to be on the new MMRC? Answer, I believe so, yes. It is your understanding that, no further questions, Your Honor.
All right. Thank you, Mr. Cabot. Any cross?
No, Your Honor.
All right. Thank you for being here. You may step down. All right.
I think I kept my promise, Your Honor.
Well, I think we were in the ballpark of number of minutes in the low 20s or something like that. And unless the other witness is going to work out to be shorter, then it would be my preference, I think, to call it a halt. At least the other witness has the certainty of knowing that she is up first tomorrow morning and will be done.
So I hesitate to say this, but she will be shorter. But I defer to the court, Your Honor. We're glad to wrap it up for the day. But as counsel points out, she has been here twice.
All right. So are you likely to cross this witness? I don't know that you know what's going to be asked. But
I don't know what's going to be asked. There may be 2 or 3 questions that I have for her, but I don't know, again, what they're going to ask.
All right. Let's get it done. Go ahead.
Yes. Your Honor, plaintiff's call Elke Shaw Tulloch can stand.
Hello, Ms. Shaw Tulloch.
Yes, thank you.
All right. Go ahead, Mr. Cabot.
Ms. Shaw Tulloch, please state and spell your name for the record.
Yes, Elke Shaw Tulloch. It's E-L-K-E. The last name is S-H-A-W-T-U-L-L-O-C-H.
Where do you work?
The Idaho Department of Health and Welfare.
And what is your position?
I'm the administrator for the Division of Public Health.
How long have you worked in the Division of Public Health?
In the division, 28 years.
And how long have you been administrator of the division?
12 years.
I'd like to turn to the MMRC program. I'll represent to you that there was testimony from a witness just a few minutes ago about the MMRC program and its sunset. You're familiar with Idaho's MMRC program as it was run by your division, correct?
Relevance.
All right. Overruled. Same. Can have a continuing objection to the extent this witness's testimony involves the MMRC. Continuing relevance objection is granted. Go ahead.
There was a bill that the Department of Health sponsored to remove the MMRC sunset provision. Is that correct?
Correct.
Were you involved in those efforts?
Yes.
That bill failed, correct?
Excuse me, correct.
When the MMRC program sunset, did it cause you concern?
Yes.
What was that concern?
My concern was based on wanting to keep the program continuing so we can continue to research maternal deaths in Idaho.
And what did you fear if the program was unable to continue?
Objection. Her opinion is irrelevant. She's not been called to testify as an expert.
Sustained.
If you would turn to, it's going to be tab 4 in your binder. You have a binder in front of you. This is Exhibit 245. You recognize Exhibit 245, correct?
Yes.
This is an email exchange between you and Jennifer Liposhak, correct?
Correct.
In the email at bottom, you're sending Ms. Liposhak and others an email, correct?
Correct.
And you say you've attached a series of questions that Director Cameron is asking about the potential MMRC legislation the governor's office put forth as a placeholder. And you ask the recipients of the email to, quote, review my answers. Did I read that correctly?
Yes.
Who is Director Cameron?
Director Cameron was the interim director of health and welfare at the time.
Now, if you turn the page, there's an attachment to the email. The parties have stipulated to authenticity, so I can represent that it is the attachment. You prepared the answers in this attachment, correct?
Correct, with help of staff.
At this time, plaintiffs offer Exhibit 245.
Non-relevance objections?
Hearsay, I understand the court's likely ruling.
All right, the same.
Yes, statement of a party
opponent
opponent.
issue. All right, overruled. The documents admitted, Exhibit 245.
Exhibit 245 and the responses relate to the effort to remove the sunset clause from the MMRC legislation, correct?
Say it one more time, I'm sorry.
This exhibit and these questions and answers refer to the department's effort to have the sunset clause from the MMRC legislation removed, correct?
Correct.
If you could turn to page 3, and this is question 9. It says, who are the detractors, the question, or what are the landmines? Did I read that correctly?
Yes, it says who are the detractors or what are the landmines?
The first line of the answer reads, specific legislators who do not want this to be in DHW, correct?
Correct.
What is your understanding of why legislators do not want the MMRC to be in DHW?
Objection calls for speculation.
Your Honor, she wrote this. I don't think it can be speculation.
He's asking her opinion on what other legislatures were thinking. That's absolutely speculation.
I'm asking.
Lack of personal knowledge.
I'm going to sustain the objection as well. If it's stated in the document, I can read it in any event.
The next paragraph says, ongoing narrative by a certain organization and specific legislators that this data and information will be used to counter abortion ban. This is not true, correct? Did I read that correctly?
Yes, you read that correctly.
And what is your understanding of why the certain organization and legislators believed that the MMRC data would be used to counter the abortion ban?
My apologies, I'm trying to remember back from this particular point in time. I believe that is based on a concern at the time we had that the looking at the data would point to abortion complications as something that would come out of the report. I believe is the genesis of that.
And when the MMRC program, the sunset for that program was not removed, what did you believe was the reason?
My understanding of the reason was more about not wanting the program to be within the Department of Health and Welfare.
You were deposed in this case, correct?
Correct.
You were deposed as a representative of the state of Idaho, correct? You received a notice of the topics that would be discussed at your deposition. You prepared to testify on those topics, correct?
Yes.
You spent approximately 5 to 6 hours preparing, correct?
Correct.
And you reviewed documents, is that right?
Yes.
You spoke with attorneys for the state to prepare, is that right?
Yes.
You spoke with the executive office of the Attorney General to prepare, correct? And you're familiar with the 2 abortion statutes at issue in this case, correct?
Yes.
I want to turn now I want to ask you about guidance that has been provided to county prosecutors regarding enforcement of the amended total abortion ban.
Relevance.
Your Honor, this goes exactly to both claims 1 and 3 related to interpretation of the statutes and to the state's statements or lack thereof, referring to guidance on those, on the laws.
Restate the question, please.
Well, that was just a intro, but the question is, other than the Planned Parenthood Great Northwest case issued by the Idaho Supreme Court in 2023, you're not aware of any guidance issued by any state of Idaho official to county prosecutors about how to exercise their discretion to enforce the amended total abortion ban.
Objection, relevance, whether guidance has or has not been issued is not relevant to whether the statutes are constitutional as applied.
Your Honor, this goes directly to the confusion that is at the heart of this case.
Overruled. You can answer.
I'm not aware of any guidance.
And let me make clear that when I say any state of Idaho official, that I'm including the Attorney General and the Office of the Attorney General. That does not change your answer to my previous question, correct? No written guidance that you're aware of, correct? Your answers are the same with regard to guidance from state officials on the amended 6-week ban, correct?
Correct.
Fair to say that the only state guidance that county prosecutors exercising their discretion to enforce the amended total abortion ban can reference is the laws themselves and the Planned Parenthood decision of the Idaho Supreme Court. Is that right?
My understanding, yes.
You are aware of statements from the Attorney General intended for the general public on the topic of abortion bans, correct?
Objection, relevance.
Your Honor, this is getting into this, but this is related to the state's interpretation of the abortion ban.
Ask the question again, please.
You're aware of statements from the Attorney General intended for the general public on the topic of the abortion bans, correct? If you could turn to tab 3 in your binder. Oh, sorry. This should be tab 2 of your binder. My binder is maybe off. Sorry, tab 1 of your binder. Should be Exhibit 587. Is that correct? You recognize Exhibit 587? It's an op-ed from the Attorney General published in the Idaho Statesman, correct?
Correct.
And you reviewed it in preparation for your deposition, correct?
Correct.
Turning to page 3, bottom paragraph. Or at this time, plaintiffs offer Exhibit 587.
Objection, relevance, hearsay.
Well, I don't think that any hearsay objection would be valid, but what's the relevance of the document?
This goes, there are statements in this about the interpretation of the bans that go directly to, interpretation of the medical exceptions that go to Claim 1 and to an understanding of Claim 1.
I'm going to sustain the objection. At this point, I think we have more than enough evidence on the topic of whether medical providers are confused by or don't understand the bans and whether and on that topic generally. So it just doesn't seem to me that whether the Attorney General has made public statements interpreting the bans is germane to the issues in the case. We can move on.
As representative of the state, you're aware of only one meeting that the Attorney General held with physicians in relation to the abortion bans, correct?
Objection, relevance.
Saint.
I want to turn to another document discussed during your deposition as state's representative. This would be tab 2 in your binder. Exhibit 518, you recognize this letter?
Excuse me, yes.
It's a letter reviewed in preparation for your deposition. Correct? It's a letter from Deputy Attorney General Phil Broadbent to Dr. Darren Petard, is that right?
Yes.
The seal of the State of Idaho appears at the top of the letter, correct?
Yes.
And it's dated February 9th, correct?
Correct.
At this time, plaintiffs offer Exhibit 518.
Any objection?
Relevance.
What is the relevance?
Your Honor, this is a letter that was written in response to a doctor who was asking for guidance from the Attorney General's office. And so it goes to the Attorney General's opinion on how to interpret the medical exception to the abortion bans.
All right, sustained.
I'd like to turn to one other topic discussed during your deposition. The Department of Health and Welfare collects data on abortion in the state, correct?
Correct.
The division compiles statistics on abortion in the state, but you're not aware of any official State of Idaho government source that would track the number of Idaho residents who have traveled to another state to have an abortion, correct?
Correct. Sorry, yes.
So, if I'm understanding correctly, if an Idaho patient is denied an abortion in Idaho and they travel out of state to receive an abortion in Oregon, for example, you're not aware of any State of Idaho office that would record that abortion, correct?
Correct. We would only know if those states chose to provide that information to us. There's no requirement that they do so.
And your answer would be the same if the abortion was necessary to save the patient's life, correct?
To clarify for people going out of state?
Yes.
Yeah, correct. Same answer.
And same answer if they went out of state to preserve their health. Your Honor, just one thing before I wrap up here. I'd like to just request that Exhibit 518 be lodged for purpose of the record.
Perfectly fine. It's been offered and refused, so it will be retained as part of the record.
Okay, thank you.
Thank you, Mr. Cabot. Examination, Mr. Craig.
Yes, Your Honor. Regarding those abortion statistics, you're in charge of the Division, Department of Health and Welfare, that publishes the reports on numbers of abortions done in Idaho each year, correct?
Correct.
And do you know approximately how many abortions were done in Idaho in 2021?
2021, roughly 1,500,
Do you know approximately how many were done in 2022?
approximately 1,000.
Do you know approximately how many were done in 2023?
5.
How long have you worked at the Department of Health and Welfare?
28 years.
And in your role with the Department of Health and Welfare, are you aware of the general physician shortage in Idaho?
Yes.
How long has that physician shortage existed?
Objection, relevance, Your Honor, relating to the ruling, ongoing ruling.
Sounds like the same issue to me, Mr. Craig.
They've been presenting evidence, including through Dr. Lyons most recently, over and over and over again. I believe some of it has been admitted. So this is my last question.
All right. Well, I'm going to permit you to answer it, but I'm going to just indicate again that this is not an issue in the case as far as I am concerned. You can answer.
How long has that physician shortage lasted in Idaho, to your knowledge?
Many years, I don't know. As long as I can remember.
Thank you. No other questions.
All right. Thank you, Mr. Craig. Any redirect?
No, Your Honor. No, Your Honor, not this time.
Thank you for being here, Ms. Shawtolik. You may step down. All right. Have we arrived at the plaintiffs resting their case?
Your Honor, we anticipate resting in the morning, but we'd like the evening to take stock of our case and possibly clean up anything we need to clean up before doing so.
Understood. Anything else before we reconvene tomorrow morning, 9 o'clock?
We're not going to push our luck, no, sir.
Understood. We'll see you in the morning.
All rise.